So thank you so much for joining us today for the 12th Annual John A. Speziale Dispute Resolution Symposium, Is Virtual Justice Just? So I'm playing the role of Tim Demon this morning, the Connecticut Bar Foundation's president. My name is Natalie Wagner. I am the executive director of the Connecticut Bar Foundation, and Tim sends his condolences that he couldn't be with us this morning. So just to get started, I want to remind everybody why this symposium series exists. Chief Justice John A. Speziale was actually the very first president of the James W. Cooper Fellows Program in the mid-90s. And shortly after that, in 97, this symposium series was started in his honor. As Chief Court Administrator, he really ushered in an age of alternative dispute resolution in Connecticut and really made Connecticut a model for how to expedite cases by utilizing alternative methods of resolving disputes outside of the courtroom. I'd be remiss if I didn't thank the two chairs of the committee this year, Charlie Pillsbury of Quinnipiac University School of Law, and Ernie Titel co-chaired the planning committee this year. And I do want to tell you we have a great list of individuals who were assisting them this year. So I want to acknowledge them as well. Neil Ferguson, Honorable Joette Katz, Chris Greason, Honorable Cesar Noble, Cindy Robinson, and Rob Simpson all came together this year to make this event possible. I also want to thank our gold sponsors, Dave Pitney, McCarter and English, Riscassi and Davis, Shook Hardy and Bacon, and Silver, Golub, and Titel for sponsoring today. I also want to thank Dean Jennifer Brown of Quinnipiac University School of Law and the entire law school for partnering with us in this series since its inception. Thank you all for also being here in person. We are recording it so other folks can enjoy the program as the new way that we participate in programs these days has really changed. As a result of that, we also have panelists who will be here in person today and others who will be joining us virtually so that we can expand our reach of those who can join us in this conversation today. Please don't forget to fill out the questionnaire. It's at the back of the program that you have today at the end of the program. It helps us improve this program series each time. And before I turn this over today, I just want to let you all know about two other upcoming events that we have. One is also co-sponsored with Quinnipiac University School of Law. It's regard to the Connecticut Afghan Asylum Project that was co-created by Sheila Hare of Quinnipiac University School of Law. And that will be taking place on November 10th from 5:30 to 7:30 here at the law school. You can also participate. It's a hybrid event. You can also participate by Zoom. And that's really to be trained in representing Afghan individuals, refugees who are seeking asylum here in Connecticut. We have over 900 asylum refugees who have emigrated to Connecticut and whose asylum cases are going to start being heard in May of 2023, and there's a real crisis and lack of individuals to represent them. And they are cases that have a great percentage, a high percentage of success when brought before the administrative tribunal. So I encourage everyone to sign up for that. Again, it's Thursday, November 10th. And then also we have a roundtable on the business of law coming up at University of Connecticut School of Law on November 14th from 6 to 8 p.m. You can find out more about both of those programs at the Connecticut Bar Foundation website. So I don't want to hold us up anymore today. I'm going to introduce Dean Jennifer Brown to introduce you to the programming today. Thanks so much.
Thank you very much, Natalie. And I want to begin again with a thanks to the Connecticut Bar Foundation that has been such an amazing partner to us for so many years. I'm especially excited to work with the CBF on the Speziale Symposium over the years because in 1997, this law school created our Center on Dispute Resolution. And let me say the name again, Center on Dispute Resolution. Not necessarily Center for Dispute Resolution, because we wanted to try to establish some kind of objectivity, an ability to be critical as well as supportive of this new way of practicing law, helping clients, and promoting justice in our society and our courts. So we called it the Center on Dispute Resolution, so we could have these conversations. And I think over the years, we've tried to carry that through our workshop co-sponsored with Yale Law School that Charlie Pillsbury has so ably organized, in addition to this particular symposium, a speaker series that brings in people from all over the country, from multiple modalities, whether it's mediation or arbitration or hybrid models, to talk about dispute resolution and to have that objectivity and a kind of high-level perspective. And then through the education that we give our students. So before I turn to the program, I really just want to put in a kind of a plug for our law school, because you know it's decanal malpractice if you're speaking to a group of people like this one and you don't take the opportunity to ask people for their help. You're helping us by being here today and by partnering with us and learning alongside us. And if you are supportive of Quinnipiac's mission, and I call it a mission, to educate the whole lawyer, to understand and serve the whole client, which this work is a part of. If you're supportive of that, please join us. We love to work with the bar. We love to work with mediators. We love to work with social workers and educators and business people. And we do that through our Bridge to Practice program. We do that by having adjunct professors, by having people who mentor our students. So please, you could teach here, you could mentor our students, you could hire our graduates. Let me repeat that. You could hire our graduates, because if you value the values we're going to be talking about today, I want to assure you that during their 3 years at Quinnipiac, our students are exposed to those values and they have an opportunity to grow in those ways. That's not always reflected in a GPA. It may not be reflected in law review membership or a moot court championship, but it is reflected in their values and what they'll bring to the practice of law. So consider hiring our graduates. And then finally, programs like this require money. And I want to stop for a moment to thank the sponsors of this program. It's extraordinary this year, the number of organizations that have come forward to support this symposium. It's really heartwarming. I think it's a testament to the power of the importance of the topics we're going to be discussing, that the bar has come forward as you have to support this program. And please consider also supporting the law school, because the Center on Dispute Resolution does very good work, and we love to have your help. And with that, I think I will turn it over to our first panel, which will get us started on this question of whether virtual justice is just. Thanks.
Thank you, Dean Brown. I'm Neil Feigenson of the Law School faculty. We're privileged to kick off the symposium this morning with Maria Hartwig, who is a professor of psychology at John Jay College of Criminal Justice at the City University of New York, where she has been on the faculty since 2006. Professor Hartwig's scientific expertise is in the psychology of interrogation and the related topic of the psychology of deception. She has worked with and been funded by, among others, law enforcement, the Department of Defense, and the High Value Detainee Interrogation Group, HIG. Her work on strategic interrogation techniques has been widely disseminated and is incorporated in the training programs of the HIG, within federal law enforcement training programs, and in practice on state and local levels. Professor Hartwig has authored dozens and dozens of peer-reviewed works, including one as far back as 2005 on a topic that's relevant to today's symposium, Witnesses Appearing Live versus on Video, Effects on Observers' Perception, Veracity Assessments, and Memory. She will be speaking to us this morning about these and other aspects of virtual courts, and I'm very much looking forward to the presentation. Please join me in welcoming Maria Hartwig.
Good morning. Thank you very much for having me. I'm very excited to be here. I think I'm probably the only non-lawyer in the room. Don't judge me too harshly. I will spend somewhere between 45 minutes and an hour talking to you about the psychology of credibility judgments, with a particular focus on the effects of modality, that is, the effect of live presentation of witnesses versus in-person judgments. So I want to give you a background of what we know from the literature on credibility judgments and deception judgments overall. A, I think it's of relevance to you as professionals, and B, it serves to set the stage for the subsequent literature review that I will give you on what we know about modality effects. So let's start here. The young man you see to the left is Jeffrey Descovich, age 17. He was arrested for the rape and murder of his classmate. To the right is him, I believe, 17 years later. And to the right of him is Barry Scheck, one of the founders of the Innocence Project. Jeffrey Descovich was convicted of a crime that he did not commit based on a false confession extracted by the police. He became a suspect, this is critical, because he seemed overly emotional about the death of his classmate. He cried profusely, he went to her wake 3 times, he even approached the police to ask them if he could help out with their investigation. So they thought he was overly emotional. Turns out that he was quite bullied, and she was one of the students in his school who was nice to him. So despite the fact that there was semen from the crime scene that excluded Descovich, he was convicted on the basis of his confession. So this miscarriage of justice started by judgments by law enforcement that he was guilty based on him being overly emotional. This is Marty Tancliffe. Marty Tancliffe was also 17 years old when he became a suspect in the murder of his parents. He spent also about 17 years in prison. He was convicted on the basis of his confession that was taken under very dubious and coercive circumstances. Tancliffe has since gone on to become a lawyer and an advocate for criminal justice reform. The reason Marty became a suspect was because he did not seem emotional enough when he was interviewed by the police at the crime scene. They thought he was too calm and seemed suspicious. So in both these cases, the starting point for what ended up being a tragic miscarriage of justice, the starting point was a judgment made by a person that they were being deceptive. And in one case, too much emotion. In the other case, not enough emotion. So you're probably familiar with the miscarriages of justice and wrongful conviction data. This is an analysis of the first 325 cases and the underlying causes. As you can see, somewhere between 25 and 30% of wrongful convictions involve a false confession. There are now thousands and thousands of these cases, but the pattern hasn't changed in the sense that there are still about 25 to 30% of these cases that involve false confessions. So it's important to understand that in every single one of those cases, a person who's innocent has been mistaken for guilty. So the stakes of these decisions are really, really high. When it comes to the psychology of deception, deception entered fundamental Western thought in a telling guise when the author of Genesis placed the serpent in the Garden of Eden. And through this deception, he enticed Eve to commit the original sin. So our ideas about deception as being fundamentally immoral is very profound. And it affects, as I will show you, our expectations for how liars will behave, which may or may not be correct. In Shakespeare's play Othello, Othello accuses his lover Desdemona of cheating on him. Now, she's innocent, but the person that she's accused of having cheated with is dead. So she despairs at the prospect of trying to convince Othello that she's innocent. And he interprets her emotional reaction at the accusation and at the prospect of being unable to convince as a sign of deception. So this is a form of confirmation bias, and this is the kind of mistake that people do make, and it's called the Othello error. So from Shakespeare to In Touch magazine, I want to say a few things about the demeanor assumption. This is Jennifer Aniston on Oprah Winfrey's show talking about her divorce from Brad Pitt. Is she really over Brad? She says she is, but her body language tells a different story. Now, I'm convinced that there's some factory out there, I don't know, in Kentucky perhaps, that produces these self-proclaimed body language experts who are willing to put themselves on CNN and all kinds of other news outlets to make comments about body language, the body language of politicians, of crime suspects, public figures, etc. So what's going on here? I don't know if you can read what it says there. You probably can. But so she's talking about that Jen is insisting that her divorce was a long time ago, but there's still a lot of hurt on this topic. It shows. And in the second picture, looks like her eyes are watering and she has tension in her jaw, and it looks like she's about to cry, and she has tension in her neck too. And then in the third picture, she's holding on to her face, which means that she's trying to comfort herself. And at the bottom comes the punchline. There's a lot of anger. The body and face don't lie. This is the demeanor assumption that you can decipher deception by essentially ignoring what a person is saying because there's leakage of cues to deception in the demeanor of the person. So the literature on deception and judgment of deception is largely experimental. People are randomly assigned, typically, to either lie or tell the truth. We call these senders or targets within the experimental paradigms. Sometimes people give true and false statements about their attitudes, opinions, or feelings about something. In the forensic literature, we often rely on mock crime paradigms where people are innocent or guilty of some kind of fake crime. We can't induce participants to commit real crime for obvious ethical reasons. And these statements are videotaped and then showed to other people who we typically call lie catchers or observers, and it's their task to make a judgment about whether what they've seen is true or not. There are numerous variations on this paradigm, and there are also a number of non-laboratory studies on the topic, but the laboratory is really the best controlled environment to study these judgments, so that's why it's the preferred method. We have conducted research on deception and deception judgment for well over half a century. There are hundreds and hundreds of studies on the topic. And it's logical that the hit rate that you would obtain by flipping a coin about it is 50%. So how good are people, if you look at the literature in its totality, how good are people at distinguishing between true and false statements? I don't know if anybody wants to take a guess. Is it 50%? Is it 75%? Is it lower than 50? 35%. Okay, lower than chance would be interesting because let's say somebody would have 0% accuracy. They would actually be 100% wrong, right? They would be wrong all the time. So you could rely on them because whatever they say, you just turn that judgment around and then you got it. So it's not below 50, but it's just barely above the level of chance, about 54%. So if you look at this based on meta-analysis, which are statistical synthesis of the literature, this is statistically significant, but for practical purposes, it's very, very, very close to chance. There is a tendency in people's judgments to be truth biased, meaning that they're more inclined to make truth judgments than lie judgments. So people have a tendency to be credulous. This doesn't hold true for all people, as I will tell you in a little bit. But that leads to a higher identification accuracy rate for actually true statement. Let's say you have an extreme truth bias and you say true, true, true 100% of the time, you will catch all true statements, right? You will have 100% accuracy rate for true statements, but 0% accuracy for lies. As in many other domains, people show poor metacognitive calibration, meaning that they don't know when they're right or they're wrong. So their confidence levels are disconnected from whether they're right or they're wrong. Means that you shouldn't care whether somebody says that they're absolutely certain versus unsure. They're equally likely to be correct or incorrect. That lie detection rates hover just above the level of chance is one of the most robust findings in all of social psychology. You'll find extremely few studies that deviate from this figure. Of course, some studies show you 53%, some show 49%, some show 57%, but the cluster of studies conducted on this topic, again, hundreds of studies, show an extreme clustering around this mean of 54%. One might think that lie detection is a skill. It's intuitive to think that some people would be better at this than others. There's no evidence for that either. In analysis of individual differences, including well over 200 studies and some 25,000 judges, there was no evidence that people differed from each other in lie detection accuracy more than you would expect by chance alone. And critically, these findings replicate across the lab into field settings. So it doesn't really matter for this 54% accuracy rate whether the lies and truths are told in laboratory circumstances by students or whether they're told by suspects in a police interrogation. So is there anything that affects this accuracy rate? So here are some possible moderators to this accuracy rate. The top bar is whether people are motivated or not. I want you to note that the axis is truncated on the bottom, so you got 50% on the left and 55% on the right. So these differences are really small. There's really no difference whether the person telling the lie is motivated to be believed or not. Experts are the gray bar. They don't perform any better than lay people. It doesn't really matter if the person is allowed to interact with the target or if they're only seeing the person on a videotape. Where there's some action going on is in the fourth bar, where the gray bar represents modalities where you can hear the person. And the yellow ones are when you can only see the person. So the interpretation of that finding, that detection accuracy is slightly higher when you have access to the spoken word, tells you that the body and the face don't lie is nonsense. when you can only see a person, you're performing at pretty much chance level. So to the extent that there are indicators of deception, they're in the speech. Police officers and other legal experts, including lawyers, do not outperform lay people. Police officers display a lie bias, meaning that they're more suspicious, and they also display higher degrees of overconfidence. So this is a bad trio of elements for an innocent person who's facing a police officer. You're meeting a person who barely has any capacity to tell the difference between truth and lies, are inclined to think that you're lying, and is very sure about that. Good luck. For any diagnostic task, including, let's say, medical diagnosing, if judgments are inaccurate, it could be because of one of two things, or a combination of both. It could be, in the case of lie detection, that people have the wrong ideas about what characterizes deceptive behavior, and that they therefore rely on the wrong cues when they're trying to detect deception. It could also be that liars and truth tellers don't differ very much in their behavior. So let's translate this to a medical diagnosis type situation. If you find that doctors perform at just above chance level at diagnosing a disease, either it's because they're looking at the wrong symptoms, or it's that the disease is largely asymptomatic. So let's look at the evidence in favor of these different explanations. In 2006, we published a study containing data from 86 countries. It's really annoying that we didn't get Denmark, because then we would have Greenland and all the top bit would be red. The red countries were included in the study and the yellow ones were not. But you can see that we covered a good part of the globe. And we simply asked people, how can you tell if someone's lying? And we expected that there would be quite a bit of cross-cultural variation, because it's well known that nonverbal behavior and so-called display rules, culturally determined rules for how to act in given situations, are culturally dependent. But we were very surprised to find a pan-cultural agreement on how liars behave across cultures all over the world. By far, the most common belief expressed by participants in this study was something to do with the eyes. They can't look you in the eye, they look away. So this notion that the eyes is a mirror of the soul seems to be happening here. In the vast majority of the countries we surveyed, the belief that eye contact is an indicator of deception was by far the most frequent. The other ideas people have is that liars are nervous, incoherent, that they move their body a lot, and that their statements are inconsistent. So what does this tell us about behavioral expectations about how liars feel? These are all indicators of nervousness and anxiety and guilt, perhaps. So it seems that people do expect liars to be feeling bad and anxious. And this finding is robust, holds true even for presumed lie experts like criminal investigators, who express in surveys that gaze aversion indicates deception, body movements, self-manipulation, so picking at your clothes or fiddling with your hair, posture shifts, and speech disturbances like stutterings or long pauses. Here's an extract from a number of police interrogation manuals that tell you what police officers should look for. As you can see, there's a great degree of overlap between what they recommend that people use, problem with eye contact, rubbing the eyes, many body movements. Essentially, they're telling people what they are already relying upon. So not only is this advice dubious, it's superfluous as well, it seems. So, how do liars actually behave? In order to answer that question, you have to compare the behavior of people lying to people telling the truth. And again, you can do that in a laboratory setting, or you can do that in a field setting where people are telling truths or lies. The problem with field settings is that you have to establish what we call ground truth. You have to have absolute certainty that a given statement is actually true or false. So that's very difficult to do, to obtain a satisfactory degree of scientific certainty that a statement given by a particular person is true or false. But there are studies that have painstakingly gone through statements told in high-stakes settings and established ground truth and for true and false statements. Another thing to note is that you have to, in field studies, have lies and truths where the stakes are equal. So you can't compare a statement where somebody is talking about their family to a statement where they're talking about a crime, because that amounts to comparing apples to oranges. So you have to have comparable stakes for the truths and lies. But again, there are those studies around, and here's what we find. There is no Pinocchio's nose. In the biggest synthesis of the literature, composed in 2003 by DePaulo and colleagues, they investigated the connection between 158 different behaviors, and those behaviors' connections to deception. And the overarching conclusion was the now axiomatic expression that cues to deception are faint at best. There's absolutely no difference in eye contact. If you combine all the different ways in which you can measure eye contact, for example, how long the person is looking at you, how many times they're looking away, etc., the effect size for the relationship between those behaviors and deception is 0.00. There is no difference in fidgety and nervous body movements. If there's any difference with respect to that, it's the other way around, that liars may move a little bit less than truth tellers, either because of attempts to control themselves or because of cognitive load involved in producing a deceptive statement. But out of all these 158 behavior, not a single behavior or set of behaviors emerged as reliable indicators of deception. So going back to the earlier slide on why lie judgments fail, we have evidence supporting both explanations, that one, people have incorrect ideas about how liars behave, and B, two, they are facing an extremely different judgment task. And in fact, if you use a statistical framework to pit these two explanations against each other, which we've done, the strongest explanation is that the signal to deception is so very weak. And I'll come back to that when it comes to modality effects. Right, so it's COVID time. During COVID, we have experienced the age of Zoom. So many Zoom meetings, so many interactions that normally would have taken place in person are now happening via video. And there are numerous questions about elements of virtual justice, which this day will reflect different aspects of. So I'm only touching on one aspect, which is social judgments given by observers on video compared to live. Empirical research on the topic of virtual justice is really lagging. I think you will see in the next couple of years a wave of research coming out, but because of the scientific process being relatively slow, to this date we don't have many studies on the effects of somebody testifying in person or via video. There are some studies which I will tell you about. There are other questions about virtual justice that are empirical in nature. For example, what is the effect of mask wearing on perceptions of people testifying? If you're interested in that, a colleague and I have written a paper about that. If you don't have the energy or interest to read it, I can give you a spoiler, doesn't matter. The reason it doesn't matter is that there are no reliable indicators of deception in the face to begin with. So obscuring parts of a person's face doesn't obstruct fact finders in any reasonable or compelling manner. When it comes to the available legal scholarship, there's quite a bit, but much of that focuses on the constitutionality, as far as I understand it, of not presenting a person in person. My belief is that it has to do with possible violations of the confrontation clause, right? Please nod, somebody. Thank you. So let me give you an overview of the empirical work that we do have on live versus video or CCTV testimony. Much of this research is on children's testimony. There are a couple of studies on adult witnesses. I don't think there's any good reason to think that the results on children don't translate to adults, but there you have it. The original impetus behind studying modality effects and comparing witnesses being presented live or in person had nothing to do with COVID. It emerged out of reform efforts, primarily in the UK, but also in the United States, to protect vulnerable populations within the legal system. And the concern was particularly for children, and again, more particularly for children who had to testify in child sexual abuse cases, where oftentimes the only tangible evidence is not so tangible. It entails the testimony given by the victim and the defendant. So to prevent children from having to face the person that they accused of crimes in the courtroom, CCTV evidence was introduced as an alternative. So the notion underlying the use of CCTV or video camera testimony was to protect the witnesses emotionally, prevent them from being traumatized further, and to prevent any obstacles from them to being able to testify properly. So again, most research is on mock jurors' perceptions of child witnesses and their testimony. So how are people perceived who are presented in these two different modalities? There are other questions that are raised in relation to modality effects. For example, what is the actual differences in quality between a statement that is given live versus in person? So the typical methodology in these studies, again, is experimental. We don't use the laboratory because we don't have anywhere else to go. We use the laboratory because it's a controlled environment where we can manipulate systematically the variables that we're interested in. And sometimes people say, well, in real life it's much more complicated. Exactly, that's why we use the lab, because we're able to simplify matters so that we can isolate particular variables and study them specifically. So the main manipulation in those studies are obviously whether a person testifies live or in person. And the primary measurements are jurors' perceptions of that person and their testimony. In some studies, Researchers manipulate the veracity of the statement so that some witnesses give true testimony and others give false testimony. And in studies like that, you can calculate judgment accuracy in order to see if people are better at distinguishing between true and false statements based on whether the statement is presented live or in person. So, briefly about the quality of the testimony. There isn't that much research on the actual quality of the testimony given live or via video, but the available research suggests that at least for children, they appear to be more relaxed when they testify via video link. And importantly, they offer more details and their statements are more complete. So for witnesses and their testimony, it seems like it's advantageous for them to present their statements via video. Again, and not clear if this translates to adults. I don't see any psychological reason why it wouldn't, but keep that caveat in mind. So, what about jurors' perceptions of the testimony? This has been the chief focus of this research. The main finding when you measure how jurors perceive various aspects of the person testifying and their testimony is that they view video testimony with more skepticism than live testimony. So witnesses appearing via video are disadvantaged in a number of ways. Jurors rate people appearing on video as less believable, less honest, less accurate, less attractive, less intelligent, less confident, less convincing, and they're less sympathized with. Also, very importantly for jury and jury deliberations, live testimony seems to be encoded better. So it's better remembered by jurors. So why is this the case? So we have to resort to basic theoretical work to figure out why we see these effects. The most compelling explanation is something called a vividness effect, which doesn't pertain only to this particular area, but to the perception of stimuli in general. Stimuli that are more vivid are processed differently than less vivid stimuli. And vivid here is defined as emotionally interesting, concrete, and imagery-provoking and proximate in sensory, temporal, or spatial ways. Vivid stimuli are more paid attention to than non-vivid stimuli, and vivid stimuli are also perceived as more credible. Why this is the case, I don't know, and I don't think anybody else knows either. But what we do know is that across the studies that compare these two modalities, people who testify via video are perceived more negatively, and their testimony is met with more skepticism. So the vividness effect can explain the results from the mock trial literature to some extent. We can understand it via the fact that in-person statements are more vivid, more direct, more proximate, but exactly why that affects how people view witnesses in terms of their credibility and the quality of their statement is not entirely sure. We're not entirely sure about that. So, as I mentioned, some studies manipulate veracity, the truthfulness of the testimony, and in those studies, you see effects on the judgments of perceivers in a manner consistent with the notion that people testifying in person are viewed more favorably. People are more skeptical and more lie biased when it comes to statements presented via video. So they make more lie judgments when they see a video testimony compared to a live testimony. And again, the proximity and the vividness of the testimony might be the underlying explanation for this. Now, when you look at differences in accuracy, at distinguishing between true and false statements, the differences between these two modalities are trivial if they exist at all. They are most likely non-existent, meaning that it doesn't help the fact finder to see a person in one modality versus the other. And the reason for this is something that we call floor effects. The differences in accuracy are already so low that they really can't go any lower. Again, the signals of deception are so very weak that it doesn't matter whether a person is testifying in person or on video. The signals to deception are so weak that the judgment task is very difficult. So no reason to think that you're more in a better position to judge the accuracy of the person's testimony depending on modality. So the main takeaway is that modality actually matters for the perception of witnesses and their testimony. These effects are not extremely strong when you talk about in terms of effect sizes, but they are definitely there. Modality matters. And the chief finding is that people who testify via video are disadvantaged. That video testimony is perceived more negatively across a number of dimensions compared to statements that are presented live. But again, no reason to think that it's easier to detect true or false statements between these two modalities. And that's all I have. Thank you very much for having me. And I think we have time for questions, don't we? Yes, sir. Oh. Yep.
Were you able to parse out the effect of inconsistent statements?
Well, I think if I understand your question correctly, the question is, are inconsistent statements more common in deceptive presentations, right? Yes. First, here we just lump together, when we asked people about their perceptions of deceptive statements, we coded all statements or answers given when they said stuff about contradictions or inconsistencies in the same way. So we had one big category for that. But in reality, there are many different kinds of consistency or inconsistency. There is within-person inconsistency, where I'm saying one thing in the beginning of my talk, and then at the end of my talk, I'm saying something else. That's a within-person inconsistency. There's between-statement inconsistency, where I'm saying something on Monday, and on Tuesday, I'm saying something different. There's between-person consistency, where you're saying something, and I'm saying something different. And there's also statement evidence inconsistency, because consistency between what I say and what the known facts show. So when it comes to, I think what people most often think about when they say consistency of statements, they mean contradictions within the statement, right? Whether the person changes their statement. It is not a reliable indicator of deception, and here's a probable why. There's something called the repeat versus reconstruct hypothesis. It's saying that when somebody is trying to recall a statement from memory, memory is a reconstructive process. So the statement that you give on one occasion might be different than the memory that you're able to derive on another occasion of recall. And so that's the reconstruct element that's present for truth tellers who have to retrieve memory. The repeat element pertains to deceptive people who are well aware of the stereotype because they hold it themselves. So a principal strategy for liars when they are interviewed consecutively is to avoid contradictions. So liars do that by trying to keep their stories simple and repeat the same story across the times they're being interviewed in order to avoid inconsistencies. So inconsistency between statements is not a good indicator of whether the person is telling the truth or not because of the natural variations in memory that occur. I hope that answered your question. Okay. I don't know who's first. Go ahead. Yep.
Thank you. There's another kind of inconsistency I've heard about in lie detection, which has this theory of micro-expressions,
Oy.
where somebody says one thing,
Yep.
but there's like a flash of
Yep.
a micro-expression that's inconsistent with what they're saying, and I wonder if you could speak to that. And then I had a second really quick thing, which is whether the skepticism toward video testimony has ever been shown in a study that presents testimony on both sides, plaintiff and defendant, prosecution and defense, and whether, so if jurors are equally skeptical of both
Yes.
sides, you know, it's not great, but at least
Yes.
it's even. I mean, do we see any
Yes,
differences?
it's exactly that pattern that jurors are equally skeptical of video statement, regardless of whether it comes from the defense or the prosecution. So in some way you could say, well, what does it matter then if the playing field is even? Well, it still matters, but it's less of a problem that it holds true regardless of where the testimony comes from. Your first question is interesting. There is micro evidence for micro expressions even existing in the first place. So these are supposedly full-fledged emotional expressions occurring very rapidly, about 1/25 of a second, supposedly again. The proponent of this idea is a researcher named Paul Ekman, who's a very famous emotion researcher, and he has claimed that these emotion microexpressions exist, and moreover that they're connected to lying, so that if you pay really close attention to the face in particular, and you know what a microexpression looks like because you paid a lot of money to take his training, then you become a better judge. This is not true. You're wasting your money on that training. We've tested that training empirically. It doesn't work. In analysis of whether microexpressions exist in the first place, the jury is completely out. There's no strong evidence that these expressions happen. In studies focusing on whether these expressions occur in truthful and deceptive statements, what has been found is some half or partial expressions of emotion that occur briefly that are inconsistent with the emotion that's being expressed, but again only occurring in the, partially in the face and occurring equally often for people who are lying and people who are telling the truth. So the explanation for this is that there's no underlying emotion that's associated with lying or telling the truth. If there was an emotional state that was attached to lying, and people believe that there is, people believe that anxiety is associated with deception, but it's not. People don't report feeling very guilty when they lie. In diary studies where you ask people about their everyday life interactions and how much they lie, people admit to lying multiple times a day, They lie in about 1 out of 3 social interactions that they have. And they report not feeling very guilty about it. And they report that if they could go back in time and relive that particular interaction, that they would probably tell that lie again. So even if microexpressions existed, which is highly dubious, there's no reason to think that they would reveal anything about the deceptiveness. They may then be revealing something about what the person is feeling, but that's not informative for their about their deceptiveness. I'm really glad you brought this up because it's a really popular notion that has taken hold of people's attention and imagination. And I think you know the TV show Lie to Me is entirely based on Dr. Ekman's work. He just doesn't publish any research on this, so it's up to other scholars to try to debunk his stuff, which we have done really painstakingly, but yes. Yep.
So I just wonder how much information you have on the effects of masking on tourists, for example,
Yeah.
being able to, either on video, because there are people even on video that are masked.
Extremely little, barely anything at all. In the study that I mentioned, we didn't conduct any collection of original data where we manipulated the presence of masks or not. We drew on the available literature that includes presentations of faces that are partly obscured versus presented completely. So there's no direct research on it. What we know is that it's very unlikely to have an effect on accuracy in judgments, but we still don't know if it, similarly to live versus in-person testimony, whether it biases fact finders in terms of their perceptions of a person who's masked or not. That we cannot speak to. Yep. Yes, again, there's nothing on that. Again, I suspect that that a number of COVID-related research papers are going to come out because people are engaged in that research as we speak. But so far, I'm sorry, we don't know. Yeah.
You mentioned the confrontation clause. Is there research about the effect of having the accuser and the accused in the same space about the amount of truth-telling or lying?
No, not in terms of the truthfulness or deceptiveness that happens when somebody testifies. So the only effects that we observe is that witnesses, again, particularly child witnesses, seem to provide testimony that's of lesser quality, but there's no evidence that people are less likely to lie if they are confronted with the person that they're accusing. And there's no theoretical reason to think that they would. Yep.
And I don't know, would you happen to know, for instance, non-jury here? For instance, a custody or an access hearing. Would you think the same kind of perception about bringing somebody in for video testimony would be very, for instance, if the plaintiff or defendant, one of them was coming in virtually, do you think the same expectation or the same perceptions would be held by the trier of fact in a situation like that?
Yes. Yes, I think that these effects are not specific to these two modalities that I've been talking about in a mock trial type setting. I think that you will very likely see these effects in other contexts as well, that the person appearing on video is simply less compelling than a person who is physically present. Yes, sir.
For years, I was firm believer that a requirement to have a live video. For a variety of reasons now, it becomes more of a necessity to have video testimony experts in the lab. Do you think over time that perception among jurors is going to change the bias in favor of live testimony?
It's a very interesting question, and I have to resort to speculation. Maybe may be inferences drawn about the witness that are negative based on their appearance via video, if that's an unusual thing. But if it becomes a very common thing, those things might not be present. The perception of a negative perception of the person as some kind of anomaly for appearing on video, they would disappear. But I think there's an inherent psychological reason to think that in-person statements are going to be more compelling because of the vividness effect, that they are more direct and more proximate. So my answer is sort of half yes.
This is completely unscientific, but I've asked jurors after a trial who made a joke, and none of them said it did. They all said, we've all gotten so used to seeing things
Yeah.
on television, Zoom meetings, that type of thing, especially with us.
Yeah, these effects are not really of the kind that we would expect people to have awareness of them. So they probably operate on non-conscious levels where it's interesting to hear what they're thinking about the effects of the video presentation, but I don't think that we can expect people to accurately self-report on these effects.
Maybe they're lying to me, I couldn't tell.
Perhaps. All right. Yes, please.
Along those lines, it seemed to me that based on the witness response, based on the fact that evidence or research seems to show that full-on black person testimony has the effect of creating greater sympathy with the witness. Before either the court or the jury, et cetera, that might it not affect the actual, it doesn't affect their ability to detect lies, is what you're telling us.
Yep.
But might it affect what the ultimate verdict or award is?
Yeah, I think it can, because it impacts the weight that jurors place on testimony, how compelling they find the testimony to be. So it's a really good question. So when I say it doesn't affect judgments, I mean that it doesn't affect specific judgments about whether the person is saying something that's deceptive or not, but whether it ultimately impacts jurors' judgments, there's some reason to think that it does, because of the effects on the perception of the testimony as a whole. 5 minutes? All right. Oh, hello.
Hi, I just wanted to ask a sort of corollary question about whether you've looked also at whether other types of evidence presented on a video screen rather than in a tactile manner also have a similar difference effect. So for instance, if the jury is seeing photographs, let's say autopsy photographs, on a screen that might be similar to things that they see in television shows or something, as opposed to holding a physical photograph of something
Yeah.
that is a maybe more intimate experience, if there's a similar effect.
No direct research on that, as far as I know. Again, because the impetus behind the main body of work has been about protecting vulnerable witnesses. So the focus has been on a person testifying. It's quite possible that there would be modality effects on evidence. So I'm speculating clearly, but if there are those effects, they would be in line with what we're seeing here, that the more direct and immediate the presentation of a piece of evidence is, the more impact it has. And the more remote it is in terms of its presentation, the less it's processed. And I think very importantly is this memory aspect, that stimuli that are presented remotely are remembered more poorly. But I suspect many of these questions will be answered by mock trial research in the coming years. And this is a really important one. Yep.
So one adversarial system is tended to force the truth to the surface and for the trier of fact to make his or her decision. And we rely in large part, not entirely, but in large part, on examination of witnesses to determine which is telling the truth and which is not. And I go back to your fundamental point that the signals for deception are so weak, there's no. So in determining who's lying and who's not, it's only slightly better than the toss of a coin. And so my entire career has been a waste.
No. Here's what I can say. 1 minute, fast. There are ways to detect deception, and those means are available to you because the interrogation research, interview and interrogation research I conduct has to do with how to interview to detect deception. So there are interview protocols and methods to question a person that leads liars to give different statements than truth tellers. So what I'm talking about here is when you are, as a juror, passively observing a statement, but it's not hopeless. A skilled questioner can pose questions in such a way that it impeaches a person's credibility. So there is hope, but it relies on particular systematic and strategic questioning methods. And as far as I know, there's no mapping of what questioning strategies lawyers use. It's totally ripe for exploration. And we don't know what the effects of those methods are. So no, your career has not been in vain. I can assure you that.
Thank you very much.
Thank you.
Now I think we're ready for our next speaker. It's an honor to introduce Valerie Hans. Professor Hans is the Charles F. Rechlin Professor of Law at Cornell Law School, where she conducts empirical studies of law and the courts and is one of the nation's leading authorities on the jury system. Trained as a social scientist, she has carried out extensive research and lectured around the globe on juries and jury reforms, as well as the uses of social science in law. Professor Hans is the author or editor of 9 books and over 150 research articles. The books include The Psychology of Tort Law, American Juries, The Verdict, and Business on Trial, The Civil Jury and Corporate Responsibility. Her current projects on the American jury include developing a new theory of damage awards, analyzing how jury service promotes civic engagement, and examining the impact of race on tort decisions. She is also studying the diverse forms of citizen participation in legal decision-making in other countries. Professor Hans is the co-editor of the Journal of Empirical Legal Studies, editor of the Annual Review of Law and Social Science, and past president of the Law and Society Association. And if I may add a personal note, Valerie has been a great friend and mentor to me over the last 25 years in my own efforts to apply social science to the study of legal decision-making. We're truly privileged to have Valerie Hans talk with us today about her recent work on virtual jury trials. Please join me in welcoming her.
Neil, thank you so much for that very generous introduction. And also thank you to the organizers for allowing me to participate. I'm so sad that I can't be there in person with you, even more now that I heard Professor Hartwig's presentation, and know that I'm not going to be as vivid to you, and you're going to be more skeptical. And anyway, I see what I'm going to be talking about as a real compliment to the kinds of things that she educated all of us about in her fascinating presentation. So I'm going to focus specifically on juries, and in particular virtual juries, with which I've had some experience now. But I think some of the phenomena that I'll be talking about actually bear on and will relate to other forms of dispute resolution. So I hope we can explore some of that in the commentary and question and answers afterwards. I'm going to attempt to share my screen. We've already tested this, so I'm hopeful. Let me know if you can see it. Okay, excellent, excellent. Well, I want to just for a moment take us back to March 2020, when the national emergency due to COVID-19, the pandemic was declared and had traumatic effects on courtrooms and courthouses around the world. And as you sadly remember, many in-person proceedings were halted, canceled, put on extended deadlines. Very few people could even get into courthouses, and jury trials were really restricted among all of the types of proceedings. Those are the ones that really do depend so much on in-person experiences. And aside from a couple of jury trials that were ongoing during that time, most were stopped, halted, delayed. With a lot of negative consequences. Even now, we are looking at tremendous backlogs, which have increased pressure to settle cases, perhaps on less favorable terms. And the American Arbitration Association actually entered the marketplace with the argument that, hey, you're going to have to wait a really long time for a jury trial, so try us if you haven't thought about it already. It also, from my perspective as a jury researcher over the years, it deprived citizens too of a very significant form of civic engagement. One of the things that we've discovered through our research is that when you participate as a juror, it actually appears to give you a stake in our government and helps people think about the possibility of other forms of civic engagement, like voting, for example. So in research that looks at before and after jury service voting patterns, we see a boost, especially among people who were low voters in the past. Well, because of these dire consequences of pausing jury trials, people began to explore. And here's an example of the in-person masked option. I too, like the Professor Hartwig, have no idea about what masks do to people, except we know, like this woman in the red shirt, that many people wear masks inappropriately. So they don't always help. So that was one option. The other was the virtual trial option. What you see here is a real virtual trial enthusiast, Emily Mitchell, up in the upper left-hand corner there, doing a jury trial. It was actually, she was selecting individuals for this jury trial, which was a summary jury trial. And, her comment at the time was, hey, it's just a summary jury trial, so if everything, blows up, at least nobody will really be hurt. Anyway, it turned out apparently just fine. But interestingly, a number of states did engage in civil jury trials. In particular, a few actually tried criminal trials as well, although of course that does raise some constitutional issues that aren't available or aren't as serious in the civil law context. So the state of Washington was a real really a real leader in terms of trying virtual proceedings, including virtual civil jury trials. There were also some trials in Florida. I don't know what the situation was in Connecticut. I'd be really interested in hearing if any of you had some direct experience with this. There were also some demonstration projects to try to explore, what is the effect of having a civil jury trial? The concerns about whether or not virtual trials were actually just was on a lot of people's minds. First of all, just unbelievable technical difficulties. I certainly had them in my research on virtual juries, and I'll talk a little bit about that later. There were also some concerning results from polls conducted by, among other people, the National Center for State Courts that showed certain categories of individuals would be less likely, or said anyway, that they would be less likely to participate in a jury in person under the kind of pandemic era circumstances. And the fact that not everybody yet has good internet access also raised the specter of Zoom trials being derailed because somebody couldn't get online or technical difficulties ensued. Lawyers also expressed a lot of concerns, and maybe those of you in the audience were among them, that even the voir dire process, if you're looking at tiny little squares on a screen, are you really getting enough of a sense about the person's credibility, their potential reaction to you as an attorney, all the kinds of things that might go into determining whether or not you think that it is safe to leave them on the jury or not during jury selection. Those were concerns about whether virtual jury selection was actually sufficient to allow attorneys to do a good job. And also the inability of the parties to present their cases fully and effectively to jurors who are engaging remotely, and also to perhaps some of the witnesses who are engaging remotely. As I was listening to Professor Hartwig's presentation, I was thinking, especially in civil trials, trying to present a plaintiff's pain and suffering, and trying to do that in a way that is vivid and engaging, and captures the fullness of the injury to people, could be potentially influenced, potentially affected. There's also the issue of presence in virtual proceedings. And if you're a juror participating remotely, you're not there. And in addition to the vividness issues, there are some other questions too that are raised. Nancy Martyr has just come out with a longtime jury scholar, has just come out with an interesting new book where she talks about the way in which the entire process of the jury trial in effect socializes people into taking a jury role and doing it well, like from the very beginning when you are in jury selection, in your interactions with the judge early on in the trial, and then throughout, in the presence of the courtroom, and with the presence of other individuals, and the instructions that you get from the judge. All of that actually helps to take people from being ordinary citizens and turning them into fact finders who have the goal to do justice. So how is that affected by the fact that you and your fellow jurors are squares on a screen? The worry is, of course, that there'll be less engagement and attention to the trial process. And our very own Neil Feigenson, along with his colleague and collaborator Susan Brandeis, have spoken a lot about and very persuasively about reductions in empathy, especially perhaps for those litigants who are different from you as a fact finder, and already might be suffering from what Professors Brandeis and Feigenson talk about as empathy deficits. And of course, there's also a question about whether or not you can have a good and robust and high quality jury deliberation if you're not sitting in the same room with each other. So here's here's my kind of small silver lining with the pandemic. In March of 2020, I was conducting I was conducting an in-person jury study. I got generous funding from the National Science Foundation, and together with my collaborators, we were doing a research project where we were trying to understand how juries come up with damage award amounts. So we assembled people from my local community in upstate New York, Ithaca, New York, and brought them together. You know, we advertised locally. We brought them together to decide on a hypothetical case, which was a videotape trial of about an hour in length. And we had them listen to attorney pitches, if you will, for different ways that they might go about deciding on damages. So we had run, I think, 24 of these mock juries. We had many more in mind, and we had the money to do it. And March 2020 happened. So we had to stop. And Cornell University, I think it was over a year before they let people unconnected with the exact business, you know, the teaching or student roles in the university on campus. So we were not going to be able to finish up our project. And we debated about what to do and thought, well, let's do a Zoom trial. I mean, let's do the same thing, exact same thing, as close as we can, but do it by Zoom. And that's what we did. So we wound up running 30 virtual juries with very close to the same methodology as in the in-person juries. So the kind of research that Professor Hartwig was talking about, you know, the research in the future, we were actually able to do at least some of it. Now, we couldn't answer every question. So lots of the questions that followed her talk about reactions to people who present their testimony on live or on video, you know, we could not actually answer those questions because everybody saw the same videotape trial. But we could look at jury deliberations, all of which were videotaped. We're still coding. Well, we finished coding those, and we're analyzing them as we speak. We also had a lot of the same questions. And one of the sets of questions we had was how they felt emotionally about the parties in the case, because we thought it was important to look at whether or not emotional reaction during a trial was related to a damage award amount. So we were able to answer some, but not all questions. Now, you know, what did we expect? There wasn't a huge amount of literature on, you know, certainly on virtual jury trials. We thought because of the National Center for State Courts polling, we'd probably get different people participating virtually versus ones who were participating online. I got to say, this was based in part on teaching virtually. We expected in-person jurors would probably evaluate the jury experience more positively than virtual jurors. They might, in fact, be more confident in their decisions, more satisfied overall with the in-person experience. But, you know, we had looked at a lot of the jury literature and did not really expect differences in the verdicts and damage awards. We thought those would be comparable, in part because of jurors' attention to the content of the evidence as they make decisions on liability and make decisions on damage awards. So I'm eager to share with you something of what we found. Again, you know, people in small groups, 5 or 6, we tried for 6, but occasionally in a few cases in each of the types of projects, somebody just didn't show up. And they came either to our school in Ithaca, upstate New York at Cornell, or participated on Zoom. We gave them questions that were like voir dire questions, although we did not exclude anyone on the basis of that. They watched together a videotaped trial of this hour, made individual decisions. then deliberated in a group using the breakout rooms feature on Zoom. Maybe some of you are familiar with that. And then we gave them more questionnaires that asked a lot of questions. So we did get pretty comparable race and gender breakdowns across those two different types of cases. 60% female in person, 62% virtually. Race was a bit different in person. The whites were somewhat higher, but not significantly. And you see modest participation of people who are non-white, reflecting our largely white environment in the Ithaca area, because we pulled from the same sources, advertised in the same places for both the in-person and virtual. Now, here's one of the things that maybe those of you who do a lot of meetings on Zoom can appreciate. We asked lots of questions, as I was saying, about emotional responses and subjective evaluations. We got a few, but only a few. What our virtual jurors said was it was a more difficult task to participate in this mock jury, and it took greater cognitive effort. Which will be interesting when you see some of the later results. So they experienced it as more demanding. I think that's important. I'm reminded of the question about, is this something that might change over time as people become more familiar with video experiences? And that is possible. And I realize one thing we might actually take a look at is whether or not those perceptions of cognitive effort or reports of cognitive effort, perception of difficulty might have changed over the course of the project, which went from started in December of 2020, but went all the way through July of 2021. And over that time, people did gain lots more experience with Zoom and doing things online. So thanks, because I think that one question is making me think it'd be really good to look at changes over time. We didn't get a lot of other differences in motivation, emotion. They were watching the same taped trial again. So some of the vividness questions really aren't answerable here, but at least whether they were watching it in person with other people sitting around a table or with the little squares on their Zoom screen did not seem to matter. Here's all of the questions that were subjective evaluations. Confidence in the decision, helpfulness of the plaintiff's attorney, the judge, and the defense attorney in helping them arrive at a damage award, which often jurors will say is one of the most difficult things in a civil trial. And you can see that except for those two things, really people responded pretty similarly, pretty comparably. The PANAS is an emotional scale. It has emotions that are negative and emotions that are positive. People answer, I think it's 50 or 60 questions about their emotional state. And what you can see is really these do not differ. And I got to say, this was a big surprise to me. And again, I've taught in person, I've taught virtually, you feel the room in a way that you do not when you're teaching virtually. And I was confident we would find more extensive emotional responses, but we didn't. Now, we looked at the case outcomes. So first of all, there wasn't a huge difference and not statistically significant, especially given the incredible variability in damage awards, in the overall award, in how severely they rated the plaintiff's injury, and whether or not they classified the desired award as deserved award, as low, medium, or high. And those all were very, very comparable. Two ways in which the virtual juries differed from the in-person juries, and each of them showed a bit of, a significant boost, I would say a positive boost for virtual juries. First, the in-person jurors they differentiated between, we had two plaintiffs in the case so that we could see whether or not people gave a low award to the low plaintiff, low injury plaintiff, and an appropriately higher award for the more severely injured plaintiff. The virtual jurors wound up differentiating more strongly between those two different types of plaintiffs in the same case, which was an auto accident. Negligently caused. The virtual jurors also were less variable. That is, they agreed more with the individual level. So they seemed to arrive at a damage award number that was more similar within the virtual juries than the in-person juries. And so you can visualize these two effects. I have some slides on them. And first, we'll take a look at the damage awards for the virtual and in-person mock juries and the total damage awards. What you see, if you look at those left bars, those are the in-person jury damage awards, and the bar that is dark is the one of the plaintiff who was not injured very much, and the one that is light is the one who was severely injured. These are natural log awards, which is a technique that we use in analyzing damage awards because of their variability. So what you can see is our in-person juries definitely did give more money to the person who was injured more severely, but it is not as great as the difference between the severely injured person and the less severely injured person among virtual jurors. So that's something to continue to explore. But it definitely doesn't suggest that virtual jurors are not appreciating the quality of the injury. In fact, if anything, they are distinguishing more between the high and low severity plaintiffs. And variability, that we took a measure of how much people varied from the average in their particular experimental condition. And what you can see here is that the virtual jurors seem to do a better job of agreeing more in the awards. In person were more all over the place. And this is one of the critiques of juries in civil cases, right? That they don't know how to come up with the number, and they're all over the place. And you see that more in the in-person jurors than in the virtual jurors. Just a couple of other things to share with you. We did, as kind of in line with the project by the National Center for State Courts, we did find some demographic differences. Our in-person jurors, who were, again, drawn from our local community, same local community, were older. It turns out they were also more conservative and less diverse in employment. You'll see there were some differences as well in education. We didn't see a lot of other differences that I'll show in just a sec. So here's the age difference. And what you can see is that when it came to virtual jury, mock jury participation, younger people in our two different age ranges were much more likely to say, yeah, I'll do that experiment. And older jurors, especially those over the age of 65, were much less likely. And yeah, we did have somebody participate who was 87. That was our oldest juror. And you can see something similar here in education, with lower education levels for the in-person jury as the virtual jury. So looking back on the differences in variability of award and differentiation between low and high severity awards, one of the things we're going to need to look at is whether or not we could actually explain those differences, not by the fact that they were in virtual versus in person, but actually by the individuals who were part of this. And that people with higher levels of education might have been better able to appreciate the high severity injury and attach a number to it. We had my collaborator is Valerie Reyna, a cognitive psychologist who specializes in a phenomenon called numeracy. And it's, the facility with numbers, kind of like literacy, facility with letters, and all numeracy, facility with numbers. We expected, especially with the education differences, we would see some big differences. No, we did not. We looked at so-called objective numeracy, which much to our jurors' dismay is kind of like a hard math test. And we put the questions right at the end of the very last questionnaire, and many people really did struggle with it. But also there's something called subjective numeracy. It's how good do you think you are with numbers? And we really didn't see any differences as a result of numeracy between virtual and in person. Again, kind of a surprise given the education differences. And, we did find that our virtual jurors seem to be kind of positive about the experience. Most of them thought that, it helped to deliberate online in the process of communicating with other jurors. They often said that it was an engaging experience and one, that they did find satisfying. Of course, we're talking about a mock jury experiment, not actual jury studies, but one of the things we do know from, countless post-trial surveys of jurors is even though they resist taking up that, banner and joining the jury initially, and there's a lot of effort, let me try to get out of jury duty. Once somebody serves as a juror, they tend to come away very positive about the experience and their opportunity to participate in part of government. Here are just a few of the comments from people who served as virtual jurors. Very different reactions. Lots of people talked about the way in which it was actually positive experience. You see faces close up in virtual experiences. I was kind of struck by this one, the very first comment. I feel over Zoom we are a closer group, closer physically. I mean, how can that be? They're not sitting right next to each other, but the experience of Zoom where you get a person's face, really close, seems to be impactful and vivid. There's also some discussion, which we are looking at, actually, we're looking specifically at interruptions. There's a way in which the Zoom experience, there's a problem of keeping eye contact on the little camera as opposed to maybe what you're reading or looking at the other person. There's also some awkwardness in turn taking and knowing, when it is time to have your time to speak and all. So you can see people had very different experiences. Virtual, there's less interrupting each other. And then, another person saying, oh no, in person, people will not interrupt each other. So we're determined to find out the answer, at least in terms of our deliberation analyses. Let me just give a nod to my amazing co-authors here, including Christia Reed, Valerie Reyna, Vivian Rottenstein, Addie Rodriguez, Rebecca Helm, and a host of wonderful Cornell students who helped us run both of these experiments, and also to the National Science Foundation, which allowed us to turn on a dime and take advantage of this very small silver lining of the pandemic. I'm going to stop sharing my slides now and would love to hear your thoughts and questions about virtual juries.
Questions? I think we should probably move.
On your earlier slide, it had to do with the subjective experience or perceptions, and there is a noticeable difference in terms of how they view the helpfulness of the
Yeah. Yeah, that is due to our manipulation. So I have, as I was explaining, the scientific purpose of this study originally was to look at what plaintiffs' attorneys might do, and defense attorneys eventually, but this one manipulated plaintiffs' attorneys, what plaintiffs' attorneys could do to help guide jurors in decision making. And so we had the judge pretty much say the same thing, the defense attorney say pretty much the same thing, and they both, kind of emphasized use your common sense. But the plaintiff's attorney, we had three different conditions. In one condition, he was all about common sense. Use your common sense to come up with a number that is, going to be a good figure for my clients. In another condition, we had him say, it's hard to come up with these kinds of numbers. Think about what an hour of pain and suffering might be worth. And whatever that number is, then, you multiply it by just how many hours my clients have suffered as a result of the negligence of the defendant. And then in the third condition, we had him say exactly the same kind of thing, but he gave them a number. He said, think about maybe $10 an hour, just as you should come up with your own number, but, how about $10 an hour? If it is $10 an hour, here is how much each of our plaintiffs should get. So then he actually did the multiplication for them. There's a well-known phenomenon in the numbers world, and that's the phenomenon of anchoring, where if you provide a dollar amount, even if it's a completely ridiculous dollar amount, people, when they generate their own damage award amounts, in this context, they'll be affected by that one way or another. So they might not, let's say you say $1 million for a severely injured plaintiff. They may not give $1 million, but they will be influenced by the fact that you have talked about $1 million. Now, if without the number, their intuition would have been higher, like $5 million for this kind of injury, that $1 million will actually pull them down. If instead they were thinking, well, maybe $100,000 for this kind of injury, and you mentioned $1 million, that will pull them up. People, it's an unconscious process, and it is very hard to get rid of. One thing that people have tried is counter numbers, populating the lawsuit with lots of numbers, so that people might be able to choose or be affected by some of those other numbers. So here's what we found. We found that plaintiffs' attorneys who gave the numbers, they were the most helpful. And those who proposed a method were sometimes also seen as more helpful than just an attorney who would say, use your common sense. One more unusual finding that we have now replicated in a couple of studies, when we change the plaintiff's numbers, that is the plaintiff's recommendations, the judge's numbers change for helpfulness. So if the judge permits the attorney, for example, to give an anchor number, the judge will be seen as more helpful too. I would love to know what your explanation might be for something like that. Our thought is, the judge is actually arranging an environment, making it possible for jurors to do a job where they at least have a kind of a number in their minds that an attorney thought was a reasonable number for an award. And so they're not operating completely at sea. So anyway, so that's why I think in this particular case, the plaintiff's attorney winds up being seen as much more helpful than the defense attorney. And of course, defense attorneys are in an interesting and often challenging position about whether to offer a counter number or not if they're contesting liability. The judge was a woman. The two attorneys arguing were men. The defendant was a man, a driver of a delivery truck who negligently, ran a red light and ran into the car of our plaintiffs. And the plaintiffs were all women. They were real estate agents. So it was hard to evaluate their income. Which of course, when you're trying to figure out how can we help people, make good judgments about damage awards, we wanted it to be somewhat ambiguous about the effect of an injury. In one case, career-ending injury, and in the other case, only a temporary career pause would do. That's the gender. We wondered whether or not there would be differences in men and women in in-person versus virtual deliberations. One of the collaborators that I have, this is Vivian Rottenstein, who now is very happily doing jury consulting for trial consulting for a firm in New York. Actually looked at gender in the in-person cases and surprisingly found a few differences in the in-person juries between men and women and the kinds of things they said, and even in interruptions, which was a surprise to us since it's somewhat inconsistent with gender effects in other jury decision-making and other group settings where men are more likely to interrupt compared to women.
Thank you, Professor Hans. This has been wonderful. I want to know, I have a process question. You mentioned that with respect to the voir dire, you did not eliminate any jurors. You asked them questions, but you let everyone sit. Can you talk to me a little bit about the thought process behind that, whether there was consideration given to those who would be very biased one way or another, or was it all kind of neutral out over time? Because as a trial lawyer, obviously, those are critical issues and considerations where, this is the most important part of the trial, and allowing folks to sit and deliberate, that have these strong biases are just not appropriate. So I wondered, how does that work through your study?
Yeah, no, I think that's a great point. And, there's so many ways in which our research project is different from an actual jury trial. And that's a very significant and very important one. In our defense, as scientists, one of the things we wanted to determine was whether or not the questions that we asked on the voir dire, which were similar to the kinds of questions that one might ask on a more expanded voir dire like you have in Connecticut, would actually predict what people decided in the actual case. So that's what, for example, we asked about demographic characteristics. We asked, have you ever been in an auto accident? And we asked questions about their views about the civil justice system, common questions that have shown in other contexts to be predictive of what juries will do in civil cases. Like, I believe plaintiffs, are often to blame for their own problems, and there's a litigation explosion with many unmerited lawsuits, and there should be a limit on damage awards. Those kinds of questions. So we're in the process of analyzing those. But the point that I think really underscores just how different this will be is that those people then, not only did we get individual level data from them, but they were on juries. So one interesting question for us in the future might be to take a look at whether or not they were particularly influential on the juries, and whether or not they shifted, what the juries did in the collective decision making. I think I've tried this with some other projects that I've collaborated on, identified by the answers, people who give really extreme answers, speculating. Those are the people that would probably be excluded by either a challenge for cause or a good peremptory challenge by one side or the other. So we could identify that group of people and then observe whether or not they do have a disproportionate effect in the jury room. It's, a fascinating question. I don't think anybody's really answered that.
So I have a question also about process, and it has to do with whether there was a foreperson and that you saw any difference in the role that the foreperson took in facilitating discussion amongst the jurors, and whether you were able, in looking at the videotape of the deliberations, to code for things like turn taking, but also how frequently jurors spoke, the amount of airtime they took. I understand interruptions you were paying attention to, but interested in that sort of broader participatory question. Thanks.
Yeah. Oh, I'm so. I wish I had the answer for you. We are analyzing the deliberation data right now. In a few months, I'll have an answer for those, but I don't have it now. One of the things I deeply regret is that we actually because we wanted to be efficient and get people in and out and have most of the time a discussion of the case, we actually assigned their foreperson status by either randomly or by whoever took a juror number one position at a table. And the reason that's, I mean, there are some states that do that. My old home state of Delaware, actually, whoever is juror number one becomes the foreperson. And sometimes judges will appoint a foreperson in other jurisdictions. But it would have been fascinating to see how the selection process developed. I mean, what we know from in-person juries in the past is that the foreperson selection is pretty quick usually, but it's not accidental. And people who have high social status in the external world often take a leadership role in the jury deliberation too. And I would have been so fascinated to see whether or not that same process would occur in a virtual setting where you have much less, you're not even rubbing shoulders with the people, you're just seeing them on the screen. So you wouldn't maybe have the same kinds of clues that you would if you are sitting around the table with somebody and watching a video with them. So anyway, a lost possibility, definitely.
Has anything been done with more complex trials or simply tort trials?
Oh, I'm sorry, I didn't quite hear that. I know there was something about complex trials.
Yeah, has any research been done on non-tort trials, more commercial disputes?
Are you asking, is there, we had a pretty straightforward and simple auto accident case with negligence, which we skewed heavily toward the negligence direction because we were really interested in damages. So they had very little, they had very little work to do to come up with a liability verdict, and all the juries in both settings arrived at a liability verdict. And I mean, we're happy about that because we wanted to look at how they decided on damages. But whether or not this would apply to complex cases, I think is another a really interesting question. Here's one thing that worries me, and that is that virtual jurors said they experienced it as a more difficult task. So even a very straightforward task might be more complicated in the virtual environment. And that's because you got to pay attention to, like, is my camera on, and who's on the screen, and am I having technical difficulties? Again, that might change over time, as we discussed earlier, that where people might be getting better at doing online things. But complex trials are often incredibly demanding. And we don't want to add any more cognitive demand. And the reason is, when people experience cognitive demand, and maybe you felt this yourself, you kind of default to a more simple, you're looking for more simple ways to resolve a complex question. And often you might default to something that doesn't really take into account the entire complexity of it. That is the one thing that worries me about complex trials. The research on juries and complex trials is reassuring generally, although, sometimes juries make mistakes. And part of it, I think, is the fact that juries do decide in groups, and the group and deliberation context can often be a real boost, offer a real boost to fact finding. So that even if individual jurors are not really fully grasping what the complex either legal issue is or factual issue is, they can really be helped along by people who are more savvy or better able to handle that kind of cognitive complexity. But that is the thing that worries me about virtual trials and complex cases, and that is this possibility that the extra demand of experiencing life virtually will be difficult for them, and maybe push them into a more, a kind of easier way of resolving a dispute, like maybe just relying on irrelevant cues or other sorts of things, as opposed to grappling with the key questions. Yeah.
Good morning. I had another process question, which was, it sounded to me as if the jurors that you had for in-person and virtual were watching a pre-recorded trial, right? But that pre-recorded trial was in the nature of being a live trial as opposed to a trial that was done on Zoom. Is that correct?
Yeah, that's right. So we, I see you're in what looks like a very beautiful Quinnipiac moot courtroom. So we filmed in Cornell's kind of moot courtroom, and, had a judge sitting at the top and somebody walking into the jury box, and, lawyers sitting at tables with their clients. So it was filmed as a live trial. Although, and then everybody saw that same live trial, that same live videotaped trial. But I wonder if you're wondering, well, what about videotaped testimony by a particular witness when everybody else is in person, or even the entire trial being videotaped and people zooming in from different places? We can't speak to that. I think it would be comparable, but I'm not sure. Because at the very least, when you're looking at a videotape trial, you're seeing people interacting. There's a lawyer there with his client, sitting right next to him. So you see a little bit of their interaction. For example, where in a trial where everyone is zooming in, it would just be maybe adjacent squares, in a Zoom room. Yeah, I see we're getting close to time, and I just would love to turn the tables on Neil Feigenson a bit. I think most of you may know that Neil's, I would say, has done some of the most creative writing about some of the challenges of virtual trials. But I'd be very interested, Neil, if there was anything that really stuck out for you in hearing about these results for the first time, giving your own concern about the possible negative effects of presence in virtual proceedings.
Well, yes, I thought it was a fascinating talk, and we're all looking forward to the next phase of what I hope will be your research or your colleagues' research, building on that last question. I think that's what it would be very interesting to see if virtual versus in-person juries differ in outcomes, in experience, and so on, not just when they're responding to the same recorded trial, but to an entirely virtual versus in-person trial. That research hasn't been done yet, to the best of my knowledge. I don't know if you know if anyone out there is, no? And as Maria said earlier in connection with the work she was talking about, it takes time for this research to be done. So I know of some projects that are proposed, underway, but it'll take a while before we have findings about those sorts of questions. Yeah, I think we just don't know about the effects of, for instance, the things that our friend Nancy Martyr has written about. What difference does it make when jurors spend their entire time physically segregated throughout the trial in the jury box, then later in the jury deliberation room? Does that perhaps create a sense of co-presence that in turn has an effect on deliberations and even outcomes? I mean, I'd be very interested to know about that, but I don't have any original results to report because the research hasn't been done yet.
Yeah, in the virtual trials that I know about, whether they're simple virtual proceedings or actual full jury trials, I know that judges do whatever they can to try to impress upon the participants the kind of legitimacy of the courts, the kind of grandeur of the courts. It's pretty hard to replicate, as your work really, I think, powerfully argues. But they're always sitting in their, at their bench with flags behind them and have people, swear, take the oath and do other kinds of things that we do have regular jurors do. So virtual juries have kind of opened up some possibilities, but also raise, I think, absolutely fascinating questions about where we go from here and whether or not the jury system actually is just a bridge too far currently in the virtual world.
Thank you very much, Valerie. Fantastic presentation. And thanks for being with us here this morning from Charlottesville.
Thank you. It was wonderful to talk to you all.
I was going to introduce the next set of speakers or panelists for the lawyers who are actually doing virtual trials. And I'm going to give a brief introduction, not the introduction they deserve, because we have so much to cover, and one of our panelists has to leave early for a commitment. So first is, I want to introduce Peter DeFrank from New Jersey. He's a plaintiff's trial lawyer who in his 14-year career now has obtained many significant verdicts. He's been described by a number of New Jersey magazines as a rising star, but based upon the number of cases he's done, he's an established star. And I'm proud to say he's a graduate of this law school and was one of my students 14, 15 years ago. Ken Friedman is a lawyer from Washington, where, as you heard, has been doing a lot of virtual trials. He's a nationally renowned trial lawyer who has has obtained a lot of significant results in both sexual harassment trials, defamation, personal injury, bad faith cases, and police misconduct cases. As I said, he has a wealth of experience trying virtual jury trials and virtual trials. We also have Ben Crump, who is on the Time magazine's list of most influential people and the Ebony magazine Power 100. He's nationally renowned for his work in civil rights cases, excessive force cases, police brutality cases. If you Google him, you'll see his list of cases and clients are all names you would recognize, like the family of George Floyd and Ahmaud Arbery. And my co-moderator is United States District Court Judge from the District of Connecticut, Victor Bolden, who I'm going to ask to pose his first set of questions to the panel.
Great. Thank you very much. It's an honor to be here and with this distinguished panel, and also Ernie Teitel, who is certainly one of this state's leading lawyers, if not one of the leading lawyers in the nation. I've had a chance to know Ernie for a number of years. We served on a board with Quinnipiac for a number of years together, and it's a pleasure to be here. This issue of virtual trials raises some interesting questions. for us. I mean, obviously, the right to a jury trial is one of the Constitution's most precious guarantees, both in the civil and criminal context. Certainly more, obviously, there are more constitutional protections that come with the criminal trial, but certainly even with the civil trial, there are aspects of it where the Constitution certainly guarantees rights, and states, even in state courts, have recognized the importance of jury trials. And virtual jury trials create sort of an interesting opportunity. The earlier panels, there have been discussions about some of the social science data related to the virtual trials. We've also now saw a presentation of what some of the data shows from some of the mock trials that I've watched of how justice has been. Now we get a chance to see from those who've actually litigated these cases what it looks like. I want to start with Ben Crump and his experience with virtual trials. So, I mean, obviously, American courts have begun and continue adopting and adapting to the technology of today to ensure justice. And virtual trials, where the counsel and parties may not be in the same room together, creates an interesting challenge. So, first, let's start with this notion of how is it done? How virtual trials done that you've seen or participated in, Mr. Crump?
Yes, sir. Thank you so much, Judge Bolden, and I'm very honored to be here to share my lessons with you. I thank my good friend Robert Simpson to make sure I got on the plane and got here on time, and my partner Chris O'Neill. So, Judge, I've had now 3 major multi-district litigation hearings, which were like mini trials. They lasted 3 days, and we were virtual. And I've had 1 trial from jury selection to end verdict, which yielded a $400 million verdict, which was very interesting. So I think I will start there. One of the things, I'm a plaintiff's lawyer, and I think for not only judicial economy and efficiency, but for our clients to have their day in court, I think this is the way of the future. And when we had the trial, Attorney O'Neill and us, it was during COVID pandemic, and we were faced in the state of Florida with the Hobson's choice. You do the virtual trial, or, and our client was partially paralyzed, or we would have to wait 3 years. We would have to wait to the end of 2023, 2024, and we had this trial in 2021. And so even though I would have much rather, Judge, have my client able to walk into the courtroom and the jury get the full assessment of his debilitating injuries, but we wanted to not have to wait 3 years. So much could happen when a person is paralyzed in a 3-year period. And so we said we're going to do a virtual trial, and it became interesting because the judge did a hybrid. He made the lawyers come to court, and we were socially distanced and all of that there. And he then had the jurors have personal laptops, and the ones who could not afford them, the lawyers, we provided the laptops for them. We had good paralegals that went to a designated spot by the clerk and met with people at certain times and taught them how to use the laptops. Now that's really interesting, and I'm sure Pete and others may have something, because I think to get a jury that is reflective of the community, you really have to be able to assist them and provide them with the technology, or you will probably lose a whole segment of the community because they can't afford that technology, they don't know how to use it, and so forth. So it really is incumbent upon you to get people who are technically savvy, who can help them troubleshoot, which was a big thing the judge was concerned about during the whole trial, is if somebody's computer goes down and we lose a juror, what does that mean? You know, do we stop the trial or do we lose that juror? What do we do? You know, if we were in regular court, somebody gets sick, we bring the alternate. But what happens if you got 2 or 3 people having problems with their computer and we can't move? And I joke with Chris a lot, and Judge, I have been in too many trials where the technology fails you, and man, when you need it most, that's when the technology will fail. And I'm sure I haven't had judges as considerate as you, Judge, but they say, well, counsel, you need to move on with your case. We're not going to wait for this PowerPoint to get ready. And so that became the real issue. And we were picking the jury, and we all had our fingers crossed because we knew that was going to tell us if the people at least understood the basic aspects to log in, to be in the waiting room, to be brought back in when we question one juror at a time and so forth. And it was challenging. We had a lot of people who had basic high school education. They understood Zoom. Everybody understood Zoom. But the whole thing with going in waiting rooms and coming out and being notified, raising your hand when you had a question, I still don't know if some of the jurors knew how to raise their hand with questions, but we labored through it. And the last thing I would say about the process, and give the other panelists time to speak, was trying to position yourself in the right way where they could see you, where you're not cut off and all this stuff, because we saw with a lot of the jurors, you're looking at these 14 figures on a computer screen, and the judge had it blown up like on a screen like this, and you saw a lot of them, and you saw half of them and everything, and you know, we really trying to get the facial expressions to see their reactions to the testimony and all like that. And then it became important to me saying, well, let me make sure that they can see me when I'm talking or when our lawyers are presenting our case. And you would be amazed at how lighting and those type of things play into you being able to communicate effectively in a virtual trial. It's just like when you're doing these interviews on the cable news things, you saw during COVID, everybody was doing them, and it became such a fascination on the quality of your technology that people started rating the rooms, and they would rate what you have in your background and all this stuff. And I think a lot of the jurors are watching us lawyers, and they're not only listening to what we say, but they're looking at our surroundings. You know, when I noticed past all your papers organized and so forth, because we tried to have the camera where they could see our whole table, and then when somebody was arguing, we let them zoom in to just that person. And the thing that we were so worried about was when you have the human emotion that you have in a, actual trial, jury trial in person. And it struck me that people go to movies all the time and they see TV and they, tear up, they laugh and everything, all the things like we're here. And so I said, I think have a chance of being able to do this. And I knew it happened when I saw a lady while our client was testifying take a Kleenex and wipe her eye. I said, no, this probably is going to be the wave of the future as we move forward with technology and judicial economy. So that was my preliminary experience. And like I said, Judge, it worked. They came back at $400 million.
All right. We move on to Peter DeFrank. I know, Peter, you've had some experience with virtual trials as well. And how's it work for you?
Sure. So on one end, I'll start. As our first criminal case in New Jersey, there was an appeal early on because it wasn't an accurate reflection of the community, which I found is I'm as much of a student as I am more than a speaker.
Yeah, you might want to be. Just you can pull it.
For the first one in New Jersey, the first criminal trial that we were experimenting, there was an appeal because it wasn't.
It may not be on. You may want to click it. Just there you go. Try it now.
How about now? All right. Can't hear the guy from New Jersey. I don't know. So when we first started this, it was fascinating learning that the first criminal trial, there was a appeal because it wasn't an accurate representation of the community. And I remember at that moment I said, oh, shoot, now what are we going to do? Because I'm glad I'm not deciding that issue. And I think after that, they started to give people computers or whatever access if they needed it for as long as we stayed purely virtual. We are still doing jury selection virtually now. I haven't heard one way or the other if they've kept giving out computers, but I think the way they left it is if you want it, which is not that many people in a lot of the jurisdictions I'm in, that you can go and get it. One thing I want to expound upon, because my light bulbs are going off from the 3 cases I tried with the other speakers and what they're finding from the social studies. Couple things that are becoming prominent. One, the jurors are more skeptical of somebody on video, which I'll get to in a second. They're less sympathetic and less empathetic. And that's what I found when I had tried my first case purely virtual. I'm one of the few lawyers in New Jersey that actually got a trial date for one that was purely virtual. And your brother, Rick Freeman, was a seminar about 7 years ago when I was, a younger lawyer, saying you can't be afraid to tell people that you lost, and you can't be afraid to lose. So about that case, it was a slim margin. Brief background. It's kind of not an unusual case. It's a herniated disc case, maybe 1 or 2 injections. The woman was 70. I made the argument she wanted to work to 75 to blow up the damages portion, but there was a liability issue. The defendant's on a main road in Hudson County. You could probably look left and see the Hudson River, so it's a busy area. There's apartment buildings, there's shops. He's coming straight through a main road, and my plaintiff is driving and making a right, and she hits him in the back panel. He says the light was green. My client says my light was green, and then the cop comes and finds that the light is not working. And the light was not working in his direction. So my hope was to get this case to 50-50, right? So I said, I got to cross-examine this guy that his light was not green. His light was not green. So as the discovery went on, the town was in the case. At first they said we have nothing, and then I started to make some arguments. Oh, we found a logbook. Someone was there at about 45 minutes before, and the light was working. So they got out on a motion. I can't prove notice. It's not palpably unreasonable. So now it's just me and the driver. So what happened was, I think my cross went really well of the driver. They didn't believe him that the light was green. My woman was in Florida, which quite frankly was great. Over an interpreter, no less. So she had a double whammy. She's in Florida. At the same time, it was going to be hard for her to fly up. So she talked about how she was a janitor. She did it for a little bit and had to stop working. It was a $100,000 policy. So I said, if I make a $200,000 lost wage claim, maybe I can get it 50-50. The jury goes out. They hear her testimony, and they come back. And you got a 55-45 in the defendant's favor. And all I have to do in New Jersey is get 50-50. But what I'm learning about with these studies is I may not have lost that case if I was live, because I don't think it would have been the same number. And I think if they saw my client's passion, if they heard from her husband, and I'm in my office, I was as passionate as I feel like I've ever been for her case. I don't think I would have lost that case. I think I would have got it to 50-50. And I think what those themes are, they're skeptical of the virtual witness, and they didn't believe the guy. I got him to believe the light was not green. As much as he said it wasn't. But at the same time, they had no sympathy for this woman. I figured they give her something, right? They go 50-50, and they maybe give her some small damages. They went 55-45 and stopped. And you learn the most from the ones you don't win. So as far as an actual case study, I can add to you that I think that is dead on accurate, what you're studying, from those social sciences.
Good. All right. Well, we hear some from Ken Freeman. Ken Freeman is in the state of Washington, and my understanding state of Washington has actually adapted virtual trials probably more than any other jurisdiction in the country. So Ken has extensive experience with virtual trials. I'd like him to share that with us now.
Thank you. Good morning. Actually, it was it started, I think, in the Seattle area in our federal court of the Western District of Washington. I think I did the first case. It was a cruise ship case that had a choice of forum clause that required cases to be filed in the Western District. My client lived in San Diego. She was 84 years old. She fell on a cruise ship, and Judge Zilli said, this is the ideal first case. We don't want to wait 2 years. It's not that complicated. Let's try it. And he called us all in. He said, we're going to do a mock trial first to test the equipment, to test the skill of the lawyers. They got 9 volunteers to act as jurors, and we spent a day doing voir dire and introducing witnesses and evidence, and learned how to operate the equipment, and it worked fine. And then the trial really went without a hitch. It was a relatively simple trial and relatively quick, but we did have neurosurgeon testimony. We did show x-rays, we did show videos, we impeached witnesses with video depositions. So it was just like any other federal trial. The jurors afterwards said, the ones who had been in traditional courtrooms and trials said they could see the witnesses better, they could hear the witnesses better, they could see the evidence better. So it was a positive experience, and we've done everything from simple trials to 8-week complicated trials with hundreds of millions of dollars at risk. And from our perspective, they've all worked really well. It's the theme of this day is justice, and can we get justice from a virtual trial? And we got to think about things like, saving $10,000, not flying a neurosurgeon into Seattle to testify is more justice for our client and less money out of their pocket. Or my 84-year-old client in San Diego could watch the whole trial from her house instead of being in a hotel in Seattle and the expenses there. And the trial I'm in now, my client couldn't sit in a courtroom all day, but she can sit at home and participate via Zoom. So those things are justice issues as well, and keeping things moving, keeping things inexpensive. Our experience on voir dire is that like the children witnesses who are testifying remotely, people seem to be more comfortable in their own surroundings. And in that first federal trial I did, we only were given 20 minutes for voir dire, and I got 2 challenges for cause because I don't think I would have gotten in a courtroom where people seem to be more tight-lipped and intimidated by the surroundings. But, 2 people very freely expressed their biases in a way that Judge Zilli was comfortable excluding them. So I think the jurors are more comfortable. They're certainly happier when they don't have to drive downtown, park, go through security, and sit in a little room all day. They love the experience, and they report that they can see, they can hear, and they can participate. One thing they said after that first trial was they didn't know each other like they would have in a traditional trial. And it took them longer during jury deliberations to really get the conversation going because they're still strangers to each other. And what they've started to do in King County here is during breaks, they put them in a breakout room and encourage them to get to know each other, not to talk about the case, but to do the small talk that they would have done in the courthouse. And that seems to be effective as well.
Well, thanks, Ken. On that one point you just raised, which is this whole question of the jury coming together, the jury cohesiveness. I see it often in the trials, and I worry about, as a judge, whether or not what translates in the courtroom, the jurors hopefully not talking about the case, but starting to bond before deliberations over photos or someone going to a wedding or what they did, and those relationships helping them form a sense of community. So I want to follow up on that. And what did you experience with respect to that in terms of the jury coming together and how the virtual process affected that?
Obviously, we don't know what was happening in the deliberations, but the thing that was real profound to me, probably more so then in a actual courtroom, you got to see literally when the jury folded their arms because they're up in that frame. You get to see it. Sometimes you can't always appreciate that if they sitting behind somebody in the second row or something. You got to see that. You got to see very clearly when they yawn, you know. And so, because we all are just studying, you know, the big screen up there. If one of our co-counsels are presenting, you studying the jury like you would in a regular trial. I would say this, Judge, it was funny. You're talking about judicial economy. One time the screen went black, and you know, we were concerned whether, because it was like a 5-day trial, we were concerned a little bit whether the person lost connection and everything. And so everybody stopped. Judge said, are you with us, ma'am, and everything? She said, yeah, I didn't want to interrupt. I just turned off the screen and muted it. I'm in the bathroom, but I'm listening. And it was like, all right, the jury is in tune and so forth, and they figuring out this technology. As it relates to the deliberations, I thought it was interesting. We had a witness, you're talking about relating, we had a witness, you remember, Chris, who was over in Paris, France, an expert. It was a truck accident, bad collision on the highway. Our client was injured. And they had this expert who was testifying, and I won't get into all the details, but his opinion, their person was a blinding rainstorm. He didn't have his flashing lights on. We think we caught him not telling the truth about it. Said he had his foot on his brake and all this stuff. And so their expert said, well, you know, really, I think the solid red light is more visible and better than a flashing light. And so Attorney O'Neill and us, we said, oh man, okay. So why do we have police officers that use flashing lights? Why on school buses do we use flashing lights and all this stuff? And the expert was kind of, you know, arrogant about it. He said, well, those are effective too, but I think the brake light works just as good. And so in closing the argument, I was arguing, you know, does it make any sense? Does anybody buy this? You know, our children are our most valuable, precious resources. We use flashing lights to protect them because we know that's the best mechanism to warn people that there's a safety risk at hand. And when you think if what he was saying was true, we would just tell school buses to use the brake light. Don't worry about the flashing light. And we saw, like, all the jurors nod their head on the screen. And so I don't know what they deliberated, Judge, but I knew on that point of liability we had won. Mm-hmm. And they came back and, you know, they gave 90% liability on the defendant. I know my time may be
No, it's fine. No, it's fine.
short.
So I mean, but your point you're making is it sounds like one of the advantages of the virtual trial is, particularly when you've got the jurors up on the screen, is it allows a sense of visibility that you actually would not have in the courtroom.
Yeah, I thought it was really helpful for us trying to know what was working during the trial and what we probably needed to work on, because we also got to see when they agree with the opposing counsel on their perspective. So I think it helps you tremendously be able to focus more. Would I rather
be in person?
Yeah. Absolutely. Absolutely. But I just think this is the way of the future, so we better adapt. Other than that, we probably will be waiting much longer to get our jury trials. I even think the backlog coming out of the pandemic, they said, is still about 2 years behind, but they keep offering us lawyers, if you want to try this virtual thing, we think we can move it faster. So.
Is that your same experience in terms of visually the experience of watching the virtual juror, the advantages that you found?
Well, I actually was surprised the trial they did where they were virtually, how much attention I think they were actually paying. Like, I thought the mailman's going to run in, the dog's going to run by, the kids are going to be screaming. They were pretty glued to the TV. And I could probably say, like, I see my 7-year-old daughter watching TV and stuff. I'm like, Sienna. And she has more attention on that than anything live. So I think from an attention standpoint, it's actually okay. They'll pay attention to it. When I had jurors in the courtroom on the hybrid, where we picked them virtually and they came in and they had masks on, I remember saying, I have no idea what these people are thinking. The mask is on, they just sit there and sit still. They don't really talk to each other much, so they don't even kind of look and give each other any type of little read there, like nothing. And I remember on that first one, after I closed, I was like, I have no idea what's going to happen with that. I will agree with you 100% on the expert witnesses. So in the second trial I had, they called 2 defense experts, a neurologist and an orthopedic, live on Zoom. One guy I think was faking that he had COVID because he canceled an IME with one of my clients like 6 weeks early. It was in his living room. And I think what makes sense is that they're starting out skeptical from a defense witness live, and then the lawyer comes in and says, you've been doing this defense medical exams since the 70s. You've been coming into our courtrooms, 4 times a month since the 80s. You made $20 million selling your company to, a nationally publicly traded company. And by the way, you have a relationship with the defense firm's father that goes back generations. Once you start questioning the bias questions and the motive on a virtual witness, I actually think that was more effective than in the courtroom, because I'm going in there, I'm saying, this guy's been doing it longer than I've been alive. I'm not going to ask him a question he's never heard of. Am I going to get outmatched here? And rather than him being charming and in person, he'd make a remark, and it actually was like kind of like catty and kind of like a little shtick remark that he would make. We got into it personally over something, and the jury laughed at me. So he was a orthopedic, and his specialty was knees. I'm in a spine case. So he was bragging, broke HIPAA, and says, I treated Tab Ramos, the professional soccer player, when he was injured. So I ball boyed for the Metro Stars. So I said, you mean when Tab Ramos blew out his knee? I said, I used to ball boy for the Metro Stars. He goes, you didn't ball boy for the Metro Stars. Yeah, it was his knee. I said, well, Doc, when you're 14, it's kind of a big deal. And then I finally got a reaction from the jury. So, but his Schneid mark doesn't translate over. Neither did his endearingness, because this guy's a professional, over the Zoom. So I thought it was an advantage from a cross-examination standpoint that it wasn't my witness over the video. Same thing you had.
Yeah. So Ken, in terms of his time is limited. Okay, well, it looks like we're going to lose Attorney Crump. Attorney Crump, thank you very, very much. I appreciate you being here.
Really enjoyed being here.
Thanks so much. So picking up on that, Attorney Freeman, did you notice there are ways that you've been able to sort of understand what's going on with the jury better because they're up on a screen as opposed to being in the courtroom?
Yeah, absolutely. In the courtroom, sometimes the way you're sitting, you can't stare at a jury, but even if you do have a view of them, it's uncomfortable staring at them. On Zoom, they don't know you're looking at them, and you've got a close-up of their facial expressions. And you can have 1, 2, or 10 members of your staff whose only job is to get on Zoom and monitor juries' faces. So depending on the case, you can really put resources into that if you think you're going to learn something. Personally, we don't do a lot of that, but we do certainly look closely at the jury's faces while especially opposing counsel is talking and try to read them. I don't know what you do about it. It's information, but I don't think you change your presentation much.
And on this issue in terms of preference, now you've done a few virtual trials. Do you still prefer to live? Would you like to be more back in live, or do you think it's a balance you'd like to?
I would certainly like it live, but picking the jury virtually, I'm kind of okay with, because there's certain things you can see there. I think they talked before. I can see in this person's house, right? I can get an idea whether they have potentially a pet running around, which tells me somebody has a little bit of empathy if they're a pet lover. If somebody's artsy in the background, I know I may not be getting somebody who's falls into a tort reform, juror or something like that. So I kind of got a better sense initially as to who they were, and I think the judges were more likely to knock people off for cause than when I was doing it live in the courtroom, where the judge has to tell them, okay, I don't like you, you're out. I mean, that's how they're going to interpret it. They knocked out more for cause from, which I didn't realize until we were speaking today, from the virtual than we did in live, from the live trials that I've done. So, I mean, I got an okay read on them. I don't know, can you look up the jurors online?
In Connecticut,
District
of Connecticut, they get in federal court. What we do is that you have access to the list about I think it's like a day or two before the actual jury selection.
But you can look up people on Facebook and people on. Can you do that or no?
I'm not going to. What I don't want is I'm not suggesting what they can do.
Lawyers in Connecticut do that.
Okay. Because there was.
The judge can't comment on
Yeah.
that.
Once they have the list, I don't know what they're doing with it. I'm not.
So
go ahead.
Lawyers have been known to do that.
When I got the list, I would do a little bit of research from what I could, and now you have I don't know if it's Twitter or LinkedIn where they like quotes of certain things. So I have a little bit of a background, and then I see them in person in their own house. I get a little bit of better perspective as to who they are, I think, than, when they walk in for, 60 or 70 people in the courtroom. And I think, at least in New Jersey, that's going to stay. Rather than bringing in 100 people, pack them in real, like sardines, like a herd of cattle, especially with COVID, especially if we ever get a stronger strain that comes out. I think they're going to keep it that way. I don't see that changing.
Mm-hmm. On virtual jury selection, do you have any points you would add on that?
Well, I think I agree with that. I think subconsciously maybe a judge is reluctant to excuse a juror for cause if they've gotten in their car, drove 2 hours, parked, and come into the courtroom, as opposed to they turned on their computer in their living room. It's not that much of a insult to say thank you, we'll go to someone else if they haven't made that kind of commitment. And like I said earlier, I feel jurors are more open, more relaxed, and you learn more. It's a little bit harder to get them talking to each other, which we like to do in voir dire. But I think as people got more comfortable with Zoom, you can get them talking to each other as well and having a conversation. So I do think Zoom voir dire may be an element of things in the future, even after the pandemic.
Just sort of stepping back in terms of process on the Zoom voir dire process, if you could sort of walk us a little bit through how you all went through that in terms of you had everyone there, I swore them in. I mean, I went through a voir dire process, which I did by Zoom, just sort of what I'll call the first half, which is determining which jurors needed to be eliminated for cause, and then we brought people in for the lawyers to exercise their peremptory challenges. But and when I did that voir dire Zoom selection, we had them all in together to swear them all in, and then we brought them up individually in order to sort of conduct a voir dire. So all the other jurors, while one juror was being questioned, they were all in individual breakout rooms. So how do you all do the voir dire there in Washington?
Especially in federal court, where, as you know, it's a smaller panel. I think we had like 25 or 22 jurors on the panel. It wasn't that hard to do them all at once. Some of these bigger trials in state court, we'll do it in stages, which takes longer. We bring in 30 at a time or 20 at a time. But one of the things the jurors commented on, who had been in traditional courtrooms, is how easy it is to do sidebars or to question one jury. The court staff can shovel everyone off in an instant, and you can talk to one juror at a time and bring them all back, or you can get rid of all of them and have a sidebar. Bring them all back. And if the court has to say, it's going to be an extra 30 minutes, they're in their home and they can do their laundry or whatever they want to do instead of sitting in the jury room. So the jurors are much happier and more relaxed in a remote trial, in my experience, which I think the judges appreciate because they're always so conscious of using the jurors' time.
So when you were doing, so I'm clear, so when you're doing the voir dire in federal court in Washington, so you'd have, say, all 30 of them, they'd all be on the screen at one time while questions are being asked, correct?
Yeah.
Okay.
That's right. It was less than 30, but it was 25, let's say. because we were looking for 8. And yeah, we could see them all and we questioned them all together. And if there was a need, I don't remember if there was or not, but if there was a need for individual voir dire, it would have been very easy to do.
And then after you did the questioning for that set of 25, you then excuse folks, and then might excuse some people for cause, and then went on to peremptory. Just sort of walk through a little bit how that process.
Right. What we would do is, I mean, that's all we needed in that trial, but in some of these state court trials where we need a panel, we need 12 jurors, and we go through a lot more for hardship and things like that for longer trials. We'll do one panel at a time, which is similar to what we do in person. We'll bring in 30 or 40 jurors in the courtroom, and if we need more, we'll get rid, go through those, bring in another panel, and then we combine the who's left, and that's our jury.
Mm-hmm. Thank you. Attorney DeFranco, talk to me about walk through the voir dire process, make sure I understand. They're in New Jersey.
So there's essentially 25 questions, but there's a set of initially where the judge will ask, do you have an extreme hardship, right? Or do you have a disability that you can't come in, or some questions. And everybody's got a job, which is an extreme hardship. But what I thought was really good is when they had that, or there was a question like, have you ever been sued before? The judge would bring them the sidebar in the room, and it would just be the attorneys, the judge, and the person. And these jurors, especially when you're in person, have these wild stories, or I think everybody who files a lawsuit is just greedy. One lady said, I'm really reluctant because if the case is 6 years old, it's probably because the plaintiff won't settle. Right, assuming that this isn't an OPA, and by the way, it was they offered me nothing on it. So I think from a tainting standpoint, there have been a couple times where jurors have said things in front of others where I'm like, oh my God, don't say this in front of the other jurors, because then they may, if they're leaning towards it, say, you know what, maybe I'm not alone in that thought, and really sway them. Another one, woman said that she was injured, never made a recovery. She was hit by a hit-and-run vehicle, and the judge says, well, did you have your own auto insurance? Why didn't you sue, the underinsured motorist coverage? She says, well, I didn't know you could do that. How long's it been? 4 years. She's like, you have insurance, you should get a lawyer. And you know what my defense counsel did? We need a new jury. The whole jury's tainted because they heard the word insurance. You don't have that when you're picking them virtually in that setting. And there was a lot of times where I was like, thank God no one else is hearing this.
And when you were picking them virtually, were they individually? So they were, or
everybody's together. Did anybody raise their hand to questions 3? Yep. Okay, let me see the first one at sidebar. Because let me see what your hardship is. Or, have you been sued before? Have you sued anybody else before? Okay, let me see it sidebar. Because it's just a couple clicks by the clerk, and not everybody's hearing that stuff. And I was relieved a lot of times when I heard that. So that was a good thing that I thought about virtually. I mean, have you been on there where a juror says something outlandish and everyone listens or laughs or snickers, right? Where I'm afraid they're going to influence the rest of them.
Mm-hmm. Well, so I think there was, Attorney Crump mentioned the notion of that virtual trials are going to be the future. So I guess I'd be interested in what both of you think about, A, what the future is, and perhaps what the future should be. I'll start with you, Attorney Friedman.
One of the problems with virtual trials is sometimes it's a little hard to hear, but I think you asked what the...
Sorry, that's my fault. I wouldn't speak into... See, there you go. I didn't speak into the microphone. That's part of the future. Judges not speaking into microphones properly. The question was, what do you think the future is going to be with virtual trials, and what you think the future should be with respect to virtual trials?
Yeah. I think there are cases where a virtual trial would make sense even absent the pandemic, either for logistical reasons or financial reasons. And my guess is it's not going to happen unless both parties stipulate to it when the pandemic is over. I think there's a default to being back in the courtroom, and certainly we all like to be in the courtroom and miss it. But what I hope will happen as a result of this pandemic and remote trial is the judges will be more open to calling witnesses remotely. Jurors will be more acceptance of seeing Zoom witnesses in the courtroom. And it will be a tremendous cost savings for both parties. And that should happen, and I think it will. And, even I did a trial in person in the Eastern District of Washington this summer, and we were in person, and it was traditional, but everything was electronic. People are not handling photographs anymore in my trials. Everything's projected. Everything's done by computers. So that part's here to stay, I think. And then I think we're going to maybe incorporate voir dire more remotely, because it is a big ask to bring people in to pick a jury when you only need 12 or 14. So let's do that so they can stay home and save their time and efforts. And the experience, I think, has been uniformly good, that we get good quality voir dire. So I think we'll be back in the courtroom when we can. I certainly prefer it to wearing masks and having communication problems and not seeing the jurors. And I personally, it's more comfortable to do a trial from my office. I don't have to lug all the boxes in through security every morning and waste that time. And when the trial's over, I can get right back to work. But I think on average, we'd rather be in the courtroom than not. So I think that's where we're heading. But the cases where, two Seattle lawyers trying a case in Spokane, maybe they'll just stipulate that the judge and jury will be in remotely in Spokane and we'll be in our offices. I can see that happening.
Great, thank you. Attorney DeFranco?
One thing that was concerning to me is I had the second one that we tried was for a special needs woman with a life care plan, and I didn't want a jury deciding that case virtually. And thank God I was with the right presiding judge in Essex County, because he had, we wrote to him about the case, and he let us move our case with a priority when it was right when people started coming back. We didn't want to try that case virtually because, one, there's too much riding on it. Two, we don't know at that point how things are going to happen. What I didn't like was another vicinage saying, well, there's no directive, so when you're ready, you're just going to have to do it. I think the lawyers should have the option to stipulate or not, because I think it depends on the case. I was concerned in some of my and other vicinages, they're going to say, okay, you got to go and do it virtual. And that one where the woman fractured her hip, had a life care plan, it was not the right case to do virtual. So I think it depends on the case. I'd hope the courts would give the lawyers the opportunity to discuss it and see whether that works, and they'll stipulate to both of them. Because when you tell us, no, you don't have a choice from our end, that's where it could lead to an unjust result, in my opinion. So that was always a concern during the pandemic, is am I going to get sent out against my will? I think New Jersey's going to stick with the voir dire on Zoom. I think they're getting better at it the more that we do it. My concern is that the defense bar, they start seeing that it doesn't work in their favor, and they're going to start saying they don't want it, or the social science is going to come out to the defense side, and they're going to say, well, we want it all live again because this isn't in our favor, where I think originally all the defense attorneys thought this was going to be the best thing for them. And I think it's kind of been, it hasn't been all defense verdicts. It hasn't been pro with the defense. So I think the virtual jury selection is going to stay here.
Great. Now, in terms of, one of the things that I'm always concerned about, and about anytime we do something virtual, anytime we're sort of reducing the amount of human contact, is whether or not it sort of furthers us becoming more distant as a society. Is this another way where technology keeps us apart when we ordinarily would be together? The bonding process you have about people coming in for the trial, there's convenience of being from home, but there is the sense of community. Community is both a challenge. It's like Thanksgiving. People are going to come in for Thanksgiving, and you sort of deal with it. But there is a magic that happens with that. Is there a loss that we should worry about in terms of the impact on community of the prospect of virtual trials likely being part of the future of the administration of justice in the future? I'll start with you, Attorney Freeman.
I think we need to be aware of that. It was interesting hearing the research that Professor Hans did, and the virtual jurors felt like they were bonding better than in person. I think some people do bond better in person, and some people probably bond better over Zoom. So I think we got to be aware of it, like we decided in Washington to try to get them in breakout rooms during breaks and get to know each other before they start deliberating. What they're doing a lot now in our Seattle courts, and I don't know what the rationale was, is they're bringing the jury into the courtroom for opening statements, closing statements, and then deliberations. And the rest of the trial, voir dire and all the witnesses, is done remotely. I don't know why they're doing that, because I don't think it serves the COVID interest, but I think it might be part of what Your Honor is talking about as let's get these people together and in the same room and bonding as a community.
I think it's significantly affected the way the attorneys are to each other in New Jersey, which is probably not great to start with. We're kind of rough on each other. And then, I could say in the last couple of weeks, I've had people, not give me courtesies or come after me, a little different than if I had met with them in person. I had worked, I'm a big proponent of, if you get into an ego battle with your adversary, it's going to make the case a lot harder, and you're probably going to get less money. So when you're just talking over a phone or on Zoom, you don't get that opportunity to talk to them like you were in the courtroom at a trial call and see that, you can be humble with them and not get into that ego battle. So I think I've lost that. Like, I've lost that opportunity to go to the defense and, show them that, I don't have this huge ego and they don't have to try to crush my ego to show that they beat me. I don't have that opportunity to do that anymore, But at the same time, the people that I knew before that I see and talk to, oh my God, how are you doing? It's even more of a relationship than before. A guy got laid off from Geico 2 weeks ago. I called him last night. How you doing? Right? And he was just so appreciative that I had called him, reached out to him. If I had only known that guy over video, I would have no relationship with him. I think we're all gonna miss that. But we're doing depositions 95% of the time over Zoom now. So and then arbitrations. You guys have mandatory arbitration in Connecticut. At the end of every civil case, we have to go into the court and have it heard by an arbitrator and give a number. We used to go and sit down at the courthouse for 4 hours waiting for an arbitrator, where you'd sit and you'd talk with each other. And at the same time, you sit there, lose 2/3 of the day doing it. But now we don't see each other at all. So I agree with you. It takes that away from us.
Mm-hmm. So
the upside might be, though, and this is a theory we have, and maybe someone will study it, but the strong personalities that sometimes take over deliberations in the jury room are less likely to be intimidating or pressuring over Zoom. So if you've got a juror who's trying to push the other jurors in one direction or the other, I think they got a harder job to do it. And I think that's good. I think that all the jurors speak their mind and have a voice. So in our experience, deliberations take longer, sometimes days longer than we expect, but the unscientific results that we're seeing is the verdicts have been very favorable for plaintiffs. And that might be unrelated to the remoteness. It might be something else about COVID and people's mood in the country right now. But in this area, the plaintiff verdicts seem to be much more favorable in the last 2 years.
All right. Is it all right? Should I open up the questions now? I know you're going to.
Before we do that, can I ask?
Yes, please go ahead.
Judge, for your perspective.
Sure.
Because I know we spoke a little bit about this, and so I'd really like to. I think we'd all be interested in your perspective from the bench about the virtual trials, virtual court appearances, that kind of thing.
I think, I think as this panel has reflected, and I think that this day has reflected, there are clearly both benefits and detriments. But I think we also have to deal with the reality that some aspect of virtual proceedings is going to be with us. The real question is, what form is it going to take? Are there times when it's appropriate? Are there times when it's clearly inappropriate? I mean, my preference, certainly for trials, is to have them in person. I mean, I've worked very hard to try to have trials in person. I just finished my 10th trial since, I guess, with March of 2020 in terms of the COVID outbreak. I worked very hard to end up having what ended up being the first jury trial in Connecticut in person, working on a partial virtual voir dire process, and trying to figure out how we can have the courtroom set up in a way that people can have the trials. Because I do think that there is this value of bringing people together. I do think the magic of community that's created by the process of people coming in, and it's not as if virtual trials change that, but I think that there is something extraordinary about the fact that we, for very important matters in this country, we bring people into a courtroom who don't know each other, and we ask them to sit together on a jury on a matter they're not generally familiar with or don't have such a familiarity that they've developed some strong opinion so that they can weigh in on it. And then we ask them at the end of hearing all the evidence and being instructed on the law, we ask them, can you come together at this time when people talk a lot about how polarized the nation is? We ask them to come together and agree unanimously. There's no filibuster rule. There's no dissenting opinions. If we have dissenting opinions, we don't have a verdict. They've got to come together and agree unanimously. So what my most paramount concern is those aspects. I think Professor Hans talked about it as the civic participation. Those aspects of civic participation, and I think that even Professor Hartwig's research suggests that this civic participation in jurors leads to other participation in other ways. Are we at a time when we most need people to figure out how to come together, resolve difficult issues? Are we doing anything that impacts the jury trial process, which brings people together and has them decide important things on a unanimous basis, something we don't require in so many other aspects in society? So I think that's what my paramount interest is making sure that those important dimensions that were elements of the Constitution, both in the civil and criminal side, on the criminal side through the Fifth and Sixth Amendments, and the civil side through the Seventh Amendment, those critical aspects of who we are as a nation, how is it being affected? And at the same time, because of the challenges that the pandemic created, it was a need to figure out ways to ensure justice. I think Attorney Crump's example of whether someone who's severely injured can wait that long. The same thing with criminal defendants. We have this speedy trial right. How long can we have people wait, particularly if we're having them wait in custody? Can we have them wait to have a fair trial? So figuring out means that we can provide justice is important, and the technology has allowed us to figure out how to simulate as much in the courtroom as we possibly can, but we have to be cognizant with the benefits coming, there will be detriments as well.
Questions for the panel, for the judge?
Yeah, go ahead.
Here, let me...
I think this is an easy one. What are does the client have a say in whether it's online or in person? So I'm thinking about the two attorneys in Spokane, Washington. What are those conversations they have with their client? I imagine, based on what you said, maybe it's fact dependent, but what does that go like?
Yeah, well, back in 2020 and 2021, it was an easy conversation. We could have a remote trial now, or we will be pushed off until the pandemic's over. So I didn't get any pushback. And now that we've done some remote trials, clients, I think they need to be part of the conversation, absolutely. But I haven't had any reluctance to. In fact, yesterday my client testified, and the judge asked her if she had any questions before he swore her in. And she said, I don't have any questions, but I want to thank you for letting us do this over Zoom because it's really easier for me. So for injured people, it makes a difference.
I think it'd be important. I mean, you say what the role of the client. In my mind, as a Jersey lawyer, I'm like, you think my client has a say in this? The court's going to tell me whether I'm going or not. But I think that if you want like a just result, they should be able to agree that I want my trial virtual, or I want now, or I want to wait and do it. Like they should have some say and some role in it. But that's like foreign to my, they tell me to go, I got to be ready. But I think they should have a role. It's a good point.
I have a quick question for both of you. Do you find that the trial moves quicker, more efficiently with virtual? And in what ways do you change your presentation style? Or
That's a great question. And yes, because anyone who's played video depositions and watched a jury fall asleep after an hour knows. When you put a video presentation on in front of a jury, it's got to be the highlights. It's got to be the most important thing, and you got to tailor it and shorten it as much as you can. And we have been doing that with our witnesses as well. I always try to do that in court, but over Zoom, I think we make an extended effort to hit the highlights and down. And the trials are shorter. It tends to start, right on time. The breaks go on time. We get a lot of information in. Like I mentioned earlier, sidebars are quick and easy. So I don't think it's a drastic difference, but I would say it's somewhat quicker and more efficient.
Yeah, I think it moves quicker. But the best thing I could say is the visual evidence is more powerful. So when you're in a courtroom, or used to get like a 36 by 48 blow up of an intersection, right? That's okay. When you're at Zoom watching it, hit exhibit, D. The whole screen is the exhibit. You can't ignore it, and it's everything you're looking at. Maybe you get a speaker and you hear them on the side, but whether it's an MRI or property damage or some type of an image, like that is even more powerful over a screen. And I think you get more focused than if you're in a courtroom and the sirens are going outside or the fans going on or whatnot, because they are zoned in on it for better or worse, right? Depending on what the image is. If the defense or the other side's using it against you, that's I think even stronger under the Zoom format than it would be in a courtroom.
Any questions for the panelists?
Yes.
Just to get us going here. All right. Unfortunately, I cannot cite a study or article to support the assertion I'm about to make, but I think I have heard this to be true, that there's evidence that...
we call that hearsay in my court, but that's okay.
Or just pure fantasy. But there is some thought that virtual interactions may blunt the force of certain forms of bias, particularly on the basis of race and perhaps on gender. That in virtual interactions, people, and that remote work has led to some higher job satisfaction, particularly among employees of color who feel more included in the workspace somehow and less subject to bias. I have no basis for knowing whether it's true or not, but I just wondered if any of the folks who have spoken so far today have thoughts about the impact of bias on the basis of various personal characteristics, including race, gender, and ethnicity, and whether we should be thinking about that as a factor in virtual justice.
I think we definitely should be thinking about that. I'm getting an echo though. I think it's on your end. Can you hear me now?
We can hear you without the echo.
Okay, great. I also don't know of any studies that say that, but I think it might dovetail into what we were talking about this morning with the separation, that people can't be as intimidating on the video screen as they can be in a jury room or in a courtroom, perhaps. You've got a little bit more, you're in your safe space. So I don't know if it makes the biased person behave better, but the person who's the subject of it might feel less impacted by it.
I don't like to hear the words work or remote in the same sentence anymore from having paralegals and staff. One thing that I'm doing blind here is when we had the jury trials, I'd love to know what they were doing. Like they're doing it in the mock juries. Like I'm kind of speculating as to how the dynamic worked. And that's, I think, the big unknown with that is how are they doing it virtually? And then, by the way, are they doing it in a satisfactory, acceptable way? Which, we just sit there and wait for the jury to come back on the virtual.
When you say acceptable, what do you think?
Are they bringing up, well, I don't want my insurance rates to go up more likely than not, more often than not in a virtual room than in person? I mean, that's one thing we don't want them to do when they're speaking among each other, or not listening to the judge's instructions, or, hey, I Googled a gun online last night, right? Are they more likely to do that in person, or are they more likely to do that online? That's the stuff, do you have more control or less control over that?
And because the access, meaning that you're sitting there in your living room next to a device that you can easily, as the witness is talking, sort of Google something as you might ordinarily do something. Yeah.
And I know they're told not to do it. They do it.
Mhm.
I mean, you can't say that it never happens.
And at least when they're live in court, at least while they're in the courtroom, there's some ability to observe and control any use of device or any ability to try to use something outside of the courtroom to influence the decision.
Yeah, and if it's virtual, you won't even know. The other jurors won't even know, because one of the instructions to the jurors is if somebody violates the law, I say, or doesn't follow it, it's your job to report to the judge. So there's a complete loss of control. I mean, I'd love to see those jury deliberations that Professor was doing,
Mhm.
to see the dynamic compared. I think that's important. Oh, you didn't hear me? Jersey guy again. All right, there we go.
Mhm.
Am I on? Yeah. Thank you. And I have obviously no proof for this other than just my own intuition. There's something about this.
So not only just hearsay, this is speculation. Too.
That's right,
Okay, all right.
exactly.
We're just having a little mini evidence class going on. Go ahead.
Exactly.
Sorry.
When jurors are virtual, it would seem to me there's much less of a psychological investment because there's not the same formality. And they're doing other things while they're going on. They're not entirely devoted to the task at hand. If they're at home, they could be having the dishwasher going. They could be throwing in a load of laundry. They can be doing other household chores unbeknownst to you, simultaneously, and even though they're listening, there's not the same investment from a psychological standpoint that this is their job. When you have a juror there for 8-10 hours a day and all they're doing is you and your case and your cause, there's obviously a much greater, I would think, psychological investment in the enterprise and in the significance of what they're doing. And when they're able to multitask, and really quite blatantly in some instances, but even if not, if they're able to multitask, is there a less of an investment in a psychological component? I'm repeating myself, but I wanted to make sure that my question at least made some sense, so thank you for your nod.
I think that was a concern we all had going in. One thing the courts do is they monitor visually every juror, so they have to be more than listening. Their faces have to be on screen. And not doing laundry. We've had one or two out of dozens of jurors over the last year not be able to follow instructions and have been dismissed, but that happens in the courtroom as well. As far as their investment, the psychological buy-in versus being in home instead of a solemn courtroom, we haven't seen it. It's a concern, but we've done 8-week trials on toxic chemical exposure to school children with thousands of exhibits and dozens of experts. And boy, they sure seem to be paying attention and asking. I guess that's the other point. The questions we get from remote jurors are more intelligent and more detailed and indicative that they are, in fact, paying attention to a degree nobody expected.
Let me just follow up on that one point, because it sounds like, is your jurisdiction one where jurors are allowed to sort of submit questions while the trial's going on? Is that that's what you're, okay.
In state court, our federal courts are probably like yours where they don't, but in state court, they're allowed to ask questions, and we get a lot of questions, and from remote jurors, they're better questions.
This room has had the experience, whether you're judge or lawyer, you walk into a courtroom and the dignity and the significance of that courtroom, I think, speaks volumes, and you really immediately understand what you're doing and why you're there. And in the absence of that, I was concerned, but your answer has given me some solace. Thank you.
I can break that down into 3 things. when you walk in a courtroom, there's something about it. There's like, this case is important. You lose that virtually. I don't think you have the emotional investment as well, which is what the studies are finding. They're not as emotionally involved. But Ken, I think people were paying attention in the cases that I've had, surprisingly so. Like I didn't see anybody walk up and leave or blink. I've seen more in the courtroom where somebody kind of dozes off in the mid-afternoon after lunch. I didn't see that virtually, and I was surprised as well, which is why I mentioned it earlier. I guess you found the same thing.
Yeah, and I think everyone's been worried about that, and I haven't seen it. I see them paying attention. It was interesting in that first trial we did, the judge was in his home, and the first day he didn't have any kind of official backdrop. And the second day he had a backdrop behind him of a bookcase or something. And the juror commented afterwards saying, Your Honor, no disrespect, but it didn't seem to have the right formality when you're sitting in your living room. So I think it matters. I think in every case now, even in remote trials, the judge is on the bench, it's in a courtroom. So even if the rest of us are in other locations, we're trying to, as much as we can, indicate that it's still a very important. And we do it in opening, we do it in closing. We try to remind them how important it is, and the judges do that well as well. So I think it is a concern. I think it is a potential issue, but thankfully we haven't seen it become a real issue yet.
We were talking about this at lunch. We had the panelists are three plaintiffs' lawyers. Put a defense hat on. Would you agree to virtual trials if you were a defense lawyer?
I'll tell you, they much more routinely object to it. They file motions. I don't know if that's because they want it delayed or because they really think it's not fair to the defendant for some reason. It's not universal. I've had cases where they do agree to it, but they tend to resist it, and I'm not sure why. And I don't see a prejudice to one party or the other from the process, but the defense bar, at least out here, 75% of the time would object to it, and the courts are overruling their objections in most cases. They, for example, these 8-week PCB trials, they really didn't want to go remote, and the judge forced them to.
Yeah, the initial reaction from the defense was like, oh, this is going to be great. Now they have no shot of winning, because a lot of auto cases where we have the verbal threshold, 90% of the time the defense wins in 95. Now they think it works to their advantage. I think the insurance companies, from a financial standpoint, in New Jersey, aren't going to really be opposed to it, in the future, because it's so much cheaper just to have their doctors come on video and whatnot. I think the initial reaction, if I was a defense attorney, was, heck yeah, I'll do it that way. How is the plaintiff's lawyer going to sway them? But I think as we've learned now, it may not necessarily be the case. They're harsher on the defense witnesses as well, and I guess skeptical of the defense witnesses. That's what I can take out of it. They're really skeptical of the defense doctor. They're skeptical of the defense liability expert, as Mr. Crump said, and I think that may be working towards the plaintiff's favor, is the skepticism.
This is a question for Ken. Just following up on your last point, what's the nature or substance of the objections that are being made by defense counsel? And do they cite any practice book rules in Washington?
Yeah, they cite the state constitution. They cite prejudice. It's unfair. It's too complicated. Won't be a fair cross section of the community, which is valid. Certainly, the courts have gone out of their way to try to make sure that it is. So none of their objections seem to be that they'd be biased, but just the cases are, it's never the right case. It's a legal malpractice or it's a toxic tort. It's too complicated. So those kind of objections are made, and the courts just have said, I think we can handle it, and they do.
I think this is an easy one, but if I heard correctly, one of the fears was that there would the jurors would drop out, something would happen, technical difficulties. Why can't you have alternate jurors virtually?
I heard everything but the question.
Oh, why aren't you able to have alternate jurors?
Oh, we do. We do. And we sometimes jurors we'll lose them just for technical reasons, and that's why people are watching all 12 faces on the Zoom screen. What they stop the proceedings, they get the juror back, and we start again. But that's pretty rare. I mean, it probably happens at least once each trial, but it's a 5 or 10 minute glitch. As far as losing jurors, we've lost them for a variety of reasons, just like you would in an in-person trial, but we do have alternates. So there's no real difference there.
In New Jersey as well?
Yeah, same. And we had the trial where we had 8 in the box, and one guy who we didn't like the next morning said, I'm not feeling good. I took 2 COVID tests. It's maybe negative, but in an abundance of caution. So before we even opened, we were down to 7. We actually were happy about that because it was one juror that we didn't like the most. But yeah, we have alternates as well. But I think that happens. It could happen both live and regular.
And to be clear, it was coincidental that the one jury didn't like the most ended up sick, correct?
In follow-up of Judge Katz's question with respect to whether jurors are paying attention, is there somebody in the court house, is it a clerical staff, apart from your own staff, that is dedicated to monitoring the jurors, making sure they're not looking offline, or that they have any potential internet problems? How is that handled?
I don't think the court clerks in New Jersey are monitoring that. They're off doing other things with it. But in some of the screens I've had, I think you see them in like 2 rows or whatnot. And whenever I look back, I don't see anybody doing anything else. I've seen them pretty much lean forward watching. From what I've seen, I mean, it's hard to put your attention in too many different places when you're trying a case. But every time I've gone to watch, they've kind of been, sitting there looking at the screen. But yeah, I couldn't trust the court clerks to keep their eye on them in Jersey.
Mm-hmm. Ken?
I think I heard the question. What they do here is they'll rename the screen names where now you can hopefully see my name. It'll be juror 1, juror 2, juror 3, and they'll put them in order. And if someone disappears, it's pretty obvious to everybody. They do have, especially in federal court, we had a really good IT staff assisting the in-court staff on making sure it ran smoothly. But the state court in the counties where they're doing it here are also pretty good at monitoring the jurors.
Any other questions? Yeah.
Sure. Is there software that's installed onto the computers to shut down jurors from surfing, looking elsewhere on the web? I'm talking now as a law professor. This is what we do now when we test students on ground, and it just occurred to me: do you all use software like that or no?
I don't have. We had nothing like that.
No, they're ordered not to do that. We did have a juror who was writing the whole time, and the defense asked that she be excused because she was obviously not paying attention, and we said, well, maybe she's just doodling. So the judge brought her in and said, "What are you doing?" And she held up her doodles. Well, she was listening. People are watching, and when they're not in court, it's the same fear that they're going on the internet, but they're ordered not to, and we assume they're following orders.
Any other questions? Any closing thoughts? Fellas?
Does anybody have any virtual trials coming up, like that they have scheduled, or even a hybrid in Connecticut here?
I didn't hear the question.
I was asking if anybody here has any trials coming up that they have scheduled or something like that. But I don't think anybody seems to. You do? And what type of case is it?
It's actually a PJR hearing, so it's kind of a mini trial.
I don't know what
It's a prejudgment remedy.
Okay, so it's not a jury trial?
It's not a jury trial. It'll be before the bench, but it'll have live witness testimony.
Okay.
Virtually, and which is a concern for me. I don't,
I don't know, I think judges, are able to separate it out, right?
I like live witnesses. I like everything live. So, but that's just me. So. I mean, be clear, they're live. They're just not in the courtroom.
Yeah.
I don't like dead witnesses either. So
I'd recommend making it as easy as possible on the judge with whatever you have. Like if you have exhibits, I'd get them over in hard copy as well as if you're going to put them on paper. Make it the easiest pie for the judge from your perspective. You know.
I'm sorry. It varies. Some courts want to be all electronic, and some courts want paper copies, and we do what they ask. It is logistically sometimes difficult dealing with exhibits, and especially impeachment exhibits that have not been exchanged. We tend to have a Dropbox open with the defense, and we just drop things in there and say, this is, the next exhibit we're going to use on your witness. And so they have just like if we handed it to them in court. That seems to be the best way to do it then, because there's no way in Zoom to show a document to everybody but the jury.
Yeah.
Okay, well, thank you, panel. Thank you, Ken. Thank you, Peter. Thank you, Judge. We appreciate it. Yeah.
Thank you.
Good afternoon. I am Charlie Pillsbury, a professor here. In fact, they call me, some of us who we can attend faculty meetings, but we can't vote because we're just distinguished practitioners and residents. And my field happens to be dispute resolution. We have about a half dozen of us who actually bring a lot of experience. And so it's just a delight to co-direct the Center on Dispute Resolution. I love the way Dean Brown described it this morning. It's the Center on Dispute Resolution, although we now have a mediation clinic, so there's, it may grow. But that said, if you're sticking around for the afternoon, I think, if you need even more CEUs than are allowed, just let me know and I'll put in a good word. Instead of 6 hours, we'll get you 9 hours, but I think you're in for a treat. We're going to look at first, and I want to thank Judge Noble, who's had a real hand in shaping the afternoon. It's been a pleasure working with His Honor, and he'll be introducing Professor Aguiar, and who's going to begin with an overview of AI, artificial intelligence, because there are forms of online dispute resolution that use AI and other forms that don't. And you'll hear more about that when Professor Schmitz from Ohio State, I'll be introducing her. She's going to be coming in via Zoom, and she asked me if it was okay for her students to attend. She's teaching a class on ODR right now, and so she's having her students Zoom in with her. And then after she gives kind of that overview of how AI and ODR link and how they affect access to justice, we have two wonderful panels, one looking at how ADR is used outside the state of Connecticut, and we already actually have one of those panelists here in person, so Stephanie Parker, who it turns out is also a graduate of Quinnipiac, and what's unusual about that is she didn't start at Quinnipiac, she started at the University of Bridgeport, but then she graduated from Quinnipiac, so she was part of that transition. And then at the end of the day, Judge Noble will be moderating a panel that will look at what's going on within the judicial branch here. And so we'll get to that. But right now I want to introduce Judge Noble, and it's my pleasure. Anybody who can handle the complex litigation docket can handle AI and ODR. So he's
not a chance. It's my pleasure to introduce Derek Aguiar, who is an assistant professor in the Computer Science and Engineering Department at the University of Connecticut. He graduated from the University of Rhode Island with a BS in Computer Engineering and Computer Science. He received his PhD at Brown University and completed his postdoc work at Princeton University with Professor Barbara Engelhardt. And I don't want to leave out Professor Soren Istrel, who was his advisor for his PhD. His research aims to develop probabilistic machine learning models, combinatorial
That's a tough one. Yeah.
algorithms, and scalable inference methods to better understand high-dimensional data, particularly genomics and genetics data applied to complex disease. How many of you had your eyes glaze over?
I'm sorry.
That last sentence. There will be a test. It's on the back page that you have, and it's pass-fail, so you're good. The goal was to give us some idea of how AI works so that when we hear from our next speaker how AI interacts with ODR, online dispute resolution, and alternative dispute resolution, we have some background. And I am very grateful that he took the time, that Professor Aguiar took the time to help us. So thank you so much.
Thank you. Yeah, so actually, His Honor Cesar knows all the materials, so he'll be grading the tests. Yeah, well, thank you so much for inviting me. It's a pleasure. I was saying before, I've done this tutorial a few times. It's been anywhere from 2 to 4 hours, so tried to condense it down to 25 minutes. Let's see how far we can get. So before we talk about machine learning and artificial intelligence, I just want to contrast it with algorithms, which is sort of the foundation of computer science and what was really pervasive before ML and AI. And so what is an algorithm? You can think about an algorithm as just a series of instructions to accomplish some task. And this is a very simple algorithm about how to get to work. So if you're within walking distance, then you can walk. If not, then you have to take public transportation, and then there's sort of a decision structure that you go through to get to work. But what's important here is we're explicitly telling the computer what to do. Okay? We're giving it instructions, and then the computer is executing our instructions. Okay, probably not the best example given this audience, but you're robbing a museum. And there's a lot of items in the museum. There's really large items like dinosaur skeletons, and there's small items like diamonds, right? And so you have a backpack with your knapsack, and it has a certain capacity. Every item has a value, and it has a weight. And the goal is try to take as much value as you possibly can. It's called a knapsack problem in computer science. It's a very traditional problem. And so you can actually solve this with an algorithm, okay? Your goal is to try to select items. Which items do you want to take? Well, all you do is you sort the items in descending order by their value over their weight, and then you grab the items until your bags are full, until your bag is full. Okay, so this is something we call a greedy algorithm because you're making greedy decisions at every step. You take the item that's worth the most based on its weight. Slightly harder algorithmic problem would be, say you have a map of the courthouses in Connecticut and distances between them, and you want to try to traverse all of the courthouses such that you visit every courthouse exactly once, and the total distance is minimum. This is another algorithmic problem. The difference here is there's no really good algorithm that solves this exactly, okay? So we have to do approximate things to solve this particular algorithmic problem. Now, we haven't talked about machine learning and artificial intelligence yet, but almost all problems in artificial intelligence and machine learning are of this type. We can't solve them exactly, so we approximate. That's the first sort of caveat, okay? So whenever anybody says we fit a model, there's no the best model. There's just an approximate model that they're trying to fit. And I'll get to exactly what a model is. By the way, if there are any questions about understanding of this talk, please raise your hand and just shout, and I'll repeat them. I don't mind being interrupted. Okay, so what kind of problem is this? You're given a complaint document for some civil case, and maybe you also have court administrative data, so where it was filed, the judge, the practicing attorneys, and you want to try to predict whether or not a motion to strike would be successful. So there's just two outcomes. It's either granted or denied. What's the algorithm to solve this problem? It's not very clear. I can't define a series of steps that will get me to the outcome. Similarly, if you're if you have a criminal case, and I work with a law professor, and he reminds me often of how terrible my terminology is with respect to law, so please give me some leeway. So maybe you have some demographic information, maybe you have the location of where the alleged crime was committed, a bundle of charges, and you want to try to compute, I think in Connecticut it's maximum, minimum, and supervised release time, so it's sort of like these three outcomes, okay, based on the facts of the case. So this, I also don't know what the algorithm is to solve this, or to compute these outputs. So these two problems are learning problems. And basically, learning problems are when the steps to solve a computational task, or just a task in general, are too complicated to write down for the computer to execute. It's really difficult to describe how all of these different features interact to produce the outcome. So machine learning and artificial intelligence allows us to answer questions like these, maybe not sufficiently, but answer questions like these by learning from examples. Okay, this is very different. Algorithmic, we have steps, and you give it some data, and then it will carry out those steps and give you a solution. Here, we just have a model, a mathematical model, which is a set of assumptions, and then we're going to give it some data, and it's going to configure itself to learn to predict new outcomes. So a completely different paradigm. Okay, I'm gonna skip that for now, for time reasons. So let's think about human intelligence, and think about how we learn things. So if we never saw a cheetah before, or we didn't know what a cheetah was, how could we learn about a cheetah? Well, you could have your friend describe what a cheetah was, maybe its characteristics, what it looks like, what kind of actions it takes. But we as humans actually would learn quicker if we just saw an example of a cheetah. So a picture, or maybe a video of a cheetah being a cheetah in the savannah. So humans learn by seeing examples. So can we take this process of showing examples and learning from those examples and giving that ability to a computer? Don't worry, I mean, this is going to seem like magic and that computers are going to solve all problems, but I'm going to have a sufficient number of caveats, I hope, to make you very skeptical of any machine learning or artificial intelligence method. So artificial intelligence is roughly, it's actually very old in computer science, and it was roughly trying to create computational systems that mimic human intelligence, or if you want to think more abstractly, just intelligence in general. And so this was really born out of robotics. And the early systems were based on logic, and so you have maybe a logic decision diagram, and you follow some logic and you arrive at the decision. Now, humans don't just operate on logic, right? We can't use logical deduction to come to all of our conclusions. And so later models were based on probability. You may have seen Bayes nets. I think some Bayes nets have been attempted to be brought in trial. Whether or not they were considered or thrown out, I'm not sure. But then you factor in probability and probabilistic estimates. Okay? And nowadays, artificial intelligence is pretty synonymous with deep learning. You may have heard of this term. Deep learning are machine learning artificial intelligence models that try to explicitly model the human brain. So it's a bunch of neuron-like things that pass information to other neuron-like things. So it's literally trying to mimic what's going on in the brain. Machine learning is typically thought of as a subset of artificial intelligence. So you can just think about machine learning as just teaching computers how to learn from examples or learn from data. Okay, and ML and AI has been in the news, and I think this is partially why I was invited to come here. It's going to be in courtrooms soon, if it's not already in your courtrooms. Here's an example of where you can just take a still image of something, and this is the Mona Lisa, and you can render video from that still image. Okay, this is actually quite old. It's like 5 years old or so. So you can do much better nowadays because the field just moves so rapidly. So maybe you can start thinking about the implications of someone who brings video evidence into a courtroom. Here's another example. This video is faked. This is just rendered video. And you can take an audio stream and you can match the video to the audio. So the mannerisms and the lips move like it's as if they're speaking the audio. So the audio here is real, but the video is fake. But you can imagine easily having an impersonator produce audio or having a model that produces audio that sounds like somebody. Then you can render the video. Again, this is maybe 4 years old or so, so it's much, the technology is much better than this. If you've seen deep fakes, it's kind of scary. Here's an example from this year. These methods are really cool, and you probably saw these maybe on social media or the news, where you provide the AI with a text-based description, and it generates an image of that text. And they're photorealistic, okay? They work really, really well. So on the left, this is an angry duck doing heavy weightlifting at the gym. I don't know, that looks like a duck at the gym. And the right, a photo of a confused grizzly bear in calculus class. No, this is, and they're not cherry-picked. Photos are really this good. Okay, so you can imagine, these are silly examples, but you can imagine where this could be used for potentially misleading or nefarious purposes. Okay, so it can do a lot, but what is machine learning? How do we characterize the different types of machine learning models? This is a taxonomy. We're really going to just talk about 4. It breaks down to supervised learning, unsupervised learning, and we'll very, very briefly talk about reinforcement learning. Okay, supervised learning. Supervised learning is a type of machine learning where the model is given data entries and labels. Okay, so you have pairs. You have pairs of data and you have pairs of outputs. Okay, and some examples of this is, say, classifying an image of an animal. Or you have, one of the earliest problems for machine learning was you have emails, some of them are spam, some of them are not spam, and you want to try to classify new emails are spam or not spam. Spam email is as old as the internet, as old as email, or predicting future weather. So all of these are related by having some data that you want to map to some outcome. Okay, so we say that the data are already labeled. A canonical example of this is US postal digits, actually. This is one of the very early data sets. So you have a bunch of examples of postal digits, and then somebody hand-labeled them. So some poor, unfortunate soul went through thousands of these examples and hand-labeled them. And then you're given a new postal digit, and you want to try to label, what number is this? Okay, so you have a lot of data and labels, and then you just are given some data, and you need to make predictions. So there are 2 primary tasks in supervised learning. The first is classification. And so this is when you have some input data. So you have X, and you have the label, but the label here is discrete. So it's going to be one of many things. Some law-related examples of this would be predicting whether or not the Supreme Court will actually hear a case. So that's discrete. They either do or they don't. Or predicting the outcome of a motion. This is something that we already talked about. Regression, on the other hand, is where it's the same thing. You have labeled data, but now the labels are continuous. So that's the only difference. And some examples of this would be, say, predicting the maximum jail time of a sentence, given facts of the case, or predicting how many crimes will be committed in an area next year. This is actually very relevant to some machine learning models that police departments use to prioritize police resources, which we'll talk about a little bit later. Okay, so machine learning is about building models. So we just talked about 2 very large class of models. There's either classification models or regression models. The models themselves capture assumptions about the data. Okay, they're a mathematical model. There's many different types of classification models that you can develop. And if somebody brings some model to you and says, hey, look, this does something interesting for your court or for your legal practice, it's based off of some fundamental assumptions. And those are actually really hard to figure out unless you kind of work in the area. You may have heard of something like linear regression. So linear regression is just like drawing a line. You have an X and a Y, and you're just drawing a line. That makes very simple assumptions. It assumes that Y is a linear function of, this coefficient times X. Okay? Then you can have really, really complicated models as well. So all of these models make assumptions. And basically what you're doing is you're configuring this model. It has some parameters. You're configuring it to predict Y from X. That's supervised learning in a nutshell. By contrast, so the next major area is unsupervised learning. So unsupervised learning, we actually don't have any labels. All we have are the X. So we just have data. Typically, this is associated with clustering, so grouping data items that are similar to each other. But you can also think about this as finding anomalies. So say you're doing an audit of a courthouse and you want to find maybe anomalous plea bargains or something like this. Or grouping similar criminal statutes. Or finding groups of similar civil court cases based on their complaint documents. There's no output here. We just have, in the first case, complaint documents or criminal statutes or plea bargainings, and we're trying to find groupings that are similar. Okay, so in supervised learning we have labels, and unsupervised we don't. In supervised learning we have an idea of what the right answer is, and unsupervised we don't. We group things and then we interpret those clusters or those groups or those anomalies. Okay, here's a little, actually the quiz is happening right now, it's not after class. So here is an example. So we're given historical Supreme Court decisions and data about the cases. And we want to compute the outcome of a current case. Okay, so is this supervised or unsupervised? I don't know how this works here. You can yell at me the answer if you think you know. But this is supervised. Okay? This was work done in 2017 where they were trying to model the Supreme Court and how they would predict. And you can see this is the classification accuracy, so how accurate the model was at estimating the Supreme Court's predictions from 1816. Wow, the data goes back far to 2016. This is kind of interesting. I don't know, I can't really interpret this, but around the 30s to 50s, I guess the Supreme Court was less predictable. Maybe there was less data. I don't know. Okay. Quiz question number 2. You have behavioral and psychological constructs from incarcerated peoples. So think about these as like survey responses or maybe some forms of tests. And you also have a count of post-release violent offenses. Here, now, you're given some information, so behavioral and psychological constructs for a new individual, and you want to estimate their risk of becoming a recidivist. Is this supervised or unsupervised? Supervised. Thank you, Cesar. Supervised. See? My TA knows what he's talking about. So yes, and actually this is modeled after that Compass example that you might be aware of. Compass? No? So this was a company that released this software that was able to accurately estimate whether or not somebody was going to become a recidivist. Someone was going to commit a crime after being released on bail. Then ProPublica had this study, I forget when this was, late 2010s, where they showed that the system was pretty racist. It ended up giving Caucasians lower risk scores, where the results didn't necessarily warrant that. So that's foreshadowing what's coming later. Yeah, and I'll just go through this quick. Data and statistics about courts and their caseloads. You want to group courts with similar caseloads. This would be unsupervised. Okay, I'm going to briefly touch on this because I think this is less relevant to this crowd. But there is a large area of machine learning that's based on human psychology. And it's about training models that can make decisions on their own. Okay, so it learns just how humans learn, trial and error. A little bit worse than humans. But say you don't know what a stove is, and so you put your hand on a hot burner, and you realize, this is not something I want to do again. So this is a penalty. So you don't want to do that again. You don't want to take that action. But say there's a button you can press to get some candy. That's a button you might want to press over and over again. That's a positive reward. And that's what reinforcement learning is. It's learning from, you take an action, the environment gives you a reward or a penalty, and then you update your action when you're going to take an action. It can be used for playing video games. This is Super Mario. I think the model is called Mar.io, pretty clever. Or it's also the only real example I could find, I didn't look too hard, but modeling deceptive behavior in courts. So you actually train a model to try to deceive. Maybe this is useful for training students or something. Okay, more test. So which one, supervised, unsupervised, or reinforcement learning is each one of these? Grouping cases based on their characteristics. Unsupervised. Oh, awesome, great. Predicting a judge's decision. Supervised. Finding the best move in a game of chess. Reinforcement learning. Yeah, very good. This is a tricky one. Predicting the best next move of a self-driving car based on visual information. Yeah, this is tricky. You're tempted to say reinforcement learning, right, because you want to learn actions, but you don't want to trial and error learn how to drive. That'd be bad. So in simulations, actually reinforcement learning is fine, but this is more likely a supervised learning task. Okay, bringing in the data. So we want, and this is where it gets really important, right? Because algorithms is sort of the algorithm exists, and it's sort of independent of the data. But machine learning models configure themselves based on the data. And so we need the data that we have to be correct and representative. Just the data that you have, you can't just take the data and say, hey, machine learning model, process this. You have to turn that data into features. And this is going to be important for you because if somebody says, I have this model to predict recidivism, you should ask, what are the features that you're using to predict recidivism? This is really important. People can omit certain features on purpose or include certain features on purpose as well. So really understanding what's going into the model is important. Those are the features. And here I just have some examples. They can be binary, real valued, discrete. Okay, so now, if there's one thing that you take away from this talk, it should be this. And that's caveats. So we kind of have some understanding of how machine learning works, supervised, unsupervised, and reinforcement. We bring in the data, this thing configures itself in order to help us make predictions about the future. But we shouldn't necessarily trust a machine learning or artificial intelligence system. And why not? Because there's a lot of caveats. The first is, how much data did they train? How much data did they use to train? Some of these models require a lot of data to train. If you don't use enough data, then it could be very poor at generalizing. If you use too much data and you're not training the model properly, it could also not generalize. So it could fit your data really well, but not fit new data very well. Data can also be biased or not representative of the population. So if you have biased data in, you'll get biased predictions out. This is sometimes commonly referred to trash in, trash out. And there's some high-profile examples of this. In 2016, Microsoft thought it would be a good idea to release a Twitter bot, so a bot that would learn from the tweets that people tweeted at it. And within days, it became racist. It went from racist and just generally terrible. It went from greeting people and asking them, how good is your day, to wishing that they'd burn in hell, within the span of just a day. And then they had to take it down, of course. But even more subtle things. If you train a model to translate text to images, for instance, and you use data from the internet and say, hey, give me a picture of a lawyer. Well, it turns out that will almost certainly give you a picture of a man. So if you train a model with gender bias, it's going to make gender-biased predictions, unless you're really careful. Or bias of any type. You could have dangerous feedback loops. So this was the example I alluded to before, where police departments are using some of these models to predict where is crime happening. Well, if you include in the training data nuisance crimes, those far outweigh violent crimes. And they're also associated with impoverished neighborhoods, disproportionately populated by minority populations. And so the model is going to say, yeah, go here. There's a lot of crime here. And so then they go there, they find a lot of nuisance crimes, and they feed it back into the model, and you have this really dangerous feedback loop of, you should go here, there's crime, add more police find more crime. So this is a famous George Box quote, all models are wrong, but some are useful. So just consider that when somebody gives you a model. It's not reality, it's just how they think reality is working. And models learn from associations, not causes. Okay, this is really important. So there's a well-known association between ice cream sales and murders. And so if you saw this, you'd be like, okay, so either ice cream sales are causing murders or murders are causing ice cream sales. But of course, there's a common unobserved confounder that's causing both of these. And the machine learning model doesn't care. It will use ice cream sales to predict murders. Okay? And it can be very easy to fool models. And I'll be done in a minute or so. So here's an example, probably my favorite example because I love cats. MIT researchers were able to fool a very sophisticated Google model. This is now showing in a picture of a cat and the Google model being very, very confident that this is guacamole. And so you could adversarially perturb the pixels in this case. I think they slightly made them more greenish. And it felt like more greenish. It looks like guacamole now. Obviously, it does not. You can imagine people doing this for nefarious purposes, like self-driving cars, messing with stop signs, right? So this is coming soon. Okay, just this is from a recent paper on AI in courts and what to be aware of in terms of ethical principles. So respect for fundamental rights. Does it violate things like equal protection or right for a speedy trial? If that's one of them. Sorry. Yeah, equal treatment under the law. So this compass method that seemed to be giving lower risk scores to Caucasians. Is it violating some equal protection laws? Data security, there's a lot of people that are adversaries that want to both change the data or also mess with the model. You have to be really careful. This is a big one that unfortunately we don't have too much time to talk about, but most of these models are really difficult to interpret. And if you're in a courtroom and somebody says, yeah, I predicted a 90% chance of recidivism, what are you and the client going to say? Well, I want to know why your model is predicting that. Okay, so there's some way to interpret that. And AI under user control. So maybe in the far distant future where AI is perfectly moral and perfectly accurate, we can sort of take the ape out of the loop. They'll just hurt things, but we're nowhere close to that. So humans should remain in the loop and should be checking our own bias and trying to find bias in the AI recommendations. That's it. This is my group. Thanks for listening.
So a question and a comment. Tiz, you had mentioned Bayes nest?
Bayes nets.
Bayes nets.
Sorry.
What is that?
Bayesian networks, actually that's where most of my research is in. Bayesian networks are, you can think about them as like graphs where you have random variables and then you have data that comes in and then probabilistic decisions come out. So given uncertain variables, you have some function that takes those uncertain variables and then gives you a probabilistic prediction. So it's like extending logic to probabilities.
Thank you. Any questions? And then I just have a comment. For those of you that do mediation or settlement, have you ever used decision trees? And it struck me that what a lot of what this is nothing but decision trees that you base on data that you have and assumptions about data.
Yeah, so in the longer version of this talk, I have one example of a machine learning model, and it's a decision tree. Okay. So those are, it's no surprise that they're actually the ones that lawyers and judges know, because they're pretty interpretable, right? The data comes in, and you split it, and then you get a decision at the end. And there's some recent controversial work that says these really complicated, I should probably even mention this because I don't even think it's published, it's on arXiv, but these really complicated models are equivalent to decision trees. Okay. So yeah, if you understand decision trees, you understand machine learning.
Any questions? With that, thank you so very much. Oh, I'm sorry, there's a question.
Just one quick, are you seeing any active applications of this kind of work happening right now? You said it's coming soon, but are you aware of projects in courthouses where AI or machine learning are being used right now?
Yeah, so I'm probably the terrible person to ask. I do work with a lawyer, and everything that I know is from him. And I think he's mentioned Bayes nets have been tried to be brought up, so probabilistic decision graphs. And I think sometimes they're thrown out, sometimes they're admissible. Lawyers are using them, right? LexisNexis, which I'm sure you're probably familiar with, right? They have a huge drive to try to provide lawyers decision support, and most of those are machine learning based, interpreting natural language and that sort of thing. So I don't think they've been used in courtrooms really, but definitely by the lawyers. Yeah.
I think we'll find out more from Professor Schmitz.
Oh,
but there are programs that are being used. I know Canada is using one for small claims. And I think that's coming. I think that's coming in the wave of in the future. So.
Right. Yeah, sure.
Thank you very much.
Yeah, thank you for having me.
It is really my pleasure to introduce Professor Amy Schmitz. if there's anyone in the field who knows about ADR and AI, I think it's Amy. There may be other wannabes, but I think she's the rock star in this area. And she'll be discussing the growing use of AI in the courts and in online dispute resolution, and the challenge of balancing efficiency and justice. So Professor Schmitz is a professor at the Ohio State Moritz College of Law and program on dispute resolution. She teaches a number of courses, including online dispute resolution. And in fact, you may be teaching a course now. You have students zooming in to, and she also teaches courses on AI and data analytics and the law. Professor Schmitz is also co-chair of the ABA Technology Committee of the Dispute Resolution Section and the ODR Task Force. And I like this, and I just have to lift it up. Among her many awards, I mean, it would take half to list them all, I found the 2017 Shook Hardy Bacon Best Publication Award. And you may know Shook Hardy Bacon is one of the sponsors of this symposium. So I love that synchronicity. So Amy, the floor is yours. Thank you for coming.
So first of all, thank you so much for having me. I'm really looking forward to talking about these issues. And I wish I could be there in person. It looks like it's just a fantastic event. The lineup is just really rich and wonderful. So congratulations on this program. So I'm going to go ahead and share screen and get to the slides. Everyone can see my screen okay? Sounds like we're good? Okay. Wonderful. So I'm going to talk about data analytics and AI in ODR with a focus on ethical design and access to justice and thinking about fairness. So I'm going to sort of pack in a lot. There's a lot of points to cover here, so I'm going to go quickly. Just setting out the basic uses, building on, wonderful, thank you for the prior presentation, super interesting. I'm building on the same ideas, but then specifically to ODR. Also outlining the benefits and risks, identifying movements toward regulation, as well as themes for ethical design. And I'm going to share some of those themes that come directly from my work with the American Bar Association ODR Task Force. Because after 4 years of hard work, we actually just released our ethical guidance for ODR. So you already heard about what is AI, so I won't labor long here. But I would like to kind of note that when it comes to the law and the last questions that were asked, in fact, to the prior speaker on kind of what is really happening out there, the truth is there's more use of data analytics than there is AI currently in the law. However, it's moving very, very fast and furious toward AI. But when we think about uses of data in the law, I think it's important to kind of have three buckets. First of all, rule-based reasoning. This is not new. This has been used over time. Think about sentencing guidelines, right? Different ways that we think about different opinions or how it will flow based on rules that are already in place. Case-based reasoning now goes a step further, where you are using case law in order to build out wizards, solution explorers, which I will get to explaining in more particularity. And then, of course, you move into machine learning, which is more advanced. When we think about rule-based reasoning, it's really just if-then. It is decision tree analysis, essentially. You know, this is a very simple, you know, if you have blood alcohol level and you have this many offenses, you lose your license, right? It's just a simple if-then rule-based reasoning. Now, case and law-based reasoning, we're starting to see more and more of this. And this is where they're building predictions based on how one will answer a series of questions. Think about TurboTax for completing your taxes. These are solution explorers or wizards, and we see them growing in use throughout the world. A perfect example is Canada's Civil Resolution Tribunal. In the CRT in Canada, what they do is they set up a series of questions, and by the way that the claimant answers those questions, it helps lead them to know what their rights are. It helps sort of lead them through the process, similar to using TurboTax to complete your taxes. Now, when you get to machine learning and further data analysis, as you heard from the prior discussion, you're beyond fixed algos. Now you're thinking about automating and learning from large amounts of data. I think about it as was discussed earlier, but I really do, I like the for my brain, I think about vacuuming up tons and tons and tons of data in this huge like data vacuum. And you're learning from that data. And so it's coming more bottom up instead of top down in terms of structure of now the decision tree analysis, which will emerge from that data. So now the technology actually sits closer to decision making, and use of foundational models is essential. As was discussed, when we think about any use of AI, I think it's important. I really like, I'm not the first one to use this. Of course, this has been around for a while, but where's the human? Is the human in the loop, on the loop, or out of the loop? Currently, when it comes to law, the human is in the loop. We do not have robot judges currently, and the human is absolutely in the loop currently. Now, could that change for small dollar claims? Could we see more movement in the direction of the human being only on the loop or out of the loop? Yes, and I could see that, especially smaller claims. But let's kind of dig more deeply into the different tools that might be available for dispute resolution using AI and data analytics. Because this is the part that I think is exciting, because it could actually help expand access to justice, right? And now we can reimagine what we do. You know, all too often, I think currently, especially with COVID and everyone being on Zoom, they're just assuming ODR is Zoom mediation or Zoom arbitration. No, it is the use of technology to prevent or resolve disputes, and it can go further than simple communication technologies. We can now use technology, build it into the process, almost like Legos, a modular system. Anyone who's interested in sort of thinking about this for self-represented litigants, I actually have a new article on my SSRN page and also the Columbia Law and Technology Law Review. I think that's what it's called anyway, but it's ODR for self-represented litigants, and it's a modular proposal. And what it does is it builds in things like using AI and data analytics for quickly digesting documents. That's already happening. I mean, law firms are using AI for sure with respect to discovery. Also assisting enforcement and risk assessment. Additionally, automatically docketing and organizing files. There was a really cool conference I was part of, I think it was like 2019, so this is before the pandemic, and it was specifically with the National Center for State Courts and looking at ways that we can use AI in the courts to help efficiency and fairness. And there was a wonderful example with automatically docketing and organizing files and really helping to really save money for the court, but also it helped accuracy in the end, especially as you train AI and it's smarter. Also chatbots, New Jersey is an example, to answer frequently asked questions and to help self-represented litigants. And then finally, there are systems in place for checking outcomes for abnormalities or checking documents for mistakes. This can be incredibly helpful for self-represented litigants, for example, because they often make mistakes in their filings, which is very problematic because then they end up not getting the remedy that they desire. There is an example, it's called Turbo Court, that is working with the courts in Hawaii, and that is one of the things they do is they check the documents for abnormalities using AI and data analytics. Some more examples, just speeding up, again, document review. There's another, it's called Contract Scout, which is a former student from University of Colorado created it, and where they are looking at contracts and speeding up review of contracts and finding abnormalities by using AI and data analytics. Also predictions and options to assist case and bargaining strategy. We see that with Smart Settle, for example, where they use algorithms to help you figure out what your ZOPA is if you're in a mediation, your zone of potential agreement, and that can be quite helpful. Also assisting, again, self-represented litigants, even using natural language processing. That's using AI, for example. You know, I see a day where we will just take a picture of a document of a W-2. It all uploads automatically, for example, into court documents, right? We could speed things up. You can help individuals who do not have the time for, or the money for an attorney. Also triaging wizards, document support. Again, modular ideas that we can build these like Legos. And I think, you know, what currently exists today is going to be nothing in comparison with what we have 5 years from now. And I think we're seeing great movement, especially if you follow the money. One of the things I like to do in my research is I also follow the VCs and see where all the money is going. And it turns out that money is just going into these AI by leaps and bounds, billions of dollars that they're putting into it. I like the comment earlier about LexisNexis. Oh yeah, they're definitely invested in AI for legal uses. Some more examples. This came out years ago that Estonia was building a robot judge. Now, are they there yet? I'd argue no, but it's in the works. Who knows? China's Smart Court Initiative. Now, this is another example that is absolutely happening. They have a judge e-assist platform where they're using text and image recognition and analysis to automatically index litigation materials. Also, the judges, as they're sitting there, they get pushed. They get a similar case push. And the system actually improves the judge's efficiency by telling them, hey, this might be a relevant case. There's also a somewhat controversial use, which is the use of analytics to essentially check the judges to promote standardization of the justice system and catch outlier decisions. This was mentioned. This is from LexisNexis, Lex Machina. This is really cool to play with if you haven't done it yet. And they are working on, and especially in the area of patent, because they have so much data. And I think that's where AI is going to grow the fastest, is in areas where we actually have the data. Because if we have large amounts of data for a particular type of litigation, it's easier to catch those patterns and build these processes. Some of you may have used the brief analysis tool that they have as well, where you plop your brief in there, it checks your quotes, it can make sure that you got all the cases you needed to include, it'll tell you if you missed some cases. Really kind of fun to play with, so check that out if you haven't already. But so, you know, kind of all the balloons and puppies and wonderful things and, oh my gosh, technology is going to save the day, right? Well, not so fast. There are dangers of digitizing due process. And that's my shameless use of alliteration, which I always have to include in any presentation. But there are dangers and pitfalls. So we heard already about some of the concerns about bias. No question, garbage in, garbage out. If your biased data is building the system, yeah, you're going to have more bias. But I'd like to add another layer onto that. Along with that, we have our human propensities, which interact. For example, anchoring bias and confirmation bias. For example, I was presenting on AI and family law and thinking about risk assessments, right, based on data. And that's concerning because if you're a busy judge, for example, and someone hands you what the quote unquote data says, should this child, for example, be taken from the home based on data? Well, you might think, okay, the data said that, right? So now you might be anchored on thinking that's the right answer, and you may not do your due diligence in the same way you otherwise would. Or confirmation bias, where you search to find an outcome that you want to fit the outcome you want by your own psychology, right? But additionally, explainability. And this is a real problem, especially in the law, where black box concerns, especially with machine learning, where we don't know exactly how the algorithm was created because it was machine learning, right? And moreover, it is hidden behind proprietary rules, right? Intellectual property rules. Compass, the case Compass that had to do with jail or bail in Wisconsin, Loomis. You know, they said you cannot get your hands on the intellectual property. You know, they can only give you the general parameters, right? And they did have to give particular warnings about how the analytics could be used against you as a defendant. However, you don't get to find out exactly what that algorithm is or exactly what went into it because of intellectual property rules. So it's not explained about how the answer is there. Also, insufficient, inaccurate, and improperly structured data. You know, we kind of think about this data like it's handed to the researchers or to whoever's building the model on a silver platter and all perfectly structured. No, that's just not true. And often it's inaccurate or it's not sufficient. We especially have to worry about this in the area of dispute resolution because most things are decided by private settlements, private mediations, private arbitrations, and that's not being considered in most of the AIs that are built on judgments. Right? Court judgments that are published. You're missing a lot of very important data. More dangers. So first of all, limited capacity. The law evolves. So if we're building machine learning based on past data, we're not taking into account future, right? Legal reasoning is complex. It's not easily codified. Law evolves. Transparency. One of the most sort of important things we think about in terms of the justice system is transparency. Public participation and trust are vital to procedural justice. There's also concern about gaming the system. You know, we've always talked about the digital divide in terms of people having access to the internet, but now there's a new digital divide. Law firms are pouring billions of dollars into developing their own AIs, their own technologies, because they have the money to do it. What about the one-shot players? What about the individuals who do not have that same access? You know, we already even see this with Zoom arbitration, for example. One person on their phone and the other has, you know, the perfectly tricked out, you know, ring light and great speakers and several screens. A new digital divide is developing. There's a concern also about second-class justice. You know, one of the things that came up recently at a conference at the Cyber Justice Laboratory in Montreal is this idea of, well, if we decide, okay, we're going to help self-represented litigants by building these robot judges and having robo decisions, does that mean that others who have the resources get the real deal, and while we're pushing off others to the technology? You know, we want to make sure that whatever we create is absolutely accessible and fair for everyone involved. At the same time, humans are biased. Humans make mistakes. As part of the Cyber Week yesterday, it was really fun. I got to moderate a student panel of my students, and one of the students talked about how people in their generation actually trust the data and trust robots more than they trust humans, because humans are biased, right? And so we also have to take that into account. So maybe it's a happy medium. Maybe it's using these different systems with a human still in the loop, just as an additional piece of data to consider in making final decisions. Also, we might want to build in, as mentioned earlier, you know, ways to use natural language processing to make processes more accessible for different people with different abilities. Automated transcription so that those who maybe can't hear can then read it, right? So there's a lot of different things that we can do, I think, that make sense. And I do think the future will be using more and more AI and data analytics. And so does the government. So as you might imagine, we're starting to see concerns about use of data. And those concerns are bringing about more movement toward regulation. So I'm going to go on a quick tour of the different regulations that have been discussed and bandied about and for you to look more into. But for example, US, we've got the National Center for State Legislation. They have an index. You can check that out, Google it. Also, the Department of Defense has been talking about use of AI. We also have an executive order as well as an AI. They even came out most recently, Biden signed sort of a Bill of Rights with respect to AI. And a lot of the published guidance actually focuses on these same 4 pillars: transparency, explainability, fairness, and accountability. So one of the common themes that I've been seeing, again, is this concern about transparency, you know, for people to know that they're subject to an AI. For example, if they're using Cogito, which is an AI that looks at your pattern of speech to know whether or not you're agitated, for example, maybe you should know about that. What about explainability, how algorithms make decisions? Maybe we can't get our hands on exactly the intellectual property, but we at least need to know what went into that AI. Fairness, ensuring that the decisions are fair, robust, and empirically sound. And finally, accountability, some means for accountability. The National Institute for Standards and Technology also had a proposal for identifying and managing bias in AI. And now that has gone through different iterations. It's actually further along than it was in June 2021. But again, it's calling for stakeholder interaction pre-design, during the design, and afterwards, during the deployment. And it really is this idea of ethical by design. So thinking about ethics at the outset, right? Not as an afterthought, which is absolutely essential to fairness. The National Artificial Intelligence Advisory Committee regarding the AI initiative is also, it has a subcommittee on AI and law enforcement, again, worried about bias and security. Again, seeking to ensure that the US will be a leader, but to make sure it's trustworthy and fair. Canada as well has a directive on automated decision-making. They're concerned about using, again, automated robot decisions and making sure that in any way that it is used, that it's efficient, accurate, consistent, and interpretable. Similar themes. Again, and this is from my good friend, from Professor Vermeer with the Cyber Justice Laboratory, the last 2 slides, who's really the expert on this area. It taught me everything I know. And with respect to the directive, making sure aimed at AI tools that classify cases, also identifying cases for human review, making sure there's a human in the loop where needed, recommendations about application, and then finally concerns about these administrative decisions. The requirements, do you start to see some things? Transparency, quality assurance, just as we talked about, recourse after the fact, just as I mentioned earlier, reporting, and they add in this algorithmic impact assessment as well. Now, this is really kind of the big beast on campus that everyone is talking about. Europe is, once again, similar to the GDPR, they are absolutely on it with respect to the AI Act. So the AI Act has been proposed. It's not yet fully enforced, but it's definitely stumbling along there, and I think it will eventually become enacted. But it really, what it does is it creates, I would say, I put it in kind of this pyramid-like structure where some things are just unacceptable. And Article 5 parses out things that are unacceptable risks in terms of the use of AI. For example, social scoring or facial recognition, dark pattern AI and manipulation, not even acceptable. But in the high risk category, that's where we see education, employment, justice, immigration, and law. So Article 6 is what we are worried about when we're talking about the law. And here they kind of set out strict obligations. Again, risk assessment, just like we saw in Canada. High quality data sets, just like we see with same things. This is not new. Logging of activity, ensuring traceability of results. Again, documentation, just like you saw with Canada and similar to the what NIST had proposed. Clear and adequate information, appropriate human oversight. Again, these are not new. High levels of robustness, security, and accuracy. So once again, themes are beginning to emerge. So that leaves us with thinking through to ourselves. What themes as ODR practitioners, providers, developers, designers, what are some of the themes that we should be thinking about? First of all, of course, I always begin with system design, but then really kind of focusing on those pillars of accountability, transparency, equal, fair, and impartial, and then finally, attention to privacy and security, which should never be forgotten. So with respect to design principles, I always go back to the book that Jan Martinez and that they put out in looking at design principles and what goals. So thinking through, as you're developing an AI or you're using some sort of data analytics, thinking about, okay, what are my goals for using this? Never use technology for technology's sake. Use it if you're going to be addressing a problem, fixing a problem, making things better, somehow helping dispute prevention and resolution. Thinking about access to justice, user experience and satisfaction, the reputation of whoever you're working with, also technical capacity, transparency, making sure there's fair and predictable outcomes. If you're using some sort of an AI for predictive coding, for example, or predictive analytics, and you're getting different predictions based on the same data, something's wrong, right? You need to go back and fix that. Thinking through trade-offs and tensions, interest versus rights, equity versus efficiency, voice, and administrative feasibility. Also prevention and enforcement, and then thinking about power and control. As mentioned earlier, repeat player advantages could be quite real in a world with more and more AI and law. So this is coming directly from the ODR task force. What I did is I pulled out some of the guardrails that were focused on AI and data analytics specifically. Now the guardrails themselves are a much longer document and include a lot of different things. And just to give you a little bit more about the process, the ODR task force, it was basically 4 years that we were looking into this, maybe 3.5. And we had 3 working groups. One was dealing with specifically the providers. Another was specifically for the courts and court ODR. And then finally, the last was kind of a catch-all for everyone, designers and anyone else who might be involved in the ODR enterprise. And these are some of the pillars that came out that really focused on data and use of data. And again, this is not new, data management. You have to have an actual system in place for how you're going to manage that data. And it has to be continually monitored, always learning, and always subject to evaluation. It is not a one and done. Data quality, making sure the data that you're using is accurate. and finding out if you are missing essential data in any AI that you're building. Outcome consistency, as mentioned earlier. A system should produce the same outcomes based on the same data inputs. If it does not, this has to be explained. And then auditability. This is similar to what we see in Canada and Europe, the idea that you should be able to audit the system. Now, again, maybe we can't get our hands on the exact algorithm and finding out exactly due to IP rules, but nonetheless, there has to be some way to audit the system. And there are ways to do that in place. Source transparency. What's the data that we're using, right? That becomes incredibly important. Even Loomis, the holding in Loomis, noted the importance of source transparency. Context and culture, thinking about the nuances of the law, right? Again, it's ever evolving. Context and culture matter. Automation transparency. If you are being subject to an automated process, you need to know that, right? That is another piece. Notice, being aware, disclosing the manner and degree that machine learning and other AI is influencing possible outcomes and options. This is actually directly as well from the Loomis decision. It required essentially warning to be given when Compass was going to be part of the decision process in setting bail or jail. Information processing, use of data to make decisions. It's got to be, again, transparent and explainable. And of course, equal, fair, impartial, watching out for system advantages. Also, access to system features. You know, it's really important that we follow not only the ADA. I mean, one of the things that's been quite troubling to me is that a lot of the ODR processes that are out there are not actually compliant, right? We're not always thinking about accessibility, and we have to, we must. It's not optional. And bias, system designers have to address bias, unfairness. Always important to think about bias that might be baked into a system. And then finally, privacy and security should never be forgotten. Following industry standards, ISO and others have set different standards that just are basically the floor. But making sure that you're following those standards, chain of custody, being aware of what data has been used, and it has to be sufficiently auditable once again. Breach risk. You know, determining, finding out what is the risk that there could be a breach in the system where the data could end up being hacked. And then storage and retention, having very clear rules on what happens with the data that you're using in order to build an AI. So I welcome research and conversation on these topics. I do think there's some great promise, especially for helping self-represented litigants, for improving processes in the courts and in private ODR. But nonetheless, we have to think about system design, and attention to ethical standards is absolutely essential. So I'm very thankful that I got a chance to Zoom in with you today, and I look forward to your questions.
Really, two questions. Because we all know that we learn by example. We just heard that, so I'm just curious, you mentioned the Compass case. Are there other examples of, both sides of where, AI has been and ODR has been abused and areas where it is really working well? Just one example in each category, and then I'll open it up to
Excellent. Yeah. Well, I have a few abuse questions. I have a few examples of the abuse. So one of them, I got to do a Fulbright specialist project in the Netherlands, and it was really interesting. That I don't know if you guys heard about this, but it was a huge scandal. So they were using AI in order to determine benefits and trying to catch fraud in the system with respect to government benefits. But what happened is people were having their benefits cut off inappropriately. And that's a really bad issue, right? With suddenly you're not getting the money that you need in order to feed your family. And so it actually created quite a scandal in the Netherlands. So I think it's a good example of sort of AI gone wrong, where it was being used theoretically to make the system more efficient, but it really kind of went too far in not protecting fairness, and it really became problematic. So I would say that's an example of kind of not working so well. One that actually is getting, at first glance, you might think that it could be problematic, but when you look deeper into it, it's actually pretty good. So Allegheny County has created a risk assessment tool for family and domestic relations in looking at sort of helping to decide whether or not a child is at risk staying in a particular home, for example. But what they've done is they've made sure that the human is always in the loop and it is not a robo decision, number one. Number two, they found that it actually helps make decisions that are less biased than the human. It turns out that some of these caseworkers, not by fault of just their own people, we're all biased, right? I mean, I had a friend once who did research looking at judicial decisions regarding grandparent rights and whether or not these judges would give the grandparents rights for visitation with the children. And wouldn't you know it, it turns out that the judges who were grandparents were way more likely to grant grandparent rights. And I'm sure it's not like, trying to do this explicitly, but things are in our heads, right? And so actually a lot of the caseworkers liked getting the assessment because it was a helpful tool and it provided additional information based on the data that helped them check their own biases, right? And so sometimes it can be used in a way that is helpful, especially when you're busy and you might be missing data. And so sometimes having that additional report can actually be helpful. So those are some examples.
Yeah, that's great. So other questions for Professor Schmitz? Sure. Joette.
I was commissioner of the Department of Children and Families for the state of Connecticut for 8 years. And when we first started looking at this question of using analytics, and the problem that I noted early on was that it sort of gets back to our earlier speaker, garbage in, garbage out. So if one of the things we were looking at as an indicator was someone's past history with DCF or someone's past criminal history, those categories were replete with racial bias. So, once again, while yes, it was true, and we weren't reopening those cases from 30 years ago, but if you actually looked at the facts attendant to them, you would never have taken anyone's children, they wouldn't have had a DCF history, and they would not have had a criminal conviction. So how valuable really was that as an indicator upon which to build? And so, to your point, it's in principle, it's great, but in detail, it can be really quite troubling.
Yeah, I have to say, especially this is where I would just add where I'm quite concerned about where anchoring bias can come into play as well, because now if you think that report is accurate and assuming that it's not biased and not realizing it's biased, because you cannot cross-examine an algorithm, and that's a problem. I think that is one of the chief concerns.
Just Joette Katz, before she became the commissioner of DCF, she was on the Connecticut Supreme Court. So that's an unusual step to go from the Supreme Court to taking over DCF and getting it out of a consent decree that had lasted 28 years. I just want to give you a little background on the questioner. I can't do that for every questioner, but I did want to share that. Other questions for Professor Schmitz?
Thank you. Very interesting comments, Professor. Is there any court system where this process of AI, ML, is actually used to resolve a dispute between real litigants? Is there even an experimental program that has gone that far?
So I couldn't really hear you. So do you mind repeating, Charlie?
Yeah, I'm sorry. Is there any court system where this process of dispute resolution using AI and ML has actually been used to resolve disputes between real litigants, even in an experimental program? Has it gotten that far yet, or is that still in the future?
I think it's not. Especially in a court, I have not seen it in a court yet. I think there's some discussion about how it is being used, for example, let's say within Amazon or within eBay to decide to give an automatic remedy to a buyer, for example. But I have not seen it in a court where they're actually using a robo decision.
Are you bold enough to predict that would happen in the near future?
I know, here's what I think. I think it will happen, but it will be probably where a human will be on the loop. So you still will have some sort of check on the system, but I could see it more in sort of administrative courts or with more sort of, let's say, traffic ticket decisions or something that's more discrete and less nuanced, like a traffic ticket decision. I think that is probably where we'll see it used first. But I think there's due process concerns. And so I think when you're talking about a court, you could run into problems there. Even arbitration, there's discussion about having robot answers in an arbitration, but that also could run into questions of enforceability under the Federal Arbitration Act, right? Did you have a full and fair opportunity to be heard? So I think there's some legal questions there about actually kind of having a human out of the loop, if that answers your question.
It does. Thank you very much.
So Lou, I encourage you to stick around for the next two panels because we'll be hearing from ODR programs outside of Connecticut and those that are going on inside Connecticut. And again, it's a good question. I'm not sure that any of them, I love that, those three loops, you're either in the loop, on the loop, or out of the loop. And I don't think, you were asking an out of the loop case. And so I don't think we're there yet. But we are probably, in the loop and on the loop. So, but we'll find out a little bit more when we hear from our panelists coming for the rest of the afternoon. But
I'm curious what you all think. Show of hands, can you count them for me, Charlie? How many people think that it's a good idea to have a robot judge for decisions like traffic tickets?
We're not ready here in Connecticut. Steady habits.
How about ADR? Has AI have any applications for ADR, or is it currently anticipated that there'll be any applications for ADR? You had mentioned the Amazon example.
Was that to me?
Yep.
Yeah. So the application of ODR to ADR.
Of AI to ADR.
AI.
So you had mentioned Amazon, and you had mentioned.
Well, I think that it
Google,
begins. I think with PayPal and you know the history. One of your colleagues, Colin Rule, was involved.
Right. So like eBay
and
or
PayPal, yeah.
Amazon. And there are some for example, they do have, let's say it's some of the Delta Airlines is one example where I think they are using, kind of tracking using APIs, and then they can figure out, if a flight is delayed by this many hours in Europe and it violates the law in Europe, then you automatically would get your money back. Things like that they're starting to develop. I mean, they're even talking about use of smart contracts for automatic enforcement of flight delay claims in Germany. So, I mean, I think we'll see it in those kind of those smaller spaces for efficiency. But again, it's based on a risk assessment, right? You're not taking away someone's benefits like in the Netherlands example, but you would be actually providing a remedy quickly to a consumer in a situation where their flight is too delayed under the European law, for example. So it's that balancing kind of the risks and benefits, right? So what are you going to lose here versus what's to be gained?
But you did mention the situation where the use in arbitration. So how do you explain that? Because I know that's another area of expertise you have is arbitration. So.
Yeah, we had a whole panel on use of AI and data analytics and focusing on kind of cyber arbitration yesterday as part of Cyber Week. If anyone's interested to listen to that, the recording will be posted. And it was really interesting kind of thinking through the different ways that we might use AI and data analytics. And I absolutely think it's already happening where an arbitrator could be using Lex Machina or could be using different data analytics that currently exists and is built into both Westlaw and Lexis, and then others that are being developed. I think we're going to see more and more where they are using agreement technologies. It's another example where you populate based on answering questions. For example, like Detour Life is an example in family, but where you're answering questions and it's populating agreements. I mean, we could see that happening in an arbitration, also helping to more quickly render an award or in a mediation to reach an agreement. But in an arbitration, again, predictive analytics, more and more use of, just like we see in litigation with document analysis is another area. And then of course, more and more with natural language processing that I think is going to really take off in litigation and arbitration, just because of efficiency.
Sure. And again, it occurred to me as you're talking that Allegheny County situation, it may be something that an arbitrator ultimately renders to the decision, but it may be a bias check to kind of see what the machine would do, and then take that into consideration. So you can see that I'm not sure we're going to get to in mediation. I'm not sure that's going to, but
Yeah.
I don't see any robo-mediation in the near future, but I may be wrong.
Well, I had a student yesterday on the student panel where she was arguing that you could use AI in mediation for sentiment analysis. So you can use facial recognition software in order to, not for the criminal uses, but looking at kind of reading the room on a Zoom mediation, for example. So you would know, like, oh, something's going on, they're upset about something, I need to caucus, for example. And so you might be able to use some of these different technologies that are AI. There's this whole facial recognition for sentiment analysis is being developed here at Ohio State. And that's one of the things that she was saying would be a great use in mediation.
Sure, but I guess to the extent that it's remote mediation and where you can, use that, right?
Yeah.
Anyway, I want to thank you very much for taking the time. It's always a pleasure to work with you, and I certainly invite you, not that you have the time, but maybe at least your students to because the next panel, which will come after a break, is with your colleague J.J. Prescott.
Oh, yes, yeah.
Who's
That's awesome.
going to be moderating a panel on ODR programs in other states. So
Well, thank you so much for having me. And next time, I hope we finally get to be in person. I feel like we meet in this Zoom world much too much.
well, one of these days. Good. Well, you're a little closer now. You're at Ohio State, so you're getting closer. Colorado, Missouri, Ohio State. So maybe
I'm moving closer. Yes.
Yeah, you're getting closer.
Same time zone. All right. Thank you, everybody.
Really a privilege to have a wonderful moderator, J.J. Prescott from the University of Michigan Law School, and 4 examples of 4 programs from 3 different states, and then this will be followed again, as I mentioned, by a panel on what ODR programs are going on here in Connecticut. As I was explaining to Ms. Parker, that one of the reasons we scheduled the outside of Connecticut first is we hoping, as this symposium does, is to educate the Connecticut bench and bar as to what's going on in other jurisdictions. So with that frame, Professor Prescott, J.J. Prescott, he's a professor at the University of Michigan Law School, and he will moderate a panel discussing judicial ODR programs in 3 states, Delaware, Michigan, and Ohio. And I'll tell you more about those after I've introduced him completely. Professor Prescott's research interests revolve around criminal law, employment law, the dynamics of civil litigation, and particularly settlement. And much of his work is empirical in focus. And one of his current projects is exploring the role of technology in improving access to justice and legal decision-making. So you can see there's a real overlap with the work he's doing and with the work Professor Schmitz is doing. Professor Prescott also helped develop an online dispute resolution platform that helps people resolve their legal disputes with state and local governments and other parties online without the need to hire an attorney. So, and we may or may not have that, but he can share with us. I'm not sure how the other programs are working, but you'll be hearing, and this is kind of come up with some alphabetical order. This is alphabetical order by state. Stephanie Parker, who's with us, and is actually also, it turns out, a Quinnipiac law graduate, is the operations manager for the Delaware Justice of the Peace Court, which she'll explain what that is in a minute. We're also joined by Michelle Hilliker, who's the ODR manager for the Michigan Supreme Court. And we're getting a lot of representation from the great state of Michigan. We also, the next members of the panel are Alicia Fink, who is the magistrate, and Lisa Fusick, who is the court administrator for a Michigan District Court 14A. So maybe they can help us tell us where in Michigan that is. But and last but certainly not least, and I hope I pronounced it correctly, Maria Coleman. And she is the dispute resolution manager for the Ohio Supreme Court. So just a message, you can notice how the Michigan Supreme Court and the Ohio Supreme Court are engaged. I think something that we can, that says the public policy supporting this work is very high in those states. I'd like to see it lifted in Connecticut. So with that, JJ, the panel is yours, and thank you very much. We really owe a lot to him because not only did he agree to moderate the panel, he actually recruited the panel, with a little help from us, but he did a lot of legwork. So thank you very much, JJ, for bringing this all together.
My pleasure, Charlie. Thank you so much, and welcome everybody. I can't see the audience. I can see you, Stephanie, so that's great. And I want to thank everybody right from the beginning for participating in this panel. My role, I hope, will be quite limited. I really want to just invite all of the participants to really just sort of tell us their stories, their experiences with ODR in their respective domains. As Charlie mentioned, we have sort of two different ways of using ODR in Michigan, and then ODR uses in Delaware and Ohio as well. And I think their stories are going to be different because they're using the technology to hopefully accomplish different things and to deal with different sorts of problems and needs in their courts. And I think that's really how I want to start. I'd like to ask everybody, and I'll just point to one of you randomly first to tell your story. And I think what I'd love to hear, and I'm hoping the audience would be interested in hearing, is just sort of how you got to this place. By which I mean, in the decision to explore and then either pilot or use ODR, what were the motivations? And one thing I'd be particularly interested in hearing from, and I hope the audience will too, is whether or not some of those motivations had to do with the users of the courts and their needs, or the judges, the magistrates, the court officials, the court administrators, and whether there were needs that ODR could speak to there. I presume both of those played a role, but I'd like to know what the needs were that really kind of pushed you to the first stage of piloting or adopting this. So maybe I'll start in terms of starting with the court that has experimented with ODR for probably the longest, I'm guessing, District 14A from Michigan. Magistrate Fink, Court Administrator Pusik, would you guys I'm not sure which of you would like to speak first, but I'd love to hear, you've been using ODR for a while now, and probably your views have evolved over time. So tell us a little bit about your experience.
Do you want me to start, Alicia?
Yeah.
Okay. So we've been using ODR in some shape or form since about 2014. We were a pilot program. Actually, Professor Prescott came up with the idea and talked to us. And as a result of a lot of back and forth, we settled on a traffic ODR program to start. So we have what's called online ticket review, and that was kind of our introduction to ODR. And we started with one agency back in 2014. And just for clarification, we're in Washtenaw County. We surround Ann Arbor, so all of the communities outside of the city of Ann Arbor, with the exception of the township of Ypsilanti, is covered by 14A District Court. So we dipped our toes with traffic, and after we found out how great it worked, we kind of experimented with some other misdemeanor type cases that we could use in an ODR format. So we came up with an online plea, which has been super helpful during the pandemic. It obviously was extremely important to us being able to continue operations. And I liken it to, and I know I've used this over the years, to say anybody can participate with their court case, even at midnight, sitting on their couch with a bowl of popcorn. So it's super easy. It allows flexibility for all participants between the defendant, the officer, the court, and it allows people to take care of their cases very timely. They can log on as soon as they receive their ticket and try and negotiate or mediate a outcome. So it's been a tremendous thing for us. And like you said, we've been doing it since 2014 and super excited. I think we were up to 5 different platforms in some shape or form of ODR at one point. So it's been a great thing, and I'm excited to hear what other people have to say. And Alicia can speak more to the day-to-day. She uses it all the time, and she's quite the expert on it now for our court.
Yeah, so we, I think the key thing for us is, like Lisa was saying, we cover almost the entire county, and it really provides access to the court for people who have many different walks of lives, different schedule. They're not trying to get to an open court building, and instead they can just log on to our system and ask their questions. It's not really designed for people to ask questions, but truthfully, I get a lot of questions. People will log into we have an online plea platform, which is intended to be a place where a person can plead guilty as charged. And then I can set the sentence and fill out a form that gets emailed to them through the platform. Or if it's a case where a magistrate can't take the plea, then the judge can do that and with my assistance. But now that gets used a lot for people saying, I'm in a treatment program and I don't know how to Zoom, or I have a warrant and I don't know what to do about that, or I think I don't live in the state of Michigan anymore. Can you dismiss my case? And sometimes I actually call people based on what they've asked and try to help them figure out what they're trying to do, which they would never have direct access to me if they came into the building. I would just say to the clerks, no, I'm not doing that, because I still need to have a little bit of a barrier between me and the public, right? So this way I get to decide whether this is a person I'm going to be speaking to. And lots of times I communicate just directly through the program to people. Are you sure you want to plead guilty to this? If you go and do this other thing, you might get a break from the prosecutor. So it's a place where, for me, I feel that I am actually really able to help litigants with true navigation of the criminal justice system, which can be very complicated. The ticket resolution program that Lisa mentioned is fantastic. It saves everybody a ton of time. I'm able to look at people's driving records and then determine whether their ticket should be modified to something that won't affect their driving record. It's great. And that has the participation of the police officers in that as well. And then for a while, before the pandemic, we were also using the program for helping people resolve their driver's license cases. That became unworkable once the pandemic occurred. And we were also using it for warrant recall. You could go online and request to have your warrant recalled through the program. We're not doing that anymore either, again, because during the pandemic, we needed to create different systems because the court was not open for so long. So those were both really good programs. And I think that we've frankly lost something by not being able to do that anymore. But the changes that we had to make as a court just don't support those particular programs anymore. So, I mean, it's not a super complicated idea or a system. I'm not knocking JJ's brilliant brain, but as far as what I'm doing and my interaction with the people that are using it, it's pretty straightforward. And the program is set up that I can talk to someone over and over and over again in that program if they need to keep asking me questions. I'd be happy to answer any questions, but I don't really have anything else I think I need to say about that.
Great. That sounds, you guys both hit points about making things easier in terms of access and communication and navigation for users, but also how it makes things easier for the courts. I love the idea of the innovation that the system can sometimes allow, or systems like ODR can sometimes lead to new ways of doing things, maybe intended or unintended, and that's something I hadn't thought about. So it's really nice to hear that sometimes technology allows that to happen in the ODR context. Why don't we move down south over to Maria Coleman, and would you mind kind of responding to the same question I gave before? What led to what you're doing in Ohio, and how has it affected the courts and also access from your perspective for court users?
We started, this was started much more recently. During the pandemic, our Chief Justice Maureen O'Connor got some task forces together to look at various ways of providing access to justice virtually. And this was one component of that. It also involved online, Zoom hearings and other things like that. And this is what we decided to do as a pilot project with some assistance, financial assistance from the State Justice Institute and of course our court as well. And we invited any court who wanted to participate, and 17 courts participated, joined in the pilot project to try ODR. The courts had different degrees of engagement, different degrees of success. We started off, it was a 1 year, they were funded for 1 year, and doing eviction, they could choose what they wanted to handle. Evictions, the options were evictions, foreclosures, small claims, and so that they were to do those, and then they could pick whatever kinds of handle they wanted to do. And then we worked with them on a platform to develop the programs. The small claims, evictions, and foreclosures came up, got going faster. They were more straightforward, and they have finished their year. And some of them are still continuing. The family court took a little longer to try to come up with plans, and they're just launched. So we were looking at, this is one way of trying to expand access to justice to people, as they said earlier, to allow folks to do it from home, to help with the anticipated backlogs from the pandemic, and also to see if we could provide service a little easier to pro se people as well as to other litigants.
Thank you. Michelle Hilliker, I wonder if we come back up north and you could describe a little bit of your role in your program and maybe speak to some of the same issues.
Sure. I'm Michelle Hilliker. I'm manager of the Office of Dispute Resolution. And in Michigan, our experience was we already knew about Alicia and Lisa's program. And we had done some research back in 2017, 2018 to see if we could insert a mediator, so a third-party neutral, in the system that currently existed. In Michigan, we have a network of 16 nonprofit organizations that provide dispute resolution to all the citizens in the state. So we had a very progressive, very supportive, and very passionate Supreme Court justice. She's still our Supreme Court justice, but unfortunately, we're about to lose her. She's going to be retiring soon. But she was very interested in the access to justice, aspect, and she was also very interested in what technology could do. And so she was very excited about us, researching this, looking into it. So what we did was we contacted Court Innovations Matterhorn to talk to them about creating a system where we could have the third-party neutral in the middle rather than the two parties, the court staff person and the litigant. From there, we picked cases that were pretty specific to access to justice as far as the individuals that would not have representation. So we first picked cases that were landlord-tenant lesser of a landlord-tenant, like disputes over security deposits and things like that, problems with apartments, small claims, general civil, and then also neighborhood disputes. And so the program was created to deal with those types of cases where the population most likely couldn't afford attorney representation and were intimidated by the court system. And let's see, we also wanted to make sure that people had information as necessary regarding representation. So we also have in the state of Michigan, the Michigan legalhelp.org. So our platform, we call it MI Resolve, has links embedded in the platform where people can get information from this legal aid type system, so they can have additional information as well. And then the nice thing about the system that's been developed is that we're able to upload documents. We're able to pretty much, all the signatures are online. They can be done online. Court forms are done online. The system has the mediators join the parties, talk with the parties. The parties are able to ask questions. We're able to have a caucus system. And just within the last year, we've allowed now multiple parties on the system. And so if parties are represented by attorneys, they may also have their attorneys join. I think that's kind of the highlights of what we've done with the platform.
Great, thank you so much. And last but not least, Stephanie, I wonder if you could tell us the story in Delaware and where it comes from and really what the drivers were for experimenting.
So back in 2019 to early 2020, our court administrator was interested in exploring ODR to address default rates, and then COVID. And in Delaware, we had eviction moratoriums that basically put a stop to the vast majority of evictions. And our concern at that time was the backlog of cases that was happening, and could we offer an alternative way for parties to potentially come to a resolution themselves instead of waiting until such time as the moratoriums were lifted. So did some research. We also went with a Matterhorn system, very similar to what Michigan's using, gives parties the opportunity to communicate with one another via email or text message, asynchronous. So again, you can do it in your pajamas at 3 a.m. If parties feel that they are not able to come to a resolution themselves, they can request a mediator to join into the conversation. We were fortunate enough to partner with the Delaware Bar Association and have volunteer mediators who are members of the bar. And so when the mediators requested, I'm the lucky person who gets to assign the random selected person, and then the mediator can join the conversation and hopefully guide the parties to some type of a resolution, or if there's multiple issues in the case, maybe they can get 1 or 2 resolved before it now does get to a trial date, since moratoriums have been lifted and things are going to trial. But we started with landlord-tenant. We've recently started a pilot with small claims and are hoping that we can get that expanded. I think with everything, the big challenge is getting parties to participate on both sides.
Great, thank you. That's actually where I wanted to go next. By now, the audience knows that I've been involved in ODR and excited about it for a while, and most of the discussion we've just heard has kind of emphasized some of the positive sides in terms of ease of use for the court, or using it with pajamas on, with popcorn on the couch advantages. I wonder if all of you wouldn't mind, and really if anybody just wants to hop in here, and if nobody does, maybe I'll I'll go into Socratic law professor mode and call on people. But what are the biggest challenges from your perspective? What are the biggest drawbacks of ODR? Because I think for this audience, there are going to be some real concerns about things that are lost in moving in this direction. And one thing I want to raise in particular is concerns about the digital divide. How do you respond to people who say, well, yeah, but what about the people who don't have access to computers or mobile phones, or people, or to speak directly to the point you just made, Stephanie, the challenge of take-up, of getting people to actually use this technology, and any other things along the way, too clunky, too difficult for entire courts to agree on using. What have the challenges been, and how have you overcome them, if you've overcome them, or limped along, or moved in a different direction? And happy for anybody who wants to jump in to go ahead and do that.
One of the things that we ran into was the use of the email address. And in Michigan, we had never collected the email address as part of the filing documentation. So we do have a requirement that obviously both parties need an email address. So getting a hold of the second party has been extremely difficult many times. And while we thought, okay, this piece of cake, no problem, we've got two names and two pieces of information, what we were finding is sometimes if the first party didn't know the email address for the second party, they would just create one. And then we had to go through and try to figure out, was this a bogus email or was this a correct email? And there's been a lot of personnel hours in following up to try to get an email address so that we can, run the system or run the case through the system. One of the other things that we found was that we built it so that individuals could use it anywhere. There's a password, you log in, you could use your office computer, you could use your library computer, you could use anything. You didn't need to have a smartphone, you didn't need to have a laptop or Wi-Fi. As soon as the pandemic hit, we realized, hey, that doesn't work. If they still don't have Wi-Fi at home, there's nowhere they can go to use it. The one fix for that we came up with was creating some kiosks and putting those in public places that were open. So we did try that as an option, but that was one of the things we ran into, was that we thought surely with this password it wouldn't be any problem, and then COVID hit. So that system didn't quite work out for us as well as we wanted. So I think that's one of the other things I suppose that we ran into. And this was just more something that we hadn't thought about. Our mediators are trained in our court will training. They are very experienced, but many of them that weren't tech savvy had a little bit of a difficult time trying to provide the service online. And so I don't know how many of you are working with mediators that might perhaps not have computer savvy knowledge, but that was one thing that we were very surprised by. That we had excellent mediators in some cases, but they just were not comfortable with being online. And so we had to recruit and train, some new mediators to provide the service.
Our situation's a little different because they have to come to us if they want to use the ODR. So they're coming to us with their information and then we're responding. So it's a little different. What we found in the beginning, and still kind of an issue for us, is our case management system. From a workflow perspective, we have to utilize our clerks on the front end to kind of put a stop on the case so it doesn't get into a default status while it's making its way through the system. And so that's something that's a manual process for us. And then on the back end, we also have to go in and update the case based on what happens with the magistrate, which is, we've asked for our case management system to automate that. Unfortunately, we're still having trouble with that. But that is one thing that we found an issue with. When we initially started, we also didn't have access to our driving records. That was something that took a little while for Matterhorn to kind of get permission from our Secretary of State to allow us to see driving records because we base some of our decisions on that. So that was a little bit challenging. And to Michelle's point, we created access points at 3 out of 4 of our locations that if people don't have access to internet or Wi-Fi, they can come in and use laptops that we have available. Obviously, we use those for Zoom hearings as well, but those access points have become a really great thing for our court and for people to be able to utilize them.
And I think that what I was saying before about the opportunity for me to talk to people through the system is also frankly a drawback, because sometimes then people are using the system to communicate and not to resolve their cases. And once I have given someone some information, like you should really go and do this instead, or why don't you, it sounds like this is what you want, so you should appear for your Zoom hearing, then that's just the end of it. And if they don't do that, I worry sometimes that then they feel like I've given them permission to do something that they really can't do because they still have to appear for court if we're not resolving it online. So I do think that it can be as helpful as it is, and I don't think I should not be using it the way I am. There, of course, is going to be a group of people that misunderstands the communication, and that's just humans. And then my other complaint is also about humans. When we were using, my complaints are all about humans for forever, as Lisa will tell you. But when we were using the program for this driving while license suspended thing that we did. So in our county, we have a sheriff's department, and then that covers kind of the whole county. And then all of the municipalities have their own, lots of the municipalities have their own local police. And many of those agencies will give people a break if they can clear their driver's license and allow them to plead guilty to something that doesn't affect their driving record. And we had what I thought was a very good way of handling that online, with me again being able to say to people, hey, it looks like you're going to run out of time. You still need to you need to get your license cleaned up. And then because these are just a bunch of small municipalities, there was a change in who was prosecuting these cases. And the new prosecutor was like, I don't want to do that. I think that there's this problem with it and that problem with it. And then it just seemed simpler to shut the whole thing down. And I think that that's what we needed to do, but I'm still sad that this one prosecutor's unwillingness to bend a little bit meant that a whole lot of people all across the county couldn't get what they wanted. And maybe when we're more open and Lisa and I can figure out how to do it again, we're getting a new judge in January, so maybe we'll revisit everything then. But there's always going to be people who, because they don't like technology, or they're not tech savvy, or they get frustrated or stymied or communicate with me and then don't understand what I've said and don't know how to do the next step. There's always going to be a problem with something that I think is beautiful and helpful actually not being available to some human beings because of their own limitations. And we can't solve that.
So we recognized early on when we were developing our system that the lack of email addresses, or perhaps incorrect email addresses in the filings, could be an issue. So our cases are loaded into the Matterhorn system on a daily basis. We're able to get our IT people to work with the Matterhorn people to develop a file transfer method. So every day, the cases that have been accepted from the previous day are then uploaded into Matterhorn. And when we send notifications out to the defendants, they are also given information about the ODR system and instructions on how to log in and what it's all about. The vast majority of our plaintiffs in our landlord-tenant cases file their cases electronically through that electronic filing system, they are made aware at the time they're filing of the ODR system. So that's kind of how we dealt with that issue. Our landlord-tenant cases have a fairly short timeline from filing to trial date. In at least one of our locations, it could be 30 days. So that is a challenge. A landlord may just be so frustrated and say, you know what, I'm not going to do it. I'm just going to wait for my trial date. And so that's a challenge for us. On the small claims side, our challenge is really with the defendants. If somebody isn't going to respond, if they're going to end up in default, we went into this thinking this is going to be a fabulous system. This is going to solve that problem entirely. Unfortunately, not so much. But we recognize that we need to do more to educate the public about the system, that this is an opportunity for them, the benefits for them, and the other issue that we're looking at now is to this point of the pilot with the small claims, participation has really been voluntary. I've tried to communicate with some other jurisdictions, and so we're having some considerations of, is there a way to more incorporate it into our small claims process so that it essentially could become more mandatory without using the word mandatory, and perhaps get a little more participation that way. So we'll see.
Maria, did you have anything? Yeah.
We've had similar issues that the others have mentioned. The biggest problem we've encountered has been the registration, getting everyone to start getting involved. Especially when just an email from the court or a letter from the court doesn't work for most self-represented parties. And we've found that we really need it. It works much better when the case is referred, and when cases that are in court are referred from a magistrate or a judge, or in a hearing, like a preliminary hearing, or if there is an administrative person, someone who actually does follow up with the people who haven't registered. And that way, it's saving judge and magistrate time, but it's requiring someone else, but usually it doesn't need to be a judge or magistrate. In fact, it's better, as Alicia just said, not to have it for the technical stuff. Sometimes it's better not to do dual roles and have an administrative person, though in some of our courts it is a magistrate who does respond to the questions. So that's been the biggest problem, is the registration, getting people started. We talked with Michelle, our group team had a Zoom meeting with her. She gave us a lot of ideas to make it easier for self-represented parties. We too have put little videos and lots of checklists on our website. So if we get people started, we have lots of resources for them, but getting them involved and getting them started is the biggest ongoing challenge we have.
So, JJ, you may have some more questions, but just given the time, I want to make sure that our audience, if members of our audience have questions they'd like to direct either to you, JJ, or to any one of the panelists, any one of the state programs that we've heard.
Thank you, Charlie. Yeah, I confess I didn't know whether we were going to do audience questions, so thank you for letting me know. I'm glad to open it up to the audience.
Yeah, so we have a question already.
Lisa, a quick question, because you mentioned something about dealing with like traffic citations, and I think you said as soon as they get the ticket, they can start the process. What exactly does that look like to start the process as soon as they get the ticket?
Sure. So with our system, we decided early on that we were going to be very specific in how it would work. So some other programs across the state are different than ours, but we said right from the get-go that we would not deal with anything that was a safety issue. So no traffic crashes, no school bus violations, no railroad crossing. So those automatically get washed out of the system based on the charge. When somebody gets their ticket on the side of the road, they can log on to our website and it takes them to Matterhorn, and they can enter their information in. When they enter their information in, which includes their driver's license number and their name, they then also have to agree that they will accept a reduced charge. So we specify what that charge will be. They have to agree that they're going to pay within 2 days of the decision. And I think what the third thing is, that they agree to work within the system itself. So the system will keep pinging our case management system looking for that ticket until it hits on it. Once it hits on that ticket, it will send a message to the defendant to say, we found your ticket. It's now being referred over to the court. So once that happens, the police officer or the court has to kick it out so that we don't default the ticket. Then notification goes to the police agency to say, hey, this person is trying to resolve their ticket online. The police agency then can send something to the magistrate, that they approve or they don't approve of the reduction and why. And they sometimes can tell stories, or sometimes it's very, very quick. The magistrate can tell you that. And then it goes to the magistrate for decision. So she has in front of her whatever the defendant wanted to say about their ticket. She also has what the agency has said, and she has their driving record that she can review. And then she then has the ability to say, yes, this is going to move forward, or it's not. And based on that, the defendant can pay their fine and it gets closed out. So in all honesty, you can have a ticket resolved in a week or less, where if we schedule a hearing, it would sometimes be 30 days out. Sometimes people didn't pay right away, but the default rate for Matterhorn is less than 1%. So when people engage in the system, we have a great return on that. So we're getting paid a lot faster than we would any other way. And in addition to all of those things, we also have kind of a front end that says if you've had 5 or more tickets in the last 3 years, you're automatically bumped out of the system too. So it would send a message to the defendant that they don't qualify and to contact the court for further information on how to resolve their ticket. So that was kind of a long-winded answer, but kind of took you all the way through our system. But yes, they can log on to the website right as soon as they get the ticket, and that the website will take care of looking for that ticket until it pops into the system.
Other questions? Yes, Phil.
Thank you. Good afternoon. First, I just wanted to say to Professor Prescott, your work with Professor Starr on the 2019 Michigan Law Study for Clean Slate was instrumental in getting Clean Slate passed here in Connecticut, so thank you for that work. I did want to know, on the data side, or if there's been any work done on demonstrating the effectiveness of using ODR prior, versus what had been in place prior to using ODR. Is it, how fast is it moving your cases? Ms. Fusick just suggested that there was a 1% default rate, for an example, when people did engage. But is there any more studies or data analysis that's been done showing the benefits of using it?
I can answer that question. I mean, I have to, you all know that I was involved with the founding of Matterhorn, and so take that with the important grain of salt. But I now I'm not involved with Matterhorn anymore, other than to ask them for data and to ask them to help me conduct research on what they're doing. And I've done a number of empirical projects that have looked at different outcomes, including duration of case, importantly, default rate. I've also looked at some of the potential disparities, racial disparities, age disparities, and how an online proceeding differs from an in-person proceeding. I'm happy to share that with Charlie or Judge Noble, or however I can get that to you. I'd be very happy to share that. One thing I'll emphasize, though, is that in most of my work, I focused on a single court system or a single type of case. And since I think one of the important messages that has come out of this is that most courts, when they move into ODR, regardless of what system they're using, there's a lot of customization that goes on and a lot of individual choices that courts and judges and court administrators make in building the system that they really want to use. And I suspect that matters a lot for how well the system works, how many people access it. But yeah, at this point, I mean, there are not just my work, but there are, Amy Schmitz, who I think was there earlier, and others who tried to, as best they can, look at data to give us some sense of what the effects of ODR are on outcomes.
Well, actually, I have a question that really involves two programs. And again, I see the world the way I am, which is a mediator. And I was struck that two of the programs are using mediators. In Delaware, you're using really essentially like volunteer members of the bar, essentially, I'm assuming pro bono.
Yes.
And in Michigan, you're using your fabulous network of community mediation centers who have trained volunteer mediators. Are they volunteering, or is there a stipend paid to the centers? And actually, I also want to say what I particularly was struck by your model in Michigan is the way that you really have brought together the judicial branch, legal services to provide information, and mediation centers to help resolve disputes in a neutral fashion. So I love that trifecta that you have going in Michigan. But anyway, back to, I want to know whether those community mediators are getting paid or not.
No.
No, okay.
Not in the community dispute resolution program. They're volunteer mediators. I mean, occasionally a staff member may have to jump in if a volunteer was sick or something, but the community dispute resolution program is set up with a network of nonprofit organizations that provide dispute resolution using volunteers.
Sure.
So,
and are those organizations funded by the state, by the court, judicial branch?
So what we have is a civil case filing fund, and a portion of that is dedicated to the community dispute resolution program. So the community dispute resolution program provides grant funding to the 16 programs. The grants run anywhere from maybe 20% of their operating budget up to 60% of their operating budget. It's a calculation that's determined based on the fees that are collected in their communities and also their previous year's performance. And that's how the grant awards are decided.
Sure, no, thank you. That's a great overview, but glad to know that the volunteer spirit of mediators is still at work. So
Thank you.
Other questions? We're nearing the end. I want to.
Maria, did you have something you wanted to say?
I just wanted to add that in Ohio, we do also use mediators in some of the cases, and some of them are paid and some of them are volunteer. While we absolutely love volunteer mediators, we do want to respect the profession of mediation, and when possible, especially people who do it day after day, that they're not always asked to volunteer.
But I'm curious, in Ohio, as in Michigan, are these volunteers, these community mediation programs or community settlement programs funded by the Supreme Court, or they operate, where's the funding come?
They all are funded individually. They are not funded by the Supreme Court. A lot of our mediators are just volunteers.
Right.
Volunteers for a local court. We don't have the organized system they do in Michigan. We have a non-unified court system, so it's a little different.
That's all right. We have no system in Connecticut, so I'm just curious. I think with that, we do have our stick around for the ODR in Connecticut panel. That'll be moderated by the Honorable Cesar Noble. But first, thank you very much, JJ, for your work in this field. I got a shout out from a colleague of mine that, obviously your work extends over various areas of, I couldn't add them all to the introduction, but you are one of those Renaissance guys who has a finger in a lot of pies. And I can't thank, Maria and Alicia and Lisa and Michelle and Stephanie for the work that I have to observe that it's always interesting to me that, the women are doing the work here. So, I don't know where those men are, but I'm glad the women are doing the work. That's all I want to say. So thank you very much.
And I'd like to introduce our panelists. We're going to start off with Alexandra Gillette. Did I pronounce it right? Who is the Deputy Director of Purchasing, but in her former job, she oversaw ODR, civil dispute resolution matters, including housing and foreclosure and small claims. And we have Matt Bardos, who is a regular user of the small claims ODR program. He's with the Stillman Law Firm, and he represents creditors in small claims and contract collection matters. And we have Executive Assistant State's Attorney Brett Salafia.
Yes, sir.
Who is a regular user of the branch's online ticket review program. So let me start off with you, Alex. How did our ODR start?
Sure. Can everyone hear me clearly enough? A little closer to the microphone. How about now?
Maybe the mic's not on.
How about now?
Oh, yeah.
There we go.
More better.
So Connecticut has had a long history, and there are some faces out here in the crowd that I know that has a long history in dispute resolution and mediation specifically. But in terms of online dispute resolution, it really started in 2017, 2018. As you heard from the earlier panels, there was sort of a court-wide interest in dispute resolution in an online setting. And are there more efficient ways to resolve cases? Are there better ways to allow people not to have to come to court? Are there ways that we can increase what we all have talked about as our default rate of people not appearing for their cases? And so the first step was within the civil context, within contract collections. And in Connecticut, contract collections are exactly as they sound, contract-based collections actions. They, generally speaking, tend to be more than $5,000 because small claims is available for $5,000 or less. But we started there because the cases were already available online using our e-filing system. And it became a sort of a small, easy to manage, what we thought of as a single opportunity of someone touching the court system to be able to try online dispute resolution. So our first attempt was to build something from the ground up. We tried to design something with mediation sort of at its core. And so we built sort of an off-ramp program where you could, at the start of the case, decide to participate in online dispute resolution. You then would not go to court in a physical sense. You would participate with a mediator, and if the case was not resolved, to go before a judicial authority on the papers, which is to say not before a judge. And at the time, we thought this is going to be great. It's going to work quite well. People are going to be interested in this. As it turns out, people are not interested in this. We had one case in our first attempt, so we learned a lot from that system. Judge Noble, would you like me to go through some of what we have now?
Yeah.
I just don't want to monopolize too much time. So from there, we really learned from some of the mistakes that we made, and we did a lot of more research in terms of what other states were doing, and that's where we settled on taking a sort of different approach. We went to small claims as our next place because we were working with a smaller dollar amount, a wider range of people, a lot more self-represented parties who did not want to take the time off of work or other commitments to come to court. Small claims cases, at least in Connecticut, and I think probably elsewhere as well, tend to be set in a sort of cattle call docket, if you'll allow me the term, where we schedule a large block of cases, and the cases are heard back to back to back to back, as opposed to scheduled individually. What that means for litigants is that they're spending a lot of time waiting. And so one of the things that we tried to do was to find a better way to do that so that people weren't taking a full day or a half day off of work in order to have their case resolved, simply just waiting for the judge. So small claims ODR as our second option, we made a couple of other changes. We kept it voluntary because we wanted to see whether people wanted to participate in this program, whether it was an effective use of their time. We made it simply email-based, so people who wanted to participate received a notice from the court. They could send an email to our small claims ODR email box. And if we had a match on both sides, volunteer participation from plaintiff and defendant, the case was referred into our ODR program. They worked with a mediator at a time that was mutually convenient for the parties using our Microsoft Teams platform. This was pre-pandemic at this point in time, but very quickly got sort of wrapped into the realities of the pandemic. And so that was where we really started to see the cases grow because, of course, as you all know, the courts being closed, there wasn't an alternative for people. We saw really a large expansion at that point in time, both in participation rates, but also in positive outcomes. It was an opportunity for people to try and resolve their cases in a meaningful way, in addition to being a convenient way.
So the small claims were synchronous?
Small claims in our dispute resolution program is a synchronous communication. So they are set via Microsoft Teams. So the parties simply receive something that looks a lot like this, a Zoom link. They get it in their email address, and the parties set a particular date and time to participate. They work directly with a magistrate who's serving as a mediator in that role and try and work out the resolution between the parties. If the case needs, oh, I'm sorry, go ahead, Judge.
And I was just going to ask you to go to the tickets, and how did that start?
So Connecticut has two different ODR programs. The first being the small claims civil program that I just discussed. The other being our online ticket review program. This is a very different program. It is asynchronous communication, as Judge Noble mentioned. So this is for motor vehicle and criminal motor vehicle infractions, and is specific to those who may choose to plead not guilty or who choose to simply pay the fine. Again, the intent is to avoid having to come to court and take the time to actually have the trial. I'll pass to Attorney Salafi. Do you want to talk a little bit about the program?
Sure. So the program was piloted by the judicial branch pre-pandemic, and they were testing it in several locations as kind of a third option for folks. They could enter voluntarily into the online adjudication. They could come to court where they could resolve in the typical pay-by-mail fashion. When the pandemic hit, one of the things the chief state's attorney and the chief trial court administrator got together and said, we have to keep people out of the buildings for this pandemic, and they set the system up to be fully remote across the boards in all of the geographic area courts that were impacted. So if you got a speeding ticket or an unregistered motor vehicle ticket, your option was to deal with the online resolution. So there's a centralized infractions bureau that judicial branch has, and they collect the tickets that come in from police departments, and they put people into the system so that they can select the remote option. Every week, the chief state's attorney's office gets a work queue of, on average, 1,000 motor vehicle and criminal infractions that have come from all corners of the state. And currently we have two prosecutors that loosely report to me who work through, they review the tickets, they review statements that individuals put in support of their version of the events. They can do email or telephone exchanges with the individuals, but they try to resolve these matters without folks having to actually be present in a courthouse. The resolution rate is well over 60% that cases are getting resolved without individuals going to court. That does leave a 40% where once they reject an offer for disposition through the online system, since the pandemic, these matters are kind of in a limbo or a never land, and there's some high-level talks between my agency and the judicial branch for how we're going to pivot going forward. I think the hope from Judge Carroll, the Chief Trial Court Administrator, is that we aren't going to have hundreds of people in courthouses standing in line to deal with motor vehicle and low-level criminal infractions, and that the branch is working towards a remote hearing process.
And do you find that you're able to communicate effectively with people online?
I think if the individuals want to engage, that we communicate effectively. There is certainly a group of individuals who submit that information they enter their not guilty plea, and that's the last of it. They don't provide any narrative. They don't provide supporting documents to show that their vehicle is now properly registered or insured. They don't respond to emails from the prosecutor. So their cases get transferred into that non-active queue and await disposition in the future. And the individuals that really want to engage in the process, it's a very effective way for them not to have to take time off. So if they work the night shift someplace and they return home at 6 o'clock in the morning, they can put forth all of the information, their supporting documentation, and do it before the prosecutors who are handling those cases are even in their office. So it has worked pretty well for the vast majority. I do think that there is a little bit of an impersonal to doing things either synchronously or asynchronously online that we have to get used to. But in terms of efficiency, I think it exploits a lot of different efficiencies that help court operations generally.
And the information that they give, the documentation that they give you, is that just sent as an attachment?
It can be sent as an attachment, as well as they can put a narrative that I believe it does cap out, but it's thousands and thousands of characters, so it would be several pages worth of their narrative version of the events. You know, the typical speeding ticket situation, it's why the police officer couldn't have been measuring their speed and had to be measuring someone else's, or some variation on that theme.
The portal itself is mobile friendly. It's just an open text box to provide a sort of narrative response to the substance of the ticket, and there is the space to attach whatever documentation, perhaps a proof of registration or something like that.
Sometimes it's photograph, proof of insurance, disposition from the insurance company if it were a minor accident where the civil side of the matter probably resolves it and there isn't a need for prosecution. So the more information that's presented, sometimes the easier it is to make discretionary decisions.
And Mr. Bartos, how has your experience been with respect to the online dispute resolution and small claims matters? Were you able to hear me?
Oh, I think I was on mute. Sorry, I'm just having a little trouble hearing you too. It sounds like a little fishbowl. Ash, could you just repeat that? I'm sorry.
Sure. What's your experience been in the online dispute resolution in small claims matters?
Yeah, so I should just probably explain my whole background briefly. So I have been doing very, very high volume consumer collections for 6.5 years, I'd say. I'm actually a Quinnipiac grad. I was class 2013. And so prior to the pandemic, I was somewhat semi-remote in terms of my homework because I worked for a firm in Rhode Island, and then for the last 5 or so years, I've been working for a firm based in Michigan. But prior to the pandemic, I was physically driving for both small claims and Superior Court to every courthouse in the whole state. So I could theoretically in the same day drive from Stamford to Putnam, and that would take up 2/3 or 3/4 of my actual workday. Then I'd actually have the hearings themselves, which would be a fraction of the workday. And then I'd come home at 5 and I'd still have a mountain of paperwork, but I couldn't do it. And I realized that I never actually thought that this was actually possible. It never dawned on me that this could all be done remotely. And then when COVID occurred, it was like a whole new world. And at first I thought, wow, this is great for plaintiffs. And then I realized it's great, even better for the defendants, because back when I was in person, I would kind of take bets. Sometimes I'd have a docket of 10 cases in one time slot at one particular court. And I would think, I wonder if 50% of the defendants will show. I wonder if 1/3 will show. Because they were intimidated by coming to court. They didn't necessarily understand the procedures. And to be frank, a lot of them couldn't even necessarily afford transportation to get to the court. They couldn't afford to take time off of work. Some of them may have had even, which I want to really touch upon when we get there, is, health issues. Everyone is differently abled. And just getting to the physical courthouse can be difficult for some people. And now that it's been remote, I would say the vast majority of defendants appear. They take time on their lunch break to appear on their phone or what have you. And it has made it so much better for their access to court, and so much better for them because they don't get defaulted for not appearing. They can actually talk to me and work something out. I try to be very nice to everybody, and I'm just doing my job. I never try to give anybody a hard time. I understand everyone's situation is different. And being able to collaborate with the defendant and figure out, okay, what is your situation? What can work for you? Has changed the game for us. And I hope it never goes back, because before that, it was just default judgment. And then they had to deal with whatever the court ordered. And it just wasn't ideal for anybody. Not only that, but when I got to meet them, when I get to more frequently meet them over remote, I can explain to them like, hey, this is how you set up payments, and this is what happens if you don't pay. And none of that was happening. I would get sometimes when I, like I said, when I would have 10 cases down, maybe one person would show up, and then the others would just get default judgments, and it was kind of awful.
How does a case get to you for resolution or for mediation or settlement discussion?
I'm sorry, I'm still having a little trouble hearing you. I think.
How does a case get to you for resolution? So it's not.
How do we get to the resolutions?
Yeah, it's. How does the case get in line for you to discuss settlement?
Judge Noble, I can help you with that. I think he's having some difficulty. So the cases in small claims are set up as sort of a pit stop on the way to trial. They were built that way so that there wasn't any delay in timeline of actually the case proceeding, but it gave people an opportunity to work towards resolution. So it's set up the same day as trial, in a time frame within 2 or 3 hours before the specific trial date and time. It's set up, as I said, in a Microsoft Teams space with a mediator ready to go. So the parties, and Attorney Bardos as an example, would be available in the space to have that discussion in the hours before the trial.
And the audience should be aware that we are now doing and have been doing small claims cases remotely since the pandemic.
Yeah, since before the pandemic.
Yeah, since before the pandemic.
Just before the pandemic, we started doing the online dispute resolution portion remotely, and then brought in the regular small claims trials as part of our return to operations post-pandemic, to the extent that we were ever post-pandemic.
Attorney Bardos, if you can hear me, what's your view as to the success rate of being able to resolve cases?
Would you be able to actually just to type your question into the chat box again? Could you do that? I'd be able to much more. I know you can hear me. I'm just having trouble hearing you. Oh, there we go. Perfect. Sorry about that.
In the interim, in terms of success rates, what we are seeing on behalf of the branch is that about 50% of the cases where the parties actually appear, and there's some. Attorney Bardos spoke a little bit about seeing an increase in participation rates. And I think that some of that is just participation bias a little bit. In order to participate in this, and the panelists earlier spoke about it as well, we need people's email addresses. So individuals still need to take that extra step to email the court in order to get their notification and their link for this particular hearing and for the mediation itself. So once people have taken that extra step, we are seeing that the default rate drops down to nearly zero. However, it hasn't had a huge impact on the default rate overall. So what we're seeing is that people who are not participating, were not participating pre-pandemic in an in-person setting, are still not participating in a remote setting. However, once they are interested in participating in a case, they stay all the way through. They come back for multiple hearings if need be, or for multiple mediations. And the success rate that we're seeing is that we're reducing the trial docket down by over 50%. It's about 52% at this point in time. So we're finding meaningful resolutions for people. Mediators are finding meaningful resolutions for people. In a way that.
And I do have the. I'm sorry, Mr. Gillette.
Go right ahead, Attorney Bardos.
Oh, I was just going to say I do have. I'm getting the questions typed now, so I can read them. Sorry about that. But in case you wanted me to answer, in terms of, I think you already answered about how how the cases are sent to me. But in terms of the success rate, well, because I do consumer collections, there's usually not a lot of dispute as to liability or damages. Sometimes, indeed, there is, but most of the time there's not. And so it's simply a matter of being able to sit down with the person and work something out. So the success rate is 99.9%. Because we literally have thousands of cases, I do have a decent amount of trials, actually, although the small and large claims trials are quite different. Because the small claims trials, hearsay is admissible, I don't need to have witnesses or anything like that. And so if indeed at the settlement conference the case is not settled, we take a separate link and go right over to the trial and resolve it then, which is also great not only for us but for the defendants, because they don't have to come back to court potentially a second time. Which now we're potentially talking 2 missed days of work. It's all done in one session. So it's truly wonderful. In the old days, to discuss settlement, because it would have to be done outside the presence of the judge who's going to be trying the case, and there was only one judge per courtroom, I would have to have a line of these potentially defendants, sometimes there's 5 of them, talk to them one at a time in the hallway to see if we could reach an agreement, then walk back in. And you can imagine the ponderousness of that. Also, face to face, prior to the pandemic when, we weren't thinking about germs and whatever, it was a totally different world. And now, again, this has completely changed the game. And I think it's equally as beneficial for both sides.
Mr. Salafia, do you find that people complain about a lack of access to this program?
I have not seen the complaints, but what does happen, I think, as a practical matter, is that some people misread the document and don't choose the online adjudication. So that's a case that appears in the active queue for a prosecutor to look at, but will only have one side of the facts. So our option to resolve it isn't the same. So those tend to go into that waiting for court queue. There are some limitations to the asynchronous, where, as Attorney Bartos is talking about, being able to interact with someone in a more synchronous, or the way, 20 years ago, 25 years ago when I started as a prosecutor, when you went to do the infractions, there were 100 people in line and you called folks up and you were able to interact and size them up a little bit. In this asynchronous world, you don't always get that same sense of people, their sincerity, what really happened. There are pluses. I think it certainly has helped the judicial branch in terms of the security of the buildings, not having people traipsing in and out at various times of the day and clogging up the metal detectors. But there are some limits. I'm always concerned that people aren't able to properly express their version of the events, but it's uncharted territory, and the branch is very fully engaged, and the Division of Criminal Justice is fully engaged with coming up with the right solution so that we continue to progress in this uncharted territory.
And Mr. Bartos, did you find that people were complaining about the lack of abilities, the lack of email connection, lack of computers? Did you receive any complaints to that effect, or have you heard about complaints to that effect?
Very rarely. There are. So here's the thing. I hope that remote for actually Superior Court 2 stays forever for any cases where, there's not a jury trial or physical evidence or something, because there's always an option for anybody to come down to the courthouse and use the remote room. So the inverse isn't true, right? So if it's only in person, everyone has to come. But if it is remote, there's always the option to come down to the courthouse. I certainly have, some people who just aren't that comfortable with technology, defendants, and then the clerks, they come down to the courthouse, the clerk helps them. More than that, if there is connectivity issues, let's say your internet is out, access to computer Wi-Fi, I see the question, et cetera, you can always call in. And it seems like in terms of defendants, just as many call in as actually put on their webcam and come in that way. I have had, a power outage here and there with a thunderstorm, and then I call in because I still have the link with the number on my phone. So there's so many different ways to access it. It's really wonderful. And the only potential issue that I've ever ran into, which is actually being fixed, I talked to Ms. Gillette earlier, is that we have to request the links for each individual court, for each individual group of hearings each day, which sounds kind of silly because, for example, I'm in court every day, and these clerks obviously have my email. They've had it for the past 2.5 years, and yet each time I have to request the link. And essentially what's being worked upon, is my understanding, is that there's going to be a universal link, either for each courtroom in each courthouse, my guess, or maybe just each courthouse period, probably on the judicial website is my guess. And then the court notice will direct them to click that link. And then that'll even solve the people who, don't have email to have the email sent to them. So there have been issues, but they've been worked out, and I think there's been workarounds.
And I can say that one of the detractions that Microsoft Teams has had in the field of mediation or pre-trials, is the lack of functionality of the program that we had, in which you could not go to a breakout room like you can in Zoom. And I was a guinea pig yesterday for the new app that we have that's going to permit us, in fact, to have the breakout rooms, and the judge or a clerk can very easily just assign somebody a room, and you'll be able to, it's like putting them in a different room, and have the same functionality that Zoom has. Alex, so you had mentioned also you had been, I think I mentioned, had been overseeing mediation in foreclosures. Is there any thought to moving towards online dispute resolution in foreclosures?
Sure. So Connecticut has had a successful foreclosure mediation program for many years, as you know. During the pandemic, as a result of the various moratoria that were in effect, the foreclosures and housing landlord-tenant matters as well took a pause. But upon returning to normal operations, foreclosures, instead of coming back to in-person, took an entirely remote approach. So at this point in time, though we don't call it online dispute resolution, foreclosure mediation is existing entirely in a remote space. So we are participating effectively in online dispute resolution in that space as well. And there we've seen a very high success rate. We've seen more people participate in foreclosure mediation. We've had more convenient and I think, quite honestly, better resolutions because people aren't taking the time to come to court. They have the ability to participate from their phone, from their office, from their home, in a longer process that happens over the span of a couple of months. We're also seeing better outcomes from the perspective of plaintiff's counsel and various other individuals on behalf of the bank actually appearing in the mediation itself, which had been a problem when we were in person. So in that way, it's another space where it really seems to be working quite well.
And I'm going to ask both Mr. Salafia and Matt, Mr. Bardos, do attorneys get involved at all? Start with you.
The attorneys do, and that's another piece that the judicial branch is working on. So there's a time sequence from when a police officer writes a ticket in an infraction matter that someone has to respond, but there's a much narrower window from the time that they've responded to the Centralized Infraction Bureau to the time that matter comes into a queue for a prosecutor to resolve. They are trying to work out a better system for collecting attorney appearances, but when I'm looking at the screen and I click on ticket number 1 for the week, it will show me in the corner if an attorney has filed an appearance. It will typically have their email, so I can shoot them a quick email and say, hey, it looks like this was an accident. Can you get me a letter of coverage saying that the insurance company is aware that the incident took place and they would handle any liability, and if you do that, I would choose to decline to prosecute the case. The other limitation that I see, both for attorneys and for self-represented people with the infractions, is we get the queue on a Tuesday at midnight, Monday into Tuesday, and at 11:59 on the following Monday night, all of those matters disappear so that I can't do anything with them anymore. So it reduces the window of time where in an in-person situation, if someone came to me and said, hey, we're trying to resolve this tax issue that's holding up our registration, I get paid in 2 weeks, I'll be able to pay that off. I might give them a 5-week continuance in an in-person setting. They take care of everything, they bring me the registration, and I decline to prosecute the case. Ultimately, that will be the result. They aren't able to provide that information. They'll have to hold on to it, and when the case gets assigned through one of the geographic area courts for disposition, they would have to present it in that forum. So there are some gaps that our agency and the judicial branch are working on, and we have 2 years' worth of practical experience to build from as we move forward.
And Mr. Bardos, do you find that you're interacting with attorneys as well, or is it primarily pro ses?
So if I understood the previous question, and again, oh yeah, so I am dealing with mostly pro se because they have limited means. However, there are a ton of opposing lawyers that I also deal with, and it is just as good for the defense lawyers as it is for the plaintiffs' lawyers. Many of them are licensed in multiple states, including Connecticut, and they live in different places. So there are national debt consolidation and defense firms that represent all 50 states, and they have local counsel. But that local counsel may be licensed in 5 different jurisdictions. And I'm dealing with one attorney who lives in Alabama right now, another who actually lives in Michigan, although nothing to do with my firm, and they're able to remotely appear here. And they could, I don't know, it would be literally impossible without remote. So it's just as beneficial for them as it is for us. And they have told me, as I've developed this relationship with them, that if there's ever a push to go back in person, that they will sign on to whatever we say, that we want it to stay remote forever, because it'll make it very hard for me to do my job, and it'll make it literally impossible for them to do theirs. Because now that they've gotten involved in this, I mean, they would have to change careers if they were to have to show up in person, because they've left the state or they never lived here to begin with.
And Alex has a final question. What plans do we have for the future?
So as you can sort of see from here, from our discussion, there are really great benefits to using online dispute resolution. There are ways where it really improves access to justice for people, where we can find meaningful resolution in lieu of a traditional court process. The question becomes, where else could we use this and where it's effective and efficient? I don't think that online dispute resolution, the branch certainly doesn't believe that online dispute resolution for the sake of online dispute resolution is the right answer. There are lots of spaces where this doesn't make sense. But there may be others where we can use dispute resolution, whether it be asynchronous communication like the online ticket review program, or a more, if you will, online as a vehicle, but still working within a traditional dispute resolution context, where that could be. Where we take that will be a question of where those needs particularly meet, and so I'd be curious to know sort of where we head in the future. We don't have set plans for a particular location, but there certainly are lots of other areas of the law where this makes sense.
Thanks. Let me turn it over to our audience now. Does anybody have any questions?
Thank you. I had a question for Attorney Slivia. You had talked about the fact that there's online or people online for court hearings, and that is kind of being decided. I just was trying to get a better sense of that.
Yeah, so right now the disposition takes place, I guess my best analogy would be if you leave here and you're going to order something from Amazon, if I have a speeding ticket, I can say, here's the information I'm going to provide you why this speeding ticket was unjust. The prosecutor looking at it's going to say, yeah, you know what, I kind of agree with that. I'm going to reduce the charge. They'll file a substituted information electronically and offer a reduced fine. And then the person will get an email saying, hey, we're going to resolve it for this lower charge and this lower fine. And if you want to do that, you can click yes and submit your payment. If you click no, you'll get further notice of a hearing. Where we have a problem is in that click no scenario, because we have a group of pre-pandemic cases that weren't handled electronically. So there's about 2,300 of those statewide that have sat in limbo and haven't had anything done with them. And in terms of the online rejections, it's about 6,800 statewide. We need to have a mechanism to give folks an actual hearing when they have a dispute. And you know, whether a criminal case is a serious felony case or whether it's a low-level infraction, it's not like a fine wine. It doesn't get better over time. We lose witnesses. We've had a great silver tsunami, so there are state troopers that are probably no longer living in the state. And it will be difficult, if not impossible, for us to prove some of those cases. That creates a problem, and it creates a fairness and equity problem where now folks that have waited a long time end up getting a better result through an attrition process than they would have gotten if everybody had come into the courtroom. So it's a process where we're learning from it, and we're trying to create those abilities for people not to have to take days off from work and to resolve disputes and to be heard, but we need to also have the follow-through steps a little bit better, and it's taken longer than I would have liked it to see.
Thank you. The reason I ask is anecdotally, I have clients that have called me, not that this is my area, who have apparently checked no and then haven't heard anything and then are wondering what happened, but I guess it's just...
It will probably work to their benefit if I'm being completely transparent at some point, but it's frustrating. None of us like to have, you don't want that unresolved issue of any type hanging over you.
You miss something that...
That's right.
And maybe something's getting adjudicated without your knowledge, but that's good to know.
That little piece of information was worth the price of the seminar.
Yep. Thank you very much.
I have no idea if any of you can hear me because I lost my voice this week. But I wanted to ask both Matt and Alex how important you think having the mediator at those negotiation sessions. Because when Matt was first describing it, I wasn't even sure if that was mediation or just an opportunity to negotiate. So who's mediating and how important is the mediator to the resolution? Or do you think a 3-step, just putting the two sides in the room, and then if they can't resolve it, because all of that would be incredibly complicated live and going back and forth. But in a remote, I could really see a triage that might be really efficient, whether it's all on one day or separate days. It's all doable now. So what do each of you think about that? If you can type that, Stacy, so Matt can hear it.
I'll give Stacy an opportunity to type. So the branch at this point in time is using our magistrates that were hearing motor vehicles and also small claims cases live and in person to do the remote mediations as well. In that situation, the use of the mediator is as good as the mediator themselves. Some came and we were able to bring on more magistrates. Some are very good and very clear, care very deeply about mediation. It's very clear, and so you see those outcomes. For those who aren't trained in mediation or who have limited training in mediation, I think that they do a very good job of allowing the parties to have that sort of conversation. The branch considered different options when looking at how to add online dispute resolution into a small claims setting, and the option of really sort of having a multiple leveled approach where you'd first have a negotiation space and then, if needed, escalate to a mediator was an option, but it would have required multiple either times, slots, days, and so it was a question of weighing the availability of the parties to come for multiple different court events, even in a remote space, as opposed to giving them one opportunity to work directly with a court neutral to try and help towards a resolution. Matt, how do you see?
And I would say too that the role of the mediator is actually huge for two really important reasons. Number one, because it's not a quote unquote trial, it's a settlement conference. It really takes down the temperature of the hearing in the room, puts everybody at ease, lets people be a little more open, knowing that this is all inadmissible, what we're going to talk about. And it really calms everybody down. And then I think that helps facilitate the settlement. But more than that, the mediator can advise to some extent, the defendant on the questions of law. They can't give legal advice, but the defendant can say, well, magistrate, isn't this case beyond the statute of limitations? And, before they want to go over to the trial, and they say, well, based on what I see, I can't give you legal advice, but it doesn't look like it. And they say, okay, I understand. I can't give them legal advice either, as I'm, the other person's attorney. And so it helps them explain, this is we actually have debt buyers and original creditors. So some of our cases, they may have a credit card with company X, and then the debt gets sold to company Y, and then the defendant is like, I've never heard of company Y. Why am I being sued? And they don't understand that, they're still responsible for the debt. And all of those questions can be answered in that process. And then it just massively facilitates the settlement after they get all the questions out. So I think that that's huge. I just wanted to mention those three things, which are kind of key. I know there's been some potential suggestions and pushback of going back in person from small and large claims here and there. But there's three things that I just want to make sure that, I never really thought about any of them before, but I've certainly given them thought over the last 2.5 years, and how fundamental they are to, hopefully making sure that we keep it remote. The first one is the Americans with Disabilities Act. I used to practice disability law before I got into collections, and courthouse is an exemplar of a place of public accommodation under the law. It's like City Hall, basically. So it has to be met with the strictest standards of ADA compliance. And and that means it has to use the least restrictive alternative, meaning that if remote is possible, it must, under the law, under federal law, be allowed. And it is possible because we've been doing it for the past 2.5 years. Therefore, it must remain, is my interpretation of the law. And why is that? Well, it's the least restrictive alternative to literally click a button or dial a phone number, as opposed to driving to a courthouse and walking inside. Everyone in this state is differently abled. So that's huge. Also, we have to not forget why we started this, which is public health. Just because COVID is essentially sort of gone, but not really, it doesn't mean that there won't be another COVID. It's funny because I also have a degree in public health. I thought I was going to be a public health attorney for a while. And we are somewhat at the mercy of Mother Nature. And it would be a shame if we spent all this time and effort setting this up and then had to abandon it and then restart it because something else like COVID, God forbid, happened. There's also other communicable things. There's colds and flus. I'm sorry? I thought someone said something. And then the other, just one last quick point I wanted to say was there is here comes my liberal progressivism coming out, but there is a big positive environmental impact on doing it this way. All the gas that is saved, all of the carbon emissions, but the wear and tear on our roads, the oil changes in the cars, all of that is reduced massively by this, and that cannot be discounted. It's a wonderful thing. So there's my soapbox for those 3 points.
Any other questions? Okay, with that, thank you to our panelists.
So certainly, thank you. I'm again, Professor Charlie Pillsbury, co-director of the Center for Dispute Resolution, and one of the co-chairs of the Symposium Planning Committee. And I have a number of, I guess, the best closing remarks are some thank yous, gratitude. And I'd like to begin first with Stacy Mayer and Elena Underwood, who has just done an amazing job. So if you need a raise, just, I'm a good recommendation. I'll talk to Natalie, whatever it takes. But thank you. Without your, collaboration, it's been a great partnership. Secondly, this doesn't happen really without my co-chair, Ernie Titel. So I want to single Ernie out. He stepped up. It was he quickly got the learning curve. He's a quick study, and we had originally thought about having the small committee to kind of figure out what the symposium would be about, and then we'd expand it. We've done that in previous years, but actually, that segues to what a wonderful committee. I mean, Ernie said, "Why expand it? We're the chemistry's great. We're doing a good job. So." I'd like to thank first the planning committee members who are still here. Joette Katz was a planning committee member, Cindy Robinson, and of course the Honorable Cesar Noble. And I also want to give credit to Alex Gillette for working on the ODR subcommittee. The planning committee had subcommittees, but I also want to thank the planning committee members who are no longer with us. Chris Creason, whose excuse was that he's climbing part of Mount Everest today. Mount Everest, it got canceled and rescheduled, so we cut him some slack. I hope he makes it home. But the other two, Neil Feigenson, just what an extraordinary, job he did in the morning with the two academics, and to discover that one of them was one of his mentors. So that was great. And I wish Rob were here because, first of all, one of the challenges historically with these symposiums is that they do cost money. We don't charge admission, and they do cost money. So, I'll just share with you. I don't know whether we can restructure this, but at some point, one of our former deans, negotiated. Originally, the Bar Foundation paid for all of it out of the Speziali Fund. Maybe that, and then at some point, the way the negotiation went was if there's a deficit, Quinnipiac splits it with the Connecticut Bar Foundation, but if there's a surplus, Connecticut Bar Foundation gets all of it. I don't know how our dean negotiated that. Didn't take one of my negotiation courses. Anyway, I've actually talked to him about it. If Rob were here, first of all, one of the unusual things about this symposium is really the first time it's brought together the ADR community and the trial lawyer community. And of course, there's a lot of crossover. I mean, now more and more trials are going to, mediation and arbitration. So it's a great partnership. But frankly, that's also where the money is. These trial firms, charge more than the mediators and arbitrators that I know. Maybe there's some mediators and arbitrators in the stratosphere. But so I want to thank, first of all, Ernie for committing his firm, Silver, Golub, and Titel, and then Rob committing Shook, Hardy, and Bacon. And I'm thinking, God, that's $10,000. We're halfway there. But that didn't stop Rob. In the next 48 hours, he raised another $15,000. So the Bar Foundation is going to get a surplus. I wanted to reopen the negotiations to see if there's, But anyway, so that's a good segue to thanking for all the sponsors. I think earlier there we mentioned the gold sponsors: Dave Pitney, McCarter and English, Riscassi and Davis, Shook, Hardy and Bacon, and Silver, Golub, and Titel. But I want to also recognize the bronze sponsors: Shipman, Robinson, Mahoney, Stockman, O'Connor, and Connors, Callan, which is that's Chris Cresens, and then the enigmatic Friends of the Speziali Symposium. So thank you to those anonymous friends who stepped up. Last, I want to thank, I think they've left by now, but you met our center co-fellows, Christine Taylor and Justin Carter. Oh, are they up there? Well, Justin is. Anyway, thank you guys, first of all, for showing up today and staying all day. Maybe you've banked some CEUs. I don't know whether you can get it before you graduate, get the bar, but it's a good networking opportunity. And thank Christine. So it's been great to have your help, and of course my co-director Carrie Cass has been particularly useful in getting the IT. Actually, one other person who's I should name. Maybe is that again, none of this happens without Nellie Scoble. I don't know if you know who Nellie basically runs the law school. We think the dean runs the law school, but Nellie actually runs the law school. And she certainly organizes these events and works with the IT folks and works with the catering and does everything to make this happen. So I just want to put that in the record. Nellie, thank you very much. So.